Secretary, you ready? July 20th, 2015 meeting of the Anne Arundel County Council is now in session. Please stand for the invocation and remain standing for the Pledge of Allegiance. Mr. Peruka will lead the invocation.
Let's pray. Except the Lord build the house, they labor in vain that build it. And except the Lord keep the city, the watchman stays awake but in vain. Lord, in Psalm 127, you remind us that you are the Lord, and unless our will and our actions are in concert with your word and your will, then our actions are of no account. Indeed, without your blessing, our activities are vain and worthless. So we ask your blessing on our deliberations and our work, acknowledging that it is not you that must conform to our wishes and desires, but that it is we who are duty-bound to conform to your holy will. Lord, in the very same psalm, we read the following: Lo, children are a heritage of the Lord, and the fruit of the womb is his reward. As arrows in the hand of a warrior, so are the children of a man's youth. And happy is the man who has his quiver full of them. And that is why, Lord, we give thanks for the blessing of a son, Kyle Joseph, to our colleague Derek Fink and his wife Kristen. We are grateful to you for this new life, and we thank you for the work and the witness of the Fink family. For all these things, we raise our prayer. Amen.
Amen.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Madam Secretary, please read the ethics statement.
The Ethics Commission has asked that I advise you that under certain circumstances, members of the public may qualify as lobbyists when they testify before the County Council. If so, the law requires that certain information be filed with the Ethics Commission. The Chairman of the Ethics Commission has asked that those present review the Ethics Commission information in the foyer of these chambers. If there are any questions about lobbying requirements, speakers should contact the Ethics Commission in the Heritage Office Complex on Riva Road.
Thank you. The administration has asked that Resolution 3415 be withdrawn, but I'm objecting to that this evening. We will be hearing that resolution. Mr. Smith, you have something for us this evening? Comment? On 7215?
Sorry about that. I've been running around. This is the introduction of the...
You're postponing the public hearing?
Yes, I'm asking to postpone that specific bill because there's, in light of some legal issues that have come up here recently, I want to give that time to sort of work itself out, as well as to meet with the affected individuals before we deliberate on that particular bill.
Thank you.
So, thank you.
Is there anyone in the audience who would like to address the council briefly on any subject not on the printed agenda? We do have one individual signed up in advance. I believe it's Nancy, and I apologize for not being able to pronounce the last name. Is it Moitrier or Moiterer? Oh, Moitrier, I apologize.
Thank you. Good evening. My name is Nancy Mautrier. I am a member of the community of Annapolis Roads. I live at 1001 Old Bay Ridge Road at the corner of Carrollton Road. Bill 1512 was created by the prior council to change open space rules and regulations. The bill was created against the recommendations of every environmental group and community group who testified. Our community is now suffering from these changes in open space regulations. The new bill is inadequate and does not consider capacity requirements of and for access to proposed uses of open spaces. To accommodate their needs, Key School is asking the community of Annapolis Roads to choose between protecting our environment and protecting our safety. To protect our environment and preserve our safety, Key School's engineering firm proposes improving Carrollton Road by increasing the lane width by 1 foot in both directions from Bay Ridge Avenue to the main entrance of Key School Fusco Athletic Park. Key School's engineering firm is also seeking a code modification that would relax county standards for road construction. Relaxing county standards would apparently permit this minimal road expansion to be considered an acceptable solution to the inadequacy of Carrollton Road for the proposed use. Any road widening that will occur along the stretch of Carrollton Road to the entrance of the Fusco Athletic Park requires a detailed design and construction process with drainage and impervious surface solutions respectful of all county codes. Without a code-driven, comprehensive construction plan, the addition of 1 foot of paving along either side of the road will not only be insufficient to provide adequate safety for our residents, but will also be in need of repair in a few short years at the Anne Arundel County taxpayers' expense. Key School apparently jumped too quickly with the purchase of this property. Key School is trying to fit a square peg into a round hole.
Please summarize.
The county permitting office should uphold the code, protect the land, and honor the communities and homeowners they are hired to serve, and not bend to fulfill the needs of private entities.
Thank you, ma'am.
Thank you.
So anyone else? Ms. Johnson, how are you? I should have assumed.
But, Mr. Chairman, you didn't then finish the invitation to all the other people
Well, I was
here.
going to do that as soon as you were done with your 2 minutes.
Oh, all right. Good evening, Mr. Chairman, members of the council. I would just like to echo the comments made by the first witness. It is always so good to have people come and tell you where they stand and what their concerns are. You have heard this over and over again for decades. A developer comes in, purchases property, gets special changes in the statutes, waivers, variances, and other kinds of special considerations. And then once he's gotten that bite at the apple, well, since that's not enough, he's entitled to another couple of bites and another couple of bites, all at the, to the harm and the injury of the people who live there. So, again, I thank people for coming and reminding you of issues, concerns, and problems. And since you wouldn't want me to miss out on my opportunity to remind you of my concerns and problems, I sent all of you an email because I figure you really don't want any more pieces of paper, especially since you've had most of these and it's a small stack. You know that I own the road. You know that my neighbors park on the road. You know they have been found guilty of trespass in a case filed in 1999. They were found guilty of trespass again in 2005. They went through assorted appeals. They're still guilty of trespass when they park on my land. And it would be so nice, since Judge Malari lifted the unlawful, the injunction that he issued that prohibited the police department from taking any action, which of course was, no judge can do that, No judge can say to the police department, you can't perform your statutory duties that are required under the law. And of course, he has no right to deprive a property owner of protection. But at any rate, eventually he lifted that in September of 2005. So I'd really appreciate your referring these documents to the Office of Law and the police department, and maybe we can even issue a few tickets, maybe charge them with trespass,
Thank you, Ms. Johnson.
harassment, stalking, and other adventures.
Thank you.
Have a good vacation.
Thank you. Is there anyone else wishing to speak at this time? Seeing no movement in the audience. Madam Secretary, please read the titles of the bills to be introduced this evening.
Bill 8015, an ordinance concerning the issuance, sale, and delivery of Anne Arundel County, Maryland general obligation bonds and bond anticipation notes. Bill 8115, an ordinance concerning personnel, positions in the classified service, Office of Information Technology, Enterprise Application Manager. Bill 8215, an ordinance concerning personnel, position in the classified service, Chief, Telecommunication Services. Bill 8315, an ordinance concerning erosion and sediment control, plans and permits. Bill 8415, an ordinance concerning licenses, secondhand dealer licenses. Bill 8515, an ordinance concerning real property taxes deferral for elderly or disabled homeowners. Bill 8615, an ordinance concerning purchasing, procurement methods, related entities. Bill 8715, an ordinance concerning the creation of a tax increment development district to be designated as Maryland Live Conference Center Development District located within Anne Arundel County, Maryland.
Thank you. Madam Secretary, please read the titles of the resolutions to be introduced this evening.
Resolution 3515, resolution approving a project of the Chesapeake Arts Center, Inc. to offer a program related to STEM skills and activities. Resolution 3615, resolution approving a renovation project of the Providence Center. Resolution 3715, resolution to ratify a mutual aid agreement for police protection between Howard County, Maryland and Anne Arundel County, Maryland. Resolution 3815, resolution recognizing the Community Health and Wellness Center at Reese Road Citizen Working Group, its efforts in actively pursuing and investigating options and resources for the development of the center, and acknowledging Anne Arundel County government's commitment to support their work. Resolution 3915, resolution approving waiver of statutory repayment obligation and release of lien on property in Linthicum, Maryland, owned by Hospice of the Chesapeake and known as Tate Hospice House.
Thank you. May I have a motion to suspend the rules to hear and/or vote on resolutions numbers 2515, 2715, and 3315 through 3915, and bill numbers 5615, 5815, 5915, 6115, 6315, and 6515 through 7115 out of order?
So moved. Second.
Madam Secretary, please call the roll.
Mr. Grasso?
Aye.
Mr. Fink?
Aye.
Mr. Pruski?
Aye.
Mr. Perutka? Mr. Trumbauer?
Aye.
Mr. Smith?
Aye.
Mr. Walker?
Aye.
7 in the affirmative, none in the negative. Motion to suspend the rules to hear and/or vote on resolutions 25, 27, 33 through 39, and bill numbers 56, 58, 59, 61, 63, and 65 through 71 out of order is passed.
Thank you. Madam Secretary, please read the title of Resolution 2515.
Resolution relating to condemnation proceedings to acquire certain interest in real property.
Mr. Marzick, when you're ready.
Mr. Chairman, members of the council, Bernie Marzick from the County Executive's Office. Resolution 2515 allows the county to obtain both temporary easements for construction and a permanent easement for storm drain access across the green property located in Arnold. The easements are necessary to address significant erosion of a stream channel bisecting the green property and an outfall from a public stormwater pond at Baronsdale Drive. We have provided pictures to the council to illustrate the problems that we're looking to address through this acquisition or for this combination. Without these easements, the county will not be able to stabilize the stream channel and outfall, which will continue to erode. The outfall will be reconstructed as a step pool conveyance and will stabilize the stream channel and protect against further erosion. The owners of this property are deceased, and the ownership of the property is not clear, but Public Works has been coordinating with the known heirs living in adjacent property. These relatives have verbally told Public Works they will not challenge such an action, and in fact, it will help them clarify the ownership for their own uses. This action is considered a friendly condemnation, and if the council approves the resolution, the county will file for a condemnation in circuit court. If there are no disputes about the facts, the case may be resolved through a hearing on a motion for summary judgment without the need for a full trial. All the known heirs will be compensated for their rights based on the appraised value of the land once the courts have heard the county's request. Here to answer any questions the council may have, Christine Romans from Public Works, and Eric Michelson from Public Works, as well as Meddy Smith from the Office of Law.
Thank you. Mr. Perutka?
Thank you, Mr. Chairman. Mr. Chairman, this is in my district, and I, along with Mr. Phipps, did visit this property and also talked to the one of the heirs that lives in the adjacent property, and I'm convinced that if there ever was such a thing as a friendly condemnation, this is it. It would not be the condemning property would not be something I'd normally be in favor of, but I think in this case it's appropriate and called for.
Thank you. Any additional questions from the council? Seeing none, thank you all very much. At this time, we'll open the public hearing on Resolution 2515. Is there anyone wishing to speak on 2515? Seeing no movement in the audience, the public hearing on 2515 is now closed. Madam Secretary, please read the title of Resolution 2515.
Resolution relating to condemnation proceedings to acquire certain interest in real property.
Thank you. Any final discussion? Seeing none, Madam Secretary, please call the roll on Resolution 2515.
Mr. Grasso?
Aye.
Mr. Fink?
Aye.
Mr. Pruski?
Aye.
Mr. Perutka?
Aye.
Mr. Trumbauer?
Aye.
Mr. Smith?
Aye.
Mr. Walker?
Aye.
7 in the affirmative, none in the negative. Resolution 2515 is passed.
Thank you. Madam Secretary, please read the title of Resolution 2715.
Resolution approving the application to the United States Department of Justice Office of Justice Programs for a grant.
Thank you. Mr. Marzick?
Mr. Chairman, members of the council, Bernie Marzick from the County Executive's Office. Resolution 2715 approves the application for the Edward Byrne Memorial Justice Assistant Grant Program that provides an award to Anne Arundel County for $170,982. The county's Criminal Justice Coordinating Council is the body that determines the internal allocations for this award. Funding from this grant will support programs within the Circuit Court, Health Department, the County Partnership for Children, Youth, and Families, the State's Attorney's Office, and the Police Department. The funding assists with adult drug court programs, teen court operational costs, restorative justice juvenile diversion program, and provides funding to assist individuals in the criminal justice system with co-occurring disorders related to mental health and substance abuse.
Okay.
Here to answer any questions from the council is Corporal Michelle Tringali from the Police Department, as well as County Attorney Nancy Duden.
Thank you. Any questions from the council? Seeing none, thank you all. This time we'll open the public hearing on Resolution 2715. Anyone wishing to speak on 2715, please come forward at this time. Seeing no movement in the audience, the public hearing on Resolution 2715 is now closed. Madam Secretary, please read the title of Resolution 2715.
Resolution approving the application to the United States Department of Justice Office of Justice Programs for a grant.
Thank you. Any final discussion? Seeing none, Madam Secretary, please call the roll on Resolution 2715.
Mr. Grasso?
I just want to make a quick note here. Listening to one of my colleagues, what he had to say, I'm all about taking grants, but I know one of my problems that I'm starting to realize here is that when we start taking grants from the state or particularly from the federal government, there always seems to be something attached to it. And there's no free lunch in business and anything else. And the more grants that we start taking from the federal government, they start dictating what we start doing. So with that in mind, I'm going to say no.
Mr. Fink?
Aye.
Mr. Pruski?
Aye.
Mr. Perutka?
Nay.
Mr. Trumbauer?
Aye.
Mr. Smith?
Aye.
Mr. Walker?
Aye.
5 in the affirmative, 2 in the negative. Resolution 2715 is passed.
Thank you. Madam Secretary, please read the title of Resolution 3315.
Resolution approving estimates of the annual cost of providing health insurance benefits and the employer's subsidies used to determine the rates for certain participants under the County Employee and Retiree Health Benefits Program.
Thank you. Mr. Marzick, when you're ready.
Mr. Chairman, members of the council, Resolution 3315 provides the estimated annual cost for the county's various health insurance plans and certain subsidies. This annual resolution is required by the personnel article of the county code. The personnel officer has prepared these costs as attachment A in this resolution, and she's also proposed subsidies for non-represented employees as well as those for survivors of retirees and survivors of employees. Here to answer any questions the council may have is Andrea Rhodes from the Office of Personnel, as well as John Peterson and Nancy Duden from the Office of Law.
Thank you. Any questions from the council?
Mr. Chair.
Mr. Trumbauer.
Thank you, Mr. Chair. I note that the auditor has produced a standalone letter on this and also distributed some charts and material. So I wonder if she might take the opportunity to walk us through that a bit.
Thank you, Mr. Trumbauer. So we reviewed the calculations that were prepared by Aon that came through the Office of Personnel, and we agree with the calculation of the annual costs of each plan. I wanted to call to your attention one public policy change that is fairly significant. So in the past, active employees and retirees who were under age 65 were all in the same plans, they had the same choices, and they paid the same rates. In real life, the average age of an employee is less than the average age of a retiree, and older people generally cost more for health care. So by paying the same rate, younger active employees subsidize older active employees and older retirees. So in the past, we've always had a blended rate. Everything was paid out of the health insurance. There was it's called an implicit subsidy, but it wasn't very obvious because everything was paid out of one fund. Now we have separated out the retirees, and we're paying their expenses out of the OPEB fund, and we're going to pay the active employees out of the health insurance fund. So now the implicit subsidy becomes more obvious. So what we're going to put into the OPEB fund from the retirees and from the retirees and from the county isn't going to be sufficient to cover their costs. And we will end up using some of the OPEB fund balance, which I don't have a problem with because that is exactly what the OPEB fund balance is intended for. And some of the OPEB fund balance is created by transferring money that those retirees paid into the health insurance fund when they were employees. So you have active employees who have been paying more than their age-adjusted rate for the terms of their employment, and now when they retire, they don't get the benefit of that, or they're going to get less of the benefit of that. So what the administration is proposing is not to do away with the implicit subsidy altogether, because they think that's, I'm going to say, too bitter of a pill to swallow, that's too much of an adjustment. So they're proposing some subsidy, but not as much as the full subsidy. It's not clear to me what the plan is, whether the plan is to do away with the implicit subsidy altogether, but to phase it out over time, whether it's take it to this level that's in the resolution is proposed and leave it there, why we would charge employees more during their entire active employment and then take the subsidy away when they actually retire. So the long spreadsheets that I just handed out to you show you different scenarios. So the first one that has a number 1 in the top right corner shows the rates on the first page for active employees, assuming the lowest cost plan provision does take effect. And if you look at the far right column, if an employee enrolls in the HMO plan, their rates are going to go up roughly 10.5% to 11%. If they enroll in the national PPO, their rates are actually going to go down around 7%. But if you flip to the second page, for that same enrollment in those same plans, for retirees who are under age 65, if they're in the HMO, they're going to pay 21% more than they pay right now. And if they're in the PPO, they're going to pay 50% more than they pay right now. That's a very significant increase. Most of that increase is driven by the lowest cost plan, but some of that increase is driven by this change in public policy. And so if you go to the one that has a 2 in the upper right corner, if you're an employee and the lowest cost plan is deferred, or the unions are successful in their challenge of the lowest cost plan, then the employees will pay 10% more in the HMO, and they'll pay almost 8% less in the PPO. And if you go to the next page, the pre-65 retirees will pay 21% more, and the national PPO, they'll pay about 1.5% more. So it's really a public policy call for the county council. The personnel officer proposes the rates, but you all approve or don't approve the rates. This is a public policy discussion that hasn't been had. It wasn't had during the task force discussions of what are we going to do about the implicit subsidy, or are we going to do anything. We didn't have it when we set up the OPEB trust of, well, now that this is going to be in the OPEB trust, does it make a difference? So in my blue letter, I point out several public policy considerations for you. One is that the cost for retirees is generally greater than the cost for active employees because the retiree population on whole is older than the employee population. But health care costs are not driven by employment status. A 60-year-old retiree doesn't incur more costs than a 60-year-old active employee. It's driven by age, not by employment status. Is it fair to eliminate the implicit subsidy for retirees when they paid an implicit subsidy during their years of active employment? The OPEB trust fund assets will be used to cover the implicit subsidy that was generated in part from fund balance from the health insurance fund from employees paying that subsidy. What level of subsidy, if any, does the administration think is appropriate, and do they intend to phase out the subsidy altogether, and if so, over what period of time? And would the administration propose this change if all of the costs were accounted for in the health insurance fund and the implicit subsidy was not obvious? The subsidy does not change simply because the transactions will now be accounted for in 2 different funds. So you have 2 issues before you, one of which there's nothing for you to do about, and that's whether the lowest cost plan kicks in or not. The other is, do you want to charge pre-65 retirees more than you charge active employees? And should you not want to do that, we do have a chart that Mr. Peterson provided of what the rates would be if they were blended.
And because we're hearing this this is being introduced tonight and voted on tonight, we have no ability to really get input from current employees, retirees.
Unless they come up and testify tonight, that's accurate, and from my
There's no way for them
conversations
to
with
know.
Mr. Chairman, this incorrect. John Peterson, Assistant Personnel Officer, this was introduced
July 6th.
July 6th. This was not just introduced
Been
tonight.
out there for 2 weeks.
Right. But my understanding from talking to Mr. Peterson is that this was not explicitly discussed with the employee groups or with retirees
Or the council.
or council.
Well, Mr.
Mr.
Thank you, Mr. I mean, I can say from my personal standpoint, I haven't received any contact at all from any of the employee groups, and I wonder, is anyone at the panel prepared to characterize, I mean, has there been a discussion, and have the employee groups weighed in or given any feedback?
Again, John Peterson, the administration has never shared or worked with anyone on the cost, setting the cost of the
Right.
plans.
Okay.
This is not where we seek input from the unions, retiree groups, in determining the actual cost of the plan.
Okay, then, Mr. Chair, if I might, the auditor outlined some public policy questions for us as a legislative body, and I want to give you, the administration, the opportunity to respond to any of those at this time, if you'd like. I'd be interested in hearing that.
So we have been sharing this information for some time, and Mr. Hammond, as budget officer, proposed back in May of 2014 the plan for setting the rates, or the plan for funding the OPEB liability going forward. And as part of that submission to the board, he included information on the hidden subsidy and the idea that we need to address that hidden subsidy. So this is not a new topic. This is something that we've shared in the past. And we've been sharing this information with the auditor, and we appreciate the auditor's team's input and help in determining these rates and getting the costs correct. A lot of this is born out of the fact that we are now going to the OPEB trust fund, and we are recognizing more clearly a separate liability for retiree health. That is a distinct, different population and pool now in our code and now in our funding and in the way we address retiree health. So it is now a complete new pool. There are different costs associated with retirees above and beyond just the premium cost. The administration of the OPEB trust. Would you take that $500,000 that we've allocated in this year's budget for the administration of the OPEB trust and build that into the rates and affect active employees with that? I don't think that would be the intent. That wouldn't be fair to active employees to have that cost borne for them for establishing and setting up and administering the OPEB trust. So we are recognizing that there are two completely different groups now.
Mr. Peterson, if I might, Mr. Chairman, you didn't include the $500,000 in the rate calculations, is that correct?
That is correct.
Okay. And while the active employees perhaps shouldn't bear the cost of that administrative cost, arguably, one, it isn't included in the rates you calculated, and two, they will be retirees someday who will benefit from the administration of the OPEB trust.
They may or may not. They may be an active employee for a couple
But are
of
you
years.
not accumulating assets in the OPEB trust now, or when we start funding it fully, on behalf of active employees?
On behalf of active employees,
Yes.
the administration has started to put money aside in the OPEB trust for future retiree liability.
Okay, so why
has
wouldn't it
just
be
started.
appropriate for the active employees to pay a portion of that administrative cost if the assets you're accumulating in that trust are in part for their future benefit?
Because it may or may not be for their future benefit. They may not be a retiree. They may not ever enjoy retiree health.
Certainly, some of them are.
There's no question. There are some people who will retire. We hope everyone enjoys the benefits of retiring and having retiree health. But that's not a cost borne by the active employees as part of their future retiree health. I think the other questions were, what is the plan going forward? This is the first step, retiree health, the changes in our health plans, the impact that the lowest cost subsidy may have, the migration between plans. We just don't know what will happen in the next couple of years. This is the first step. We'll take it year by year to identify what the impact is. We want to minimize any, negative impact to the retirees. We want to maintain a strong retiree health plan, so we have that available to our retirees and to our active population.
Mr. Peterson, as I understand it, the options that are available to a retiree who moves out of state, they're restricted to the PPO, is that correct?
That would be correct.
Okay. So if you happen to retire and live here in the state of Maryland, you could opt for the HMO, which would only increase 21 or 22%. But if you happen to retire and move somewhere else, the only option you would have would be an increase of 49 or 50%.
That is correct, and the council was clear on that when they voted for that in part of 8513.
The second page in from the top.
That is not a function of what we're doing with setting the cost here today. That's a function of the lowest cost plan, which was implemented by this council through Bill 8513, and that was a known impact. We didn't. That's not being impacted by whether the rates we're setting here today.
Mr. Chairman.
I'm sorry, Mr. Prisky.
Yeah. Just to clarify, I wasn't on the council, and I opposed that bill. I just want to make that very clear, because certainly the retirees and the council and everyone here have an impact. And I agree, we have to do something about OPEB. The auditor has said that. But, you know, I think the bigger concern that I have here is just reaching out to people. You know, if I get the Capitol tomorrow morning or Baltimore Sun and see that the council approves a 10% increase to retiree health care and nobody knew about it, and you could say, yeah, it was 2 weeks' notice, but, you know, the devil's in the details. I'm just concerned about that, you know, from that perspective. And I don't know what outreach is normal, you know, in terms of reading. I know we just got our, you know, property tax bill in the mail, and people understand that. I know you can't send out a letter about everything, but I'm just really concerned about the way this is coming out. I'm not, you know, you certainly have a right to you know, your opinion and proposal, but in terms of notification, I don't know. And of course, I didn't get the blue letter from Ms. Sutherland to sort through details. I'm not, by no means a healthcare expert, but
right. So last year was the first year that the administration brought the rates down to the council, and the administration approved the rates. Prior to that, the administration determined the cost. We approved the cost. The budget officer signed off on the rates, and those were the rates, and they first became promoted through open enrollment and through our outreach at that time. Starting last year, and again as part of Bill 8513, it became a requirement that the administration propose the rates, that the personnel officer proposed the rates to the council, and then the council approved them. So any rate increase, it's not something that we've, you know, it's not a, I don't want to say it's not a discussion. The rates are the rates. You know, that's a function of trends, increases in trends and increases in utilization. So it's not really something that's, you know, open for public discussion. The only change this year would be the policy change to separate and recognize that implicit subsidy. We did work with the auditor's office early on. We've been reaching out to them since early June to share this, you know, our information with them. So it's, you know, we're not sneaking this up on you at the last minute. We're not just here tonight proposing these rates.
Again, I think when you have a 10 to 21% increase, that's my concern. You know, people know that gas prices go up a few cents here and there, but I'm going to have sticker shock when I get my health care bill from the county. And I got to be honest with you, if I'm a retiree and I put in, you know, good hours, good pay, good and do my job, again, it would just be concerning to me. I just want to make that clear.
And Mr. Prisky, it's not 10 or 20%, it's 50%.
Well, I know, I'm trying to be, give them a little credit.
Well, again, the lowest cost, the 50%, 45 or 50% increase is a matter of the lowest cost subsidy. And that, I can tell you, we've been promoting and putting that information out to public groups about the lowest cost plan and that impact for over 2 years now. So that information...
It's going to go up by 50%?
Yeah.
Mr. Chair, just to clarify the numbers and what is a result of the blended rate and what is a result of the lowest cost plan. If you look at the handout that's number 1 versus the handout that is number 3, so the second page of both is the pre-65 retirees. And in handout number 1, it's going to go up 21% if you're in the HMO and 50% if you're in the PPO. And that is the rates as they've proposed them, where they're narrowing the subsidy and assuming the lowest cost plan. Number 3 is if you do a fully blended rate, do it like we've always done it, but we're still doing lowest cost plan, which is what you passed in Bill 8513. That's an 11 to 12% increase for the HMO and a 45% increase for the PPO. So this blended issue is an additional 5 percentage points. for the PPO. 45% of it's going to happen just by going to the lowest cost plan, and that has been out there since Bill 8513 was there. I think those of you who were on the council then will remember some of the emails you were getting from the unions of, look what's going to happen. Well, that's happening because if you look at chart number 3 and say we don't have any change in public policy on the blended rate, it's just the lowest cost plan, it's because we're trying to get people out of the PPO. And at the time, they had a choice. And so now, if they live out of state, they really don't have a choice. They have no choice but to be in the national PPO. And I think before, John, if they lived out of state, if you correct me if I'm wrong, they did have a choice of the other plans. So I think that is a difference. If we had all of those other plans out there, then we could say, well, you have a choice, you could be someplace else. They no longer have a choice because we're only offering 2 plans, and if you live out of state, you only get 1. So I think that is a significant difference from what was on the table, the emails, the discussions, the comparison of the cost that you got when Bill 8513 was before you for consideration.
Mr. Chairman.
Mr. Fink.
Thank you.
Sorry.
We didn't have a work session on this bill, so I just kind of want to wrap my head around this. A lot of these questions I probably would have asked there and we wouldn't have had to deal with today. But is this the first year, and you might have already said this also, is this the first year that we're starting to split this with the lowest cost plan? Or did we do it last year as well?
The lowest cost plan is legislated to be effective 1/1/16.
Okay.
Currently, we're under an injunction to prevent us from going to the lowest cost plan.
Right. And then, so the lowest cost plan, and I think I understand this, but I just want to talk it out loud. We, the county, are willing to pay, it looks like, an equal share if you go with that lowest cost plan.
Correct.
If you choose to do a better plan, you are responsible for 100% of the difference between the Cadillac plan, if you will, or the better plan versus the lowest cost plan. Is that right?
Correct.
And then if we look at these nice charts, the lowest cost plan, you know, the national PPO, I'm looking at 3, goes up, actually the price of it goes down 5.2%. Is that right? Actually, that's a bad example. Go on 3, pre-65 retirees, number 3. The cost of the plan goes down, the national PPO, the cost of the plan goes down 5.2%. The county share goes down roughly 18%, but yet the employee's cost skyrockets to over 45% increase. So if the cost of the plan is going down, the cost of it's going down, and the employer share is now saying, hey, we're not contributing anything over the lowest cost plan. Is that what we're seeing, that gap there? Mm-hmm. Is that the 18%?
Right. So even though the cost of the overall plan may go down, the actual employer subsidy for that plan is also going down, because we're only subsidizing at the same level that we would subsidize the HMO.
And a lot of this has to do with the federal health care law as well. I mean, wasn't that kind of the whole Obamacare, the lowest cost plan?
No, that was really just I mean, the part of the ACA that is affected here is that we have a guarantee that our lowest cost plan will never go below a certain threshold of the Affordable Care Act plans, except the fact that we will not be subject to the Cadillac tax. So we as a county can design a plan that is cheaper than the 85% threshold if we would otherwise have been subject to the Cadillac tax. So in Bill 8513, there was a guarantee in there that we would maintain a certain level of plan design for our employees and retirees, except with the caveat that if that plan becomes subject to the Cadillac tax, we can change it.
In 8513, which I voted against, but 8513 dictates what we're doing here, correct?
In part, the recognizing the hidden subsidy or moving a part there is not part of 8513. I mean, that is just a conscious decision that...
What is that part? I'm sorry.
Identifying that there's a separate cost between retirees and actives, and that there's an implicit subsidy from the actives to the retirees. Recognizing that as a policy decision is not part of 8513.
Okay. And Madam Auditor, I'm sure you said this, and it's one of the sheets. What would it look like if we did not separate, is that number one, if we did not separate pre-65?
It's number 3.
2 or 3.
Number 3 or 4 is the way that
That is
we...
either number 3 or 4. Number 3 is if you didn't separate it out and you did the lowest cost plan. And number 4 is if you didn't separate it out and you had no lowest cost plan provision. And I think it's really important to note that when 8513 was before you and you enacted the lowest cost plan, it was to entice people to move to the HMO.
This
They
is the
had
way-
a choice.
But this is the way it entices them, right?
Well,
This
it
cost
does and
is-
it doesn't, because now if you don't live here, you have no choice. If you live in Florida, you can't say, okay, the PPO is too expensive for me, I'm not going to do that, I'll choose the HMO.
Sure.
You have no choice anymore.
But we knew that.
No, we didn't.
We did
When
not.
8513 was before you, there were 3 plans that retirees could pick from.
Okay.
But that second HMO plan was a more expensive HMO plan and would have had a severe pricing.
I thought
But
we
there
had a
was an
rebate on
HMO
out of
plan. There was-
County employees.
Wait a minute, there was an
out-of-state
HMO
employees.
plan, Mr. Peterson, that was less expensive, that was significantly less expensive, that the employees at that time, if this were in effect, could have chosen.
It was less expensive than the than the PPO, the national PPO, but it was more expensive than the existing HMO. So given the lowest cost plan subsidy, it would have significantly driven those costs up.
But not 50%, or even 45%.
It probably would have driven the cost up 50%. The dollar amount might not have been, as
The
significant.
employees' share, retirees' share was not going up 50%. It was significant, but it was not 50%. And they had a choice.
I would say just given last year the monthly cost for that other HMO was $108 more than and that all that cost would have been borne then by the employer or the retiree. So the difference between the national PPO and that other HMO was only around $60. The difference between those two HMOs was over $100. So it would have raised that cost 50%. The dollar amount might not have been quite the same, but the percentage increase would have been there, and the overall cost would have been pretty significant.
Mr. Fink still had the mic. I'm sorry.
Thank you, Mr. Chairman. The cost of the plan is what it is, right? I mean, the cost of the plan is what it is. It's there. There's nothing we can do about that. We're certainly not voting on that tonight.
You're
Is that
voting
right?
on the allocation of the costs.
Correct. But that allocation, was that in 8513?
No.
No.
It didn't specify based on the lowest cost plan? Because we had a
It
lot of
did.
debate on that lowest cost
The
plan.
difference is if you look at number 3 and number 1, or you look at number 2 and number 4. So if you look at number 1, which is the lowest cost plan, and the pre-65 retirees paying more than active employees for the same enrollment, you'll see, for example, that in the HMO for a family, it's $17,935, but if you look at the pre-65 retirees, it's $19,728. This resolution is making that choice of how you allocate it. You could go to number 3 and charge $18,154 for everybody. So you are making a choice in the allocation between actives and pre-65 retirees. You're not making a choice on the lowest cost plan, because that happened by virtue of Bill 8513.
So this bill, and again, we normally have a work session, but I'm wondering why we didn't do that. It's probably our fault, I'm guessing, though. Is that right?
We didn't have one.
We didn't have one
a
in
session
July,
this
so
month.
it was our fault. So this resolution is separating retirees. We're classifying retirees for the first time. We're saying there's pre-65 and there's over 65. And that's how we're coming up with these crazier rates. Is that correct? Am I understanding this?
Well, the bigger, I hesitate to know what you're calling crazier rates, the 50% and the 45% increases.
50% increase is crazy.
That's, yeah. Well, that's a function of the lowest cost plan. If the lowest cost plan is implemented, that's just a function of the lowest cost plan.
But
What's
wasn't that part of 8513?
Yes.
So that portion is part of 8513?
Yes. So what's before you today is a resolution on the cost, and the cost is the cost, and the auditor will agree that we came to the cost appropriately. In terms of, looking at utilization and trends and all those things in the cost in the plan. What we've done differently with that cost, we've now recognized that there's a little bit of a difference in the retiree population and the active population, and we're identifying that subsidy and we're separating those costs out a little bit. We're recognizing a little bit of that delta, that difference in the cost between those two groups. We're not putting in the full amount of that difference. We're not putting the full amount. We're just taking a little step to say, we recognize there's a difference in cost between active employees and pre-65 or non-Medicare eligible retirees, and we're going to recognize some of that in this resolution and setting these costs.
Who benefits from that? The employee?
Well, the employees will see a slightly lower rate than they otherwise would because they're not bearing some of that cost of the retirees. And then we're maybe more appropriately recognizing that cost to the retirees for our OPEB liability and addressing that and hopefully addressing those costs in our OPEB trust fund.
So, you probably just explained this, I don't understand it. Who is benefiting from changing the way we've done it? The splitting the retirees. I mean, the employees get the benefit, but the retirees are going to pay a little bit more?
Correct.
The employees, when they retire, then they'll be paying more?
Correct.
Okay.
Yeah.
And it's our decision by this resolution whether we want to split the retirees or we don't want to split the retirees.
Yes.
Thank you.
Before you chime in, go ahead, Mr. Ray.
Just my last question. If we were to hold this bill,
That's what I was going to say.
what would happen? I mean, this is a huge. 8513 took us every bit of every day, and
Okay,
I feel like
so-
this has popped up. We didn't have a work session, which I'm sure is our fault, not the administration's, but there's a lot going on here.
So, yeah, first, so it's a resolution, not a bill, so there's some leeway in that. The issue that we have from the Office of Personnel is administrative in nature. We need to publish our open enrollment books. We need to disseminate the information, and we need to get the rates into the system so we can be ready for open enrollment and moving forward.
And what's your absolute deadline? Because this is a resolution, we could meet
If you are happy to come
August
back,
15th if we wanted to pass it, right?
if you could come back in August, but if you're off in August, we this is it.
If we passed it September 3rd or whatever the first meeting in September is, that's too late?
It's too late.
But August 15th is okay?
No, August 15th would be late. Really, by the first week in August, we need to get our information to the printers to be.
Do you feel that this bill could have came to us any earlier than it did?
Well, I like to say I tried to work with the council staff, and they were very helpful with setting a timetable, and we got it on the agenda for the first meeting in July. We have to wait a certain amount of time to get enough experience to actually know what experience to set the rates, because we have to have, the claims experience. So we waited as long as we could to gather the information. Obviously, you guys were going through budget, and that wasn't the best time to come down with the bill during that time. We tried to work with the county auditor staff as much as possible, but they were obviously tied up with budget as well. So,
I guess
I'd
one
like
more
to think
question.
I came to you as quickly as possible with this information.
Just to be clear, Mr. Fink, it can be any day in August, any time. It doesn't have to be on a legislative day, as Ms. Jones just pointed out. So
Sure.
if that's the inclination of the council, it doesn't have to be on, the first or third Monday. It can be at any time that's convenient for the council.
And then just my last question. If this resolution passed as is, what is the savings to the county? Do we know?
There's not really savings to the county.
It's just balance between employees and...
Right. I mean, really, and I think we tweaked the numbers, it roughly balanced out between the two. There could be savings to the county further down the road when the retirees, the other provision of 8513, it goes into effect, a sliding scale, so then the retirees are paying higher percentages based on years of service, so then they're bearing more of the cost. But right now, it's pretty much a wash.
And then I'm done after this. Just a quick question for Ms. Sutherland. If
Columbo
this is it,
impersonation over there.
Ms. Sutherland, if we kept it the way it is now, then we're looking at pages 4. Is that right? I say pages because there's 2 number 4s.
If you kept it like it is now, you're looking at number 1.
1.
And if you can't deal with the lowest cost plan tonight. That requires legislation. We
No,
don't
yeah,
have
I
the
understand
litigation's
that.
going to come out. So if you take the split, I'm going to call it, between the retirees and the actives as proposed by the administration, it is scenario 1.
No split.
If you do no split,
4.
it is scenario 3.
And then I do have another question. That's why I like work sessions.
Page 2 of number 3.
My
So-
last question, and I will hold everything else.
And Mr. Fink, just so you know, there is an amendment prepared to do that, but that amendment has to be proposed by the administration.
Okay. How is it possible that on page 1, the PPO price goes down, but the HMO price goes up?
So that's a function of utilization. First of all, the people in those claims groups and what what history they've had. So it might be that last year was priced low, and now it's recognizing those costs are higher. Part of it's the migration of people moving from plan to plan, the anticipated migration, people where they're going to be moving. So we believe that there'll be a healthier population moving into that PPO. And that'll help drive that cost down. But those cost drivers are mostly just from utilization, what's been real experience over the last year or so.
So, top of your head, just a quick dollar figure, then I'm done, I promise. What is the difference, under that scenario, just dollars per month, the individual, what would the difference between the HMO and PPO that the individual pays? Just a ballpark. I mean, you got one going down 8%, the other one's going up 10%, 18% delta.
That's the third set of columns there where it says increase. That's the dollar amounts.
But I'm curious what the employee pays.
The employee's going to pay
Employee share?
For example, on page 1, and this
Yep.
is the 4th to the last column on the page,
Yep.
the employee in an HMO individual is going to pay $91 more a year.
Yeah, but I'm curious what the plan costs to them.
That
They're
is
paying-
That is
They're
the
paying-
cost, I'm sorry,
that's
the
the
cost to
increase.
them is $974. It's the third column on the page.
974. Okay, so the PPO is still about double, roughly. All right, thank you. Actually, one more. No, I'm just.
Mr. Trumbauer.
Thank you, Mr. Chair. So to the administration, I mean, this has been a fascinating conversation. I think I understand where you guys are going with this, and so I'm gonna summarize something, and you tell me if I got it right or not. It sounds to me like you're saying before we set up the OPEB trust and did all of this, the retirees, the pre-65 retirees, were getting a pretty significant subsidy, and that was okay because it was all blended. But they didn't have the assurance that the money would be there to pay them because we had no fund, right? So now we set up the fund, we have a more robust way to deliver these benefits to them, but we're now accounting for it more accurately, and that comes at a price because that subsidy is being decreased. Is that what's going on?
And I'd be careful with the term subsidy because the subsidy is not being decreased. The subsidy is mandated in 8513.
The share of the subsidy?
The cost of the plan is being recognized. So what's being recognized in this is the true cost of the plan. The true cost of delivering health care to our retiree, non-Medicare eligible retiree population.
I think it's acknowledging the implicit subsidy between active employees and retirees, not the employer
No, I
subsidy.
understand. You're right, yeah.
So yes, it is.
I understand why that's an important designation. But, I mean, I'm appreciating my colleague from the 3rd District's point that this seems to be a pretty big deal, and we are having to make a public policy decision here very quickly. I mean, either now or hastily schedule an August meeting where, I mean, who knows if we can get 4 or 5 of us together. And honestly, I don't know if I would be any more prepared to make a decision in 2 weeks than I am right now. So if this resolution does not pass tonight, the status quo would continue as far as the rates? No. What happens if we don't pass?
Something has to pass. Either
Something has to
now
pass.
or before the deadline.
Okay,
that
so
they have. Here's what I would suggest. I mean, I don't know where the rest of the council's at. I'm counting votes or anything like that, but I mean, I can speak out loud for myself and say that I'd be much prefer the option number 3 to leave this subsidy in place as it is right now. And I think if there's consensus on the council to do that, I would hope that the administration would be willing to offer the amendment to make that happen so that we can get this passed tonight.
Because, Mr. Chair, the council cannot amend it without the administration
Correct.
bringing
It has to
in
come
the
from the
policy.
administration.
Well, so I guess since I quasi still have the floor, I would be okay with that, with the understanding that I think if we're going to do that for the next year, maybe more attention happens between now and this time next year, where if you guys want to change this policy. I mean, if I support that option that you're saying, that doesn't mean I want that forever. It just means that I'm not convinced what you've brought us today is the right thing to do at this juncture.
Mr. Chairman.
Mr. Fink, only one question?
Only one question. The deadline is October 1st, is that right?
No, they have to print.
You have to
books.
print, but it's not a 6, I can't see it being 6 weeks printing.
Well, there is a lot of...
There's a lot of stuff, but it's 6 weeks to print?
Well, we're not just...
I mean, government takes longer, so we can add an extra couple of weeks on there, I get that. But still, 6 weeks?
Yeah, it's not just it's not just printing the booklets. I mean, we're printing the booklets, we're getting the information into the system, we have to program the rates into the system for the
But can't you have that both done for both scenarios, and then when we say, this is what we're going to do it, you got 4 weeks to get it printed? Are we printing these in-house, or we ship them out?
We have a vendor that prints them for us.
We got to be a pretty big account. I mean, I would think that vendor could say, hey, we'll save press time, we're going to give you 3 weeks press time in August, or in September. It just seems like we're being rushed to print, and I can't imagine any project taking, what are we printing, 8,000 of these things? Same thing over and over and over and over again? And it's going to take 3 weeks for that?
Well,
it just seems like an awful long time, and you guys can have all your paperwork prepared, you can have the document ready to roll, you can have 2 pages where it talks about the benefits, you remove the one based on what we do. Maybe I'm just not understanding it. I don't see what takes 8 weeks.
Well, it's not just, printing the booklets is just one part of it. It's getting it set up, getting it typeset, getting it ready.
But that can be done for both scenarios. That's done in-house, right? I mean, we create the document in-house, so you do it both ways. We're paying everybody anyway. Whether they do it twice, it's right. And we're only talking about, and the whole book wouldn't be different. The only part that would be different would be the actual rate page. So it's 2 or 3 pages.
Well, it's actually
10 pages, whatever.
Okay.
I mean, I think we're giving it a lot of extra time.
Before you make a comment, Sutherland, I'd just like to say that the county executive apparently doesn't mind double printing things, so maybe you'd be okay with printing 2 sets of books.
That'd be a waste of...
Mr. Fink, or I guess this is for Mr. Peterson and the administration. The lowest cost plan right now is subject to litigation. We're being sued over that. So if the council were to adopt, let's just say scenario 1, and then in September or October, you find out that we lost that lawsuit, you're going to have different rates anyway. What are you going to do then?
So I would assume that whoever prevails in the lawsuit, the other side will appeal, and there'll probably be a continuing injunction. If not, by then it's too late probably for us to change the rates. So I'm guessing the administration will probably come down with a solution to the lowest cost plan before the end of the year.
So if that happens, the rates as proposed in this resolution are what's on spreadsheet number 1. If the council didn't make any change for whether the rate is blended or not, and regardless of the outcome of the lawsuit, you think that's going to be appealed, so it's not going to be number 1 anyway. It's either going to be number 2 or number 4. Right? So why is the council considering and passing tonight a resolution that adopts the rates in number 1 when you think number 1 isn't going to happen under any circumstance?
Well, the costs are going to be the costs. I mean, the resolution is...
Oh, right.
The resolution is for the costs. So those
right.
will be...
Okay.
We're
So
not
then,
passing
so
rates,
what
we're
the
passing
council is
costs.
really considering now is the allocation between the pre-65
Correct.
retirees and the active
The
staff.
cost is the cost. We're not setting rates here. We're setting the annual
Right.
cost.
But to Mr. Fink's question of when is the latest date you can go to print, you're going to have to do something different anyway, very likely. On the lowest cost plan, no.
No.
Nothing changes, okay. Okay, thank you.
So, I mean, I'd still, I mean, I sort of put out there, and I don't know where the rest of the council feels, but maybe you can just weigh in real quickly with your thoughts, because where I'm at, and I think if there's 4 of us that say that number 3 is the way to go, then Mr. Marzick, is the administration willing to make that adjustment in the form of an amendment introduced? Or you just rather us vote it down?
I think I'd rather have a discussion of if we can get 4 members to support the resolution as is first, rather than deal with
Okay, well,
hypothetical.
let's just take a quick poll coming down the dais. I don't not vote, but just, I mean, what? Well, I understand that, but I mean,
You can vote and reconsider your vote.
is there 4 of, let's put it this way, is there 4 of us that want to stick with the subsidy as the way it is and leave it number 3?
I'd like to make a motion to adjourn. I mean, yeah, to adjourn. There's a motion on the table, Mr. Chairman.
May I second that, or?
I'd like to make a motion to hold and not be held to these artificial deadlines when the time comes.
But if it's held, you're still going to have to make a decision as to which the rates are going to be.
I would think the administration probably doesn't want to vote right now. It doesn't look like it's going to go your way, so a hold would be as good as it gets.
Right. I believe you could reconsider the vote, can't you?
So vote it down now and reconsider it in September?
And then you've already started your work that you say is going to take them many
Yeah, no,
months.
I can't wait till September to have.
And then change it.
Mr. Chairman,
That's what I'm saying. It doesn't look like it's going that way. That's
May
why
I
I was
just
suggesting, let's go ahead and amend it, and
I want to clarify again that we're not setting rates here.
We
We're
understand that.
only
It's a
setting the
subsidy.
annual cost.
it's the subsidy that we're addressing, though. That's
We're
what we're
not
concerned
even-
about.
Yeah, we're not addressing the subsidy. It's the separation of the cost between retirees and actives. So it's either
We
the
understand.
same cost.
I think we understand that. Yeah, I can't speak for everybody. Mr. Grasso?
Okay, just so I can get my input. And then Mr. Fink said enough for me and probably everybody else. If we support this resolution, we're saying that you're going to ask the retirees for more money than you're asked for the active employees. Is that what you're basically saying with this resolution?
Yes.
We're saying the cost for retiree health is more than it is for active health.
Okay. I don't think that's too fair, because I think that once you're retired, it's a lot harder to produce extra income than someone who's actually active and working, you know what I mean? I don't think that's a good move. I'd rather, in my personal belief, I'd rather stay where the active employees may have to burden more of them, but they have a better chance of being able to make extra money than someone, and I think that's retired. Probably their health is not that great, you know, and then you got to kind of think about it and say, well, a younger person's going to have to kick out more money. They got a family, you know, they got expenses too, but, you know, they have, I think, a little bit better chance of picking up extra cost than someone who's retired, who's probably really doesn't have the physical capabilities to pick up that extra money. That's my take. Because I know I'm getting there. I'm 54, and I tell you what, I don't want somebody coming to me, not that I get anything from Anne Arundel County, but I wouldn't want anybody to come to me and say, you're going to work a little bit harder now when I can barely move because my back's killing me like it is now. So that's just my take. That's what I feel.
Mr. Smith, do you care to give any indication as to where you're at? I think I know where Mr. Grasso is.
I mean, I do not vote when I do not support an effort if I don't clearly understand all the implications, as well as, I mean, I don't feel like I've been prepared enough on the data piece of this to make a yes vote. So in absence of being educated on this thoroughly, for me, I'm not going to support it for that simple fact, whether or not, and that's where I'm at. So.
Mr. Peruka, any thoughts? Okay. You can't vote for it like it is? Mr. Trumbauer?
Well, Mr. Chair, just
I think that's 4 or 5 at least of us.
Yeah,
Mr.
I'm not speaking on my position. I've already, I think, articulated that. But I'm just wondering procedurally what happens next. If the admin isn't going to do an amendment, then we need to figure out a way to move forward one way or another. So.
I think we are prepared to
get the sense that there is need for an amendment if you're saying that it has to pass tonight. Yeah.
So then
are you willing to?
We would offer an amendment to the chart, the Exhibit A. Yeah, the Exhibit A on page, well, it's listed as page 1, but it's actually page 2. So just substituting a new chart in.
Okay, do it, Madam Auditor?
Do it.
Yes,
You got a mic up.
Yes, Mr. Peterson sent me those rates that are fully blended with the subsidy, implicit subsidy, as we've always done it. We agree with those rates, or with that calculation. And I just want to clarify, John, I understand that this resolution is only approving the annual costs of the plans, but if you go to print with the split as you've proposed it, or even if you do the blended rates and the lowest cost plan doesn't get implemented, you do have to reprint. You're printing employer, employee, retiree shares in that book. And if the lowest cost plan doesn't happen, you do have to reprint.
Correct.
Okay. I just want to make sure that was clear.
Yeah.
It
And
was
I think
spinning in my mind.
I thought I stated that the administration will most likely present something to address that.
Okay. But yes, Mr. Chair, there is a chart prepared to do a revised Exhibit A that came from the administration, and we do agree with that calculation.
So, Mr. Chair, again, should we close this and move to another bill and give them time to print this thing all up, or should we hang out and wait for them to print it up now?
Let's just hold.
It's ready to go.
Okay.
We can go ahead and have the public hearing.
Yeah, let's do that.
Okay, since they're working on that, we'll go ahead and thank you all for your testimony, questions, counsel. This time we'll open the public hearing on Resolution 3315. Is there anyone wishing to speak on 3315? You'll have more than 2 minutes now.
I do?
I'm teasing.
Oh.
I think you're the only one coming now to speak, so we need some time to have them allow.
Oh, we'll do some song and dance and stuff?
I'm
No.
teasing. I'm going to hold you to 2 minutes. Thank you, Ms. Johnson.
Okay, I can't see the clock from here. Julie Johnson, P.O. Box 6634, Annapolis, Maryland. This is murky. I don't have the spreadsheets. I only have the sense that the people who have retired under the age of 65 are going to be getting hit pretty hard. And that historically there's been what works in insurance. The young, healthy folks subsidize the older folks. But I have concerns because I talk to so many people who are so angry about government. They're angry at the Republicans, they're angry at the Democrats, they're angry just about so many things. When President Obama was running, we were going to get health care. And everybody said, gee, I really want people who don't have health care to get health care. That's important. Well, it turns out, no, we don't get health care. They get insurance, and they get to pay for the insurance, except that for the fact that the people who can't pay, it turns out that when we get around to going to the Supreme Court, and Chief Justice John Roberts says, well, this bill really is a tax program. It really is a tax program, at least among some people. And I have heard people say they're making out all right, but I've also heard other people complain that their premiums are going up, but not as much maybe as before, but their deductibles are huge. And so they have a lot of concern about the deductible. So the net is they don't have the coverage that they had before. We need to, as a public policy question, I would urge you to think about how do we increase the number of providers locally. Because you can drive down the costs by
Thank you, Ms. Johnson.
flood the market with healthcare workers, drive down the wages and the other costs.
Thank you.
And drive out the private profit-making companies
Thank
that are
you.
in healthcare.
Thank you. You talked us right through the time to make the copies for the amendment, so appreciate
Just
that.
here for,
Is there anyone else wishing to
entertainment and
speak on
comedy.
Resolution 3315? Seeing no movement in the audience, the public hearing on Resolution 3315 is now closed. Madam Secretary, please read the title of Resolution 3315.
Resolution approving the estimates of the annual cost of providing health insurance benefits and the employer's subsidies used to determine the rate.
Thank you. We have an amendment. Please read the title of Amendment Number 1.
This amendment revises the estimate of the annual cost, employer subsidy, and rates and monetary credits for calendar year 2016.
Thank you. To have a motion to adopt?
So move.
Thank you. Second? Thank you. Any discussion further?
Oh, Mr.
Mr.
Chairman.
Fink, I figured you might have a question.
Just quick, I just want to clarify. This is bringing it back to the way that we currently blend the rates?
Correct.
So it's status quo?
Correct.
There we go. That seems simple.
It's status quo on the blending. It's not status quo on the cost of
These
the
are the
blend.
new
Yeah, but the cost, as we said, the cost is the cost.
It is
We're
what it
not
is.
debating the cost.
That's correct.
I like that.
Fair enough. Any additional questions or comments? Seeing none, Madam Secretary, please call the roll on amendment number 1.
Mr. Grasso.
Aye.
Mr. Fink.
Aye.
Mr. Pruski.
Aye.
Mr. Perutka. Mr. Trumbauer.
Aye.
Mr. Smith.
Aye.
Mr. Walker.
Aye.
7 in the affirmative, none in the negative. Amendment number 1 is passed.
Thank you. Because this is a resolution, we can amend it and vote tonight. Is there any final discussion? Seeing none, Madam Secretary, please read the title of, call the roll on Resolution 3315.
Mr. Grasso.
Aye.
Mr. Fink. Mr. Pruski.
Aye.
Mr. Perutka. Mr. Trumbauer. Mr. Smith.
Aye.
Mr. Walker.
Aye.
7 in the affirmative, none in the negative. Resolution 3315 as amended is passed.
Thank you. Madam Secretary, please read the title of Resolution 3415.
Resolution adopting the revised debt management policy for Anne Arundel County, Maryland.
Thank you. Mr. Marzik's not down here yet, but Ms. Sutherland, I was hoping that you had a couple comments for us on the proposed debt policy change that's in front of us.
I thought this was withdrawn.
It is, but I objected.
So is it still proposed?
Would you care to make comments, Ms. Sutherland?
Yes, so just to point out what this resolution does and the affordability guidelines that are in it, there are some, the new policy expands the county's debt capacity and allows the county to repay the general improvement bonds over a longer term. So during the budget, you were presented with debt affordability guidelines that were 10% debt service as a percentage of current revenue, 3% debt as a percent of personal income, 1.5% debt as a percent of full value, and debt per capita of $3,000. And the only change from prior years to this year was the debt per capita. This resolution increases those affordability guidelines. So instead of having debt service as a percentage of current revenue at 10%, it's at 11.5%. Debt as a percent of personal income is increased from 3 to 4%. Debt as a percent of full value is increased from 1.5 to 2%. Debt per capita goes from $2,000 to $3,000. The maximum term of the bonds goes to 30 years from 20 years. It allows for a straight line amortization instead of the accelerated repayment schedule. And it states that individual capital projects are matched to the bond maturity schedule to ensure that the projects are financed over a period of time no longer than their useful life. So these proposed debt affordability guidelines are consistent with those that the county executive presented to the bond rating agencies in March, which is attachment 1 to that blue letter. So you can see the increased ratios, and under those ratios, you would have new authority of $205 million a year. So that's $60 million more than what was presented to you in budget, and these guidelines were never presented to you in budget. So all the discussions you had about the term of the bonds, the interest rate on the bonds, whether we should do 20-year bonds or 30-year bonds, and what was affordable, and all of the debt affordability scenarios that we ran were based on 10% of general fund revenues, 3% personal income, 1.5% full value. These guidelines increase that significantly, so that under these guidelines you could issue $205 million a year. So, as I say in my blue letter, if you increase the ratios to these higher ratios, you don't need to issue 30-year bonds. You can afford to issue 20-year bonds, except you're going to use a lot more of your revenue to pay those bonds. If you stick with 30-year bonds, you have no reason to increase these ratios above what was presented in the budget. And likewise, if you do a combination of 20 and 30-year, with 30-year for Board of Ed projects. So that's what the proposal does compared to what was presented to you during budget.
So last year, we borrowed approximately $125 million during the budget process.
You
And then this
had
year,
new authority of 125 a year.
Right, and then this year, that authority expanded to $145 million. and now he's asking to go to $205 million.
He doesn't actually ask to go to $205
He's
million, but
tweaking all the
under
ratios.
these debt affordability guidelines, it would allow $205 million. If you adopt these guidelines and you say, this is the various ratios of debt that we can afford, it equates to $205 million a year over 30 years, 30-year bonds.
A point of clarification, Mr. Chairman. The county executive is not asking for anything as he withdrew it. You're asking to keep this alive, so I would put it now on you. You're asking for that increase.
Well, he put it forward, I guess.
But he withdrew it before we voted, before we had a public debate, for whatever reason. I mean, I've never seen this in the council in my 5 years, that we refused to withdraw a bill the administration or any member of this council has put forward.
Because
It's never happened.
Because I think having a conversation about increasing our debt from $125 million to
But the
$205
conversation's
excuse me, I was
off the
talking.
table. The
Excuse me, I
conversation
was-
is off the table. And now you're just making a scene out of this.
Because I'm making a point that the county executive is asking us to take on more debt from $125 million to $205 million, which is a substantial increase.
He's not
in the
asking,
debt.
Mr. Chairman. He withdrew
is.
it, and you're keeping it alive for political
He
reasons.
withdrew it because he knew that it was going to fail.
Maybe that's it, but why are we still debating it?
Because I wanted to make a point.
You've never withdrawn. You wanted to make a political point. Thank you. And I just made a
appreciate
point
you
as
sticking
well.
up for your business partner.
Well, I'm happy to do it. No reason to bring politics into this. You've never questioned a county executive, the three
It
county
increases
executives you and
debt
I have served
policy.
under.
It's an
But he
increase in
withdrew
debt
it.
policy. Well, he did. He proposed it. He should have thought about that before he proposed it.
Well, now I would suggest that you're a sponsor for keeping it alive.
I doubt that's the case because I'll be voting against it.
Wasting the time of this council.
Any additional comments? Thank you. This time we'll open the public hearing on Resolution 3415. Is there anyone wishing to speak on 3415?
That's the one you were just talking about? Okay. Julie Johnson, P.O. Box 6634, Annapolis, Maryland. I think the public has made it very clear that they're very strongly opposed to increasing the debt burdens. You look at a 30-year bond, look around at the little kids in kindergarten. They're going to be paying the bills for while we're going to be, we're purchasing now. I don't think that's fair, and I think you've got a lot of people in the county who feel very strongly that way. So I won't take any more of your time except to say that it does not make sense to increase our tax burden when we're already $18 trillion plus and growing. Thank you.
Thank you. Any additional comments on 3415? Seeing none, Madam Secretary, please read the title of Resolution 3415.
Resolution adopting the revised debt management policy for Anne Arundel County, Maryland.
Thank you. Any final discussion?
Mr. Chair,
Mr. Trumbauer?
considering that the administration has indicated they want to withdraw this, and considering, we had the public hearing, so you got it on the record, I mean, would you consider letting them withdraw it at this point, or are we going to have to vote on this?
I just want to clarify something, because the request is made of the administration to withdraw it, but the sponsor of this is technically the chairman.
Understood.
So it's really on the chairman if he wants to withdraw it, just like it would be if any other councilman had a piece of legislation before the body and they asked to have it removed and someone on the council objected.
Certainly, I'm not.
I just want to clarify that.
I'm not questioning any of
Record.
that. I'm questioning on whether we have to vote on this or not. That's what I'm wondering.
And we just concluded the public hearing, and the next step is a
Okay.
vote. So it's up to the chairman at this point.
We can withdraw at that point. This is beneath this council right now. We've been at this for 5 years together, and we have never questioned an administration. And we've served under 3 county executives who want to withdraw a bill. It's going to die, but it's just ridiculous.
Are you going to make a motion to hold it or something?
There's no hold. I don't think Mr. Trumbo is asking for a hold.
No, I'm
okay. Any final discussion?
I mean, if you want me to move to allow the withdrawal of it, I'm happy to do that. But I don't know that the ball is in my court on that. And Ms. Tate is saying it is indeed not in my court. So I stand here as a council member, waiting to do whatever opportunity presents itself.
Perfectly put.
fair enough. Made my point. It's on the record that the county executive wanted to increase that to over $205 million. I'm going to withdraw the bill.
The county executive didn't want to. He
Yes, he
withdrew
did,
the
Mr.
bill.
Frank.
You brought it up. I can't believe you're bringing politics in these chambers. Not even an election here.
It's my resolution, not his. Thank
Oh,
you.
so you introduced it.
I did on his behalf.
I've seen you
And it's
tell
my
county executives
resolution
no
as well.
before and they had to go elsewhere.
Okay, here's another one that ought to get everybody cooking in the seats. Madam Secretary, please read the title of Bill 4614.
An ordinance concerning public works landfills.
Okay, this is another John Grasso special. I'm on a roll. Okay, let me give you a flashback on when this 4614 came out of. In my constant monitor of trying to make Anne Arundel County an up-to-date county, I work the recycling facilities at the different locations and try to monitor things that are going on. As some folks know, the county makes money from recycling, and probably in the tune of around, I think, $3 million overall. So going in and out of this recycling facility, I'm always looking to make sure people are doing what they're supposed to do. And was speaking with the workers there, they kept telling me over and over again that I thought it was 5% of the people weren't doing what they were supposed to do, but I soon was brought standing to be corrected that it's 30% of the people aren't doing what they're supposed to do. So you have little Johnny comes walking, driving his truck through the gate, and gate guy says, hey, head up on the hill, and there's all the recycling set up there. And then there's another shack up there. The guy says, hey, please take your recyclable items and put them where you're supposed to put them. And there's generally another person on the wall that's watching this go down the line. So you got little Johnny in the back of the pickup truck with brush, cardboard, metals, whatever the case may be, and I just start heaving this stuff into the dumpster. And soon to find out, one of the people working the county says, hey, please take your recyclable items and put them where they're supposed to be. You know, you would think that's what most people would do. But unfortunately, I'm finding out that people are very much like water. They take the path of least resistance. So it's not bad enough that you get little Johnny coming up there taking the recyclable items and just throwing it in a dumpster because he's too lazy to go at the different stations. I mean, we had stations in school. That's what we did. And all you do is take your vehicle and put them where they're supposed to be, and it does a couple things. One, the last numbers I got, it cost the county $500,000 to prepare 1 acre of a landfill. That was the last number I got. The second thing I got here was that these items that we are allowing to fill this hole with is money that we physically can make in Anne Arundel County to help offset this landfill. And if anybody knows anything about hauling or truck drivers or dump truck people, they'll realize that a truck driver or dump truck guy or woman makes their money from several ways. The first thing they do is they go to Bob's house and they charge Bob to pick up the dirt. Charge him a fee to get rid of it. That same truck will turn around and take it to Joe's house and drop the dirt off and charge Joe for dropping the dirt off. It's all the same dirt. So what I'm saying here is that we've got a method to make money from recyclable items, but because some of our constituents think they're too better than everybody else, think that they can do what they want coming in their government, we just allow them to take physical items that make money and throw them into a dumpster, which is going to go into the landfill that we, the taxpayers, paid for. Now, I mentioned last week that it was businesses, but it is also residents. I can tell you with certainty that there is a host of businesses that come into that Dover Road landfill, and they come in there for a couple reasons. One, because they've got an Anne Arundel County license and registration, and the best part about this, they don't live in Anne Arundel County. They're operating their businesses out of Baltimore City and using the taxpayers to turn a profit for them. How do I know that? Because I know these people. Why do they do this? It's very simple. It's called insurance. And what they do is people live in the city. They get any one of their friends that live in Anne Arundel County and say, hey, listen, do you mind if I use your mailing address for my registration for my vehicle and my driver's license because I get cheaper insurance rates? And if you don't think that that's going on, you're a fool. I see it all on a regular basis, and that this has been going on for the longest time. So we got many of these businesses coming in here, and today I was watching it. They were coming in with trailers, pickup trucks. These are not residents that come in here just doing their daily cleanup. They're making money off the taxpayers of Anne Arundel County. And I also brought up to one of my colleagues over here, is that they're going to the Dover Road, because if they go to the one in Burns Crossing, I don't know if they would be forced to put into the recycle, or they would be charged to go over the scale and go up to the regular landfill. Well, they can just turn around and go to Dover Road and just dump all their stuff. So we, the taxpayers, are paying for it. Second part of this bill is that picture yourself being an employee working for Anne Arundel County. Your bosses tell you that you should encourage recycling. Okay? It is not a mandate. You should encourage people. So I want you to picture yourself working up in one of the recycling facilities, and little Johnny comes up, and you say, hey, how you doing today? Hey, Johnny, please put your recyclable items where they're supposed to go. Hey, you know what, pal? You can go somewhere. Sir, please put it where I said you can go somewhere. Okay? Except they don't use it kindly like I say it. They tell them really where they go in words we don't choose to use on TV. Okay? That's what goes on to the county employees. Now, I think it's pathetic that this council or this administration doesn't support our county employees and puts them into the war without the gun. Okay? It doesn't make sense to me. So now what happens is, because I've told this person off, the next person that comes along, that person that works in the county probably won't say anything. Because, why bother? I know if I just got chewed out by a constituent for doing my job, I'd probably say to heck with it. Nobody else cares. So now we're losing revenue, because that person's not going to say nothing in fear of the person saying something back to them. And all I got to say is, shame on us for not backing those county employees. Shame on us. So anyway, the purpose of this bill was a very set process. Person comes through the gate, goes up to the wall. The worker at the place would say, sir, ma'am, please put your recyclable items where you're supposed to be. No, I'm not going to do it. Then the person would turn around and call the supervisor. So now you got two sets of eyes. Sir, ma'am, it's the law. You're in a recycling facility. Please separate your stuff that you have. We're not asking you to rip the bags open and fumble through your trash bags. Stuff that is readily exposable that you can see should go to where it's supposed to be. Please do that. No, I'm not going to do it. Then the next move is to call the county police and write a civil offense of $50 for the first time offense, $100 for the second, and so on down the line. Now, the only people that don't like this bill are the problems in the world. They're the ones that will go there and spite and will throw that stuff over that type of wall. That's the people that don't like this, because the good people, 70% of them, could care less about this bill. They're already doing it. It's the 30% that's the problem in this world. And I've always said once before that 100% of the work in America is done by 10% of the people. It's the same thing you got right here. Why wouldn't we do the right things? That's my point. So that's where the bill stands at this point. The administration, I'm sure, is going to say a few things, and I'm going to have to say a couple things back that is probably going to accept a few, but at least the people are going to know where we're going with this. You say?
Mr. Chairman, Don Murphy on behalf of the administration. First of all, the administration does support its county employees, contrary to what you've said here tonight. Contrary to what you said last week, 2 weeks ago at the last session, we do believe man landed on the moon. We also believe in voluntary recycling. We don't, and we believe that the huge majority, by our numbers last week, was 95%. It's now down to 70%.
That was my number.
That was your number.
Mistake.
That was your number last week.
I'll take the credit for that. I was brought to current numbers. So that was my mistake, and I will take that.
We believe the vast majority, whatever number it is, and I'm sure folks here at DPW will share some numbers with us, are supporting voluntary recycling, and that we do, the huge majority of recyclables are within the waste stream come out. So we commend them on that. What we don't believe in is mandatory recycling, and we don't believe that the placement of a soda can, a Post-it note, a paper clip in a trash dumpster is a jailable offense. And that's what this bill, as currently written, does. It's a jailable offense. As noted by Kelly Kenny in her note to the council, as is noted by Teresa Sutherland, and I'll read the pertinent statement here. This amended bill requires those disposing of solid waste at the county landfill to separate recycling materials from trash or other waste before disposal. A person who violates this provision of the county code would be guilty of a misdemeanor and subject to a $1,000 fine and up to 6 months in prison upon conviction of the county code.
Now, Mr. Murphy, it's obvious that you aren't aware of, or you chose not to bring up, that there is an amendment that was put in to make this just a civil penalty, because
That amendment is not before us, Mr. Chairman.
Well, it will be tonight.
Well, it will be, but it's
It'll be
not right
tonight,
now.
so-
As it sits right now, it is amended from 2 weeks ago.
Well,
This bill
clarify
provides
this
for a
very closely.
jailable offense.
Let's clarify this real closely. My colleagues, okay, are the ones that turned around and took away the fine mistake. And yes, I did vote for it also, because I wasn't aware that it was going to go into this criminal thing. So what we've done is introduce an amendment that you're aware of, and that will be introduced tonight to make this into a civil penalty. The second issue we're going to talk about is voluntary, okay? Don't kid yourself, and don't anybody kid themselves, that people don't do too many things voluntary. Let's talk about cigarette smoking.
Let's
okay?
talk about this bill, Mr. Chairman.
How many
Mr. Chairman,
people
under this bill,
voluntarily not smoke in a restaurant? How
those,
many?
those
No,
that
we had to pass
those
a
that
law
don't
for it.
smoke, those that don't smoke.
Yeah, that's it. But here you had probably 80% of the people not smoking in the restaurant, and there was little Johnny puffing his cigar right next to you. 1 out of 80. Now, do you think he cared enough about what the 80 other people thought? We had to pass a law.
I believe
because
you
it
should have
was
left that
voluntary.
to the restaurant owner, but that is a topic for another
But they
day.
all went out of business, though, right? All the bars and restaurants were out of business.
Not to my knowledge.
Yeah, but that's what was going to happen. So my point is, you leave people alone to volunteer. The good people would do what they're supposed to do. But again, 70%, we've got that. My numbers, the correct numbers, 30% aren't.
Mr. Chairman, do you really believe that 30% of the people of Anne Arundel County go to the landfill and hassle the employees of this county?
Well, I would tell you what I would do, and do what I do, is
There
get your-
are 1,000 people that show up at the landfill on any given Saturday. That means 300 people hassle the people who are working there. I don't believe that for a
Well, then
minute.
here, let me ask this question to you, very simple. Let me ask you a question. Have you ever worked the landfill on a Saturday? Just a straight yes or no.
I did campaign at the landfill.
So here what it is. You haven't even been to the landfill other than a tour that our friends from DPW took you, but you've never actually worked the wall or the landfill to make that statement. Yes or no?
That's correct.
All right then. So as far as I'm concerned, I did.
And you tell me that 300 people hassle the
It's
employees?
between 2 landfills that this is going on, and most of the time when this is happening is during the regular Monday through Friday events. It's not as much happening on the Saturdays, okay? I'm telling you what the employees said to me. Now, I'm going to say this again.
Well, last week they said it was 95% were good
I
people.
said that was a bad number on my part. I'm just going by what was brought to me in correct numbers, okay? Here's what I got. When I first introduced the first piece of legislation of the council, citing that people were stealing our recyclable items, the administration and friends, not the Newman administration, but the Leopold administration and friends, were basically telling me I was hallucinating, and that the employees were going out to lunch, and when they were coming back, the stuff wasn't disappearing. And I went in there and I asked the employees, is the stuff being taken or isn't it being taken? They told me the stuff is being taken. And the administration, Mr. Pittman and friends, okay, was here then as they were tonight, feeding me a bunch of BS, okay? And then what winds up happening is this council, through its wisdom, passed it, contrary to what the administration wanted and Mr. Pittman and friends, okay? Soon to find out, several months after that fact, they turned around and they put a metal cage around the batteries, okay? Now remember this. Grasso's hallucinating, the employees are going out to lunch, and they're coming back and things are disappearing, but this is really not happening. So, to the credit of the administration, they put a nice metal cage around the batteries. Soon to find out, constituent comes by, drops the batteries off in front of the cage. One of the workers couldn't get there in time to unlock the cage to get the batteries in there. And guess what happens? Another constituent pulls up with his truck and loads the batteries up. And they got it on video and they got the tags. But I'm making this up, okay? I'm making this up. And so is the employees. So I'm going to take another one. Because while I got Mr. Pittman here, I'm sure he's going to have a lot to say. Then I turn around and I find out about the vinyl siding, okay, that comes off the houses. We had buyers for vinyl siding, all right? But you know what? The administration didn't want to ask the employees to do anything else, and all that involved was putting a dumpster at the landfill with the sign that said vinyl siding, and when the people come through, please put your vinyl siding over there. But you know what got back to me? They didn't want the employees to do anything else. And we had a person willing to buy this vinyl siding. But you know what? They didn't want the employees to do nothing else. So I made a phone call, I want to say Thursday or Friday, and I told them, the administration, that if you don't get that dumpster out there, I'm going public with this. And guess what happened? Wednesday or Thursday, there was dumpsters at both landfills. Now, all I know is all that vinyl siding before was going into the landfill that we paid $500,000 per acre to do. Now what I know is that vinyl siding is going into a can, and we're getting money for it, anywhere from the tune of $1,500 to $2,000 for a tractor trailer load. I don't care if it's $1,000. All I know is they didn't make it in our landfill, and we actually made money off of something we were throwing in our landfill. But the administration knew this, and they didn't want to do nothing about it, okay? It's complacency. And when you get people that have been in the government too long, this is the nonsense that you got going on. And I'm telling you, folks, this garbage that you're going to hear tonight is more of complacency. This is why Anne Arundel County is what it is. You want to fix the government? You get rid of these merit employees and put people in there that do their job and are always constantly striving not to wait for retirement. That's when you want to fix the problems in Anne Arundel County. Now I'm off my pedestal. I said what I had to say, and everybody in Anne Arundel County knows the truth, what's going on at these landfills. You say?
We respectfully requested unfavorable on this bill as written. Thank you.
Fair enough. All right. Let's see, we have the public hearing on 4614. Anybody want to come down and say anything about it? Seeing none.
Mr. Pittman? Chris, you have anything you want to add?
I echo Chris Phipps, Director of Public Works for Anne Arundel County, echoed Mr. Murphy's statement that we are opposed to this particular bill in the way it's formatted. And since you've given me an opportunity to speak, Councilman Ladd, I do take offense to the characterization of DPW employees overall. We have extremely committed employees that do everything in their power to do what's right for the county citizens, the taxpayers, the ratepayers. And with regard to Mr. Pittman, this man has dedicated his entire career to diverting the waste stream, reducing the waste stream. And he's not someone that you can characterize as a merit employee biding out their time. He's a dedicated, recognized leader in this industry. And every year I come down for the budget discussions, and without fault, all I hear are if there's one facility that the county public works gets basic recognition, it's the landfill operation, it's the recycling center operation, it's his entire operation. So I think the county owes Mr. Pittman a debt of gratitude for all the years of service and commitment he's given to this county, and that's all I have to say.
Mr. Phipps, I want to say thank you. That's what a good leader does. Unfortunately, all this happened under Ron Bowman, and the cases I just stated to you are facts, okay? They're undisputable, everything I told you. And I'll also tell you something that happened before your watch, is that this council asked to have a board put together on recyclability for businesses in Anne Arundel County, and a 12-member staff got together. It was also reported to me that DPW Waste Management was heard in conversations that we need to derail this commission because we don't have the manpower to do this, okay? I was also told from that department that there are people sitting in that department that have nothing to do that would love to do a project. I also went to the Chief of Staff, Eric Roby, and asked to find out what everybody is doing on their computers. Then the Leopold thing happened, and all this got shut down. But I was right in the middle of finding out all this stuff. So, yes, there are good employees in DPW. I'm not sure you're characterizing all the good employees or the right ones. Mr. Ladd.
I had the occasion, Jim, to read some of the code where we talked about business recycling, and it said that we were doing we had a program to do attractive pricing for businesses that would segregate their materials, and we could do some recycling of businesses. I'm off of residential, and I'm just wondering, is that program still active where you have a pricing structure to make it attractive to businesses to separate their recyclables and trash?
Yes, James Pittman, Deputy Director of Waste Management Services. We have a small business recycling program, and if a small business that's on an established collection route wants to recycle and looks a lot like our curbside customer,
right,
and is willing to put their recyclables in a cart and bring it down to the curb, there's a fee structure that, based on a council bill that was passed several years ago, they can participate.
So this is, you do not have a program or something out there that deals with this outside of the normal small volume trash pickup, such that, for example, you, the county, might have yellow recyclable dumpsters that if somebody wanted to do it, we would come down and pick up and take that for them and try to reach out and do this on a larger scale, something along the lines of what Mike, what's his name, that guy that's opened up with us. Have you got anything along that, or am I misreading the code?
No. If you remember my testimony with the solid waste management plan several months ago, about 65% of the entire waste stream that's generated in Anne Arundel County is commercial businesses.
Right.
The lion's share of those businesses have dumpsters where you can automatically pick them up and dispose. The fleet of vehicles that we're using for our curbside program is manual throwers.
Right.
So we're not equipped, either contractually or within the county, to service those businesses.
Okay, but on the other hand, I mean, we contract with all the curbside. I'm pushing you to say, why couldn't we have a contractual arrangement for somebody to go for businesses if we had large yellow containers for businesses to sort out and take it away? I mean, that would give us, to John's point, we would have some recyclable sources, and it would perhaps reduce the cost of doing business here.
Well, the residential waste stream, the residential ratepayer pays that. They fully fund that entire operation from soup to nuts. On the commercial side, there's no fees that are being charged to the commercial business. The private sector is completely managing that waste stream for the businesses. So it's not an easy thing. You would have to completely change the financial structure of businesses in this county.
In other words, we would be getting in the business of what business is doing today.
We'd be competing with the private sector for the commercial waste business.
I would note then that the code write-up that you've got on this program is a tad bit misleading, but nonetheless, thank you.
Okay. Mr. Chair, let me make one more question here because we're going to continue with the public. Go ahead, Mr. Mike.
Thank you. I've enjoyed the 20 minutes of editorial on the bill, but I'd like to actually focus on its content, if I may. And the administration is against the bill, and this is for Mr. Pittman. I guess in as much as the administration opposes the bill, you're there every day, and you're charged with running the landfill. And I echo Mr. Phipps' sentiment that for a Red Sox fan, you do a pretty good job of running it. But you're there every day. Do you agree with Mr. Grasso that this notion of sort of scofflaw, interloping in the landfill is a problem? I mean, do people disregard kind of the policy that we have in the landfill? When you drive in there, it's very clear to me, the attendants talk to you all the way through the landfill. Hey, man, if you got metal, you got to put it there. If you got this, you got to put it there. And it's a pretty disciplined, regimented process. But are there people who regularly ignore kind of the unspoken or visible rule of how to?
I think Mr. Grasso's characterization is generally correct. What I don't know if it's 30. I don't know if it's 5. I do know that we have thousands of customers that come to the convenience centers and the landfill. Obviously, those that come over the scales, they're entitled to dump, especially if they pay. And this bill covers that. So if you bring in recyclables and if it's concealed and it's in bags or it's just loose and it's in a truck, you won't know if it's recyclable until it's dumped in the working phase. One of the challenges, if this bill were to pass, is figuring out what you do after if it's dumped. It's not going to be safe to send our employees into that working phase to pull out. It's definitely not safe to send the customer in there to pull it out. So that's a challenge at the landfill. At the drop-off centers, it's not as grave.
So Mr. Grasso's bill, his proposal as it was initially submitted for consideration, characterized this as basically a criminal offense. I guess it was initially. It was a criminal offense, and there's going to be an amendment debated in a little while that would make it a finable. I don't know if that's a word. A civil offense to which violators would be subject to a fine. Will the administration keep opposing the bill if that amendment passes?
Yes.
Okay.
We don't believe the way to increase participation in recycling is through the stick. It's through the carrot.
I understand.
And with all due respect, and I appreciate the sentiment and the passion of the sponsor.
So, Mr. Pittman, let me ask you again. You're, again, as the landfill expert for the county, what is the best way to, in your mind, bearing in mind the administration's against the bill, what's the best way to use to make the best carrot to get people to stop doing the thing that Mr. Grasso is so angry about?
Well, I don't think we have a total solution. Obviously, a mandatory program by itself would work. The problem is all the implementation aspects of doing that. And I could enumerate all those, but it wouldn't be a slam dunk to be able to do that. One of the things that we did at our recycling centers is the individuals that have mixed loads that would typically, if they were non-compliant, if you will, with our desires, that have recyclables, we've identified a separate area where they have to sort through. But Mr. Grasso is correct. There are some people, I don't think it's a large amount, but large is in quotes. There are some people that do not want to do that. They've borrowed somebody's truck. There's all kinds of stories that they have, and they just want to dump and get out.
So
it's voluntary. Our recycling centers, approximately 40% of what everybody's bringing there is recyclable. Now, you have to understand that the same people that have curbside service are the people that are coming to our landfill and our recycling centers. So all the recyclables coming out of the home, the first place of disposition of those is at the curb. The reason why they're coming to the recycling centers or the landfill is for those bulkier items that you just can't physically put out in trash cans, or they're cleaning out their relative's basement, and they only have a certain amount of time to do it, so they want to make these trips to the disposal site. That's why those facilities are there.
Does the staff, the landfill staff, and I'm using this term just to make a point, and it's not literal, but do they interrogate the people who come over the scales the same way they do me when I want to drop off some cardboard? I get asked a lot, and I think it's great. The staff, what do you have? Cardboard and metal. Okay, well, you better take your metal to 6 and I'll be watching. And then your cardboard can go to number 8 or whatever it is. Does that same process take place for the guys who are bringing it in on a 40-foot flatbed?
I think generally speaking, yes. I mean, I think there's different degrees depending on, I don't know if they say, I'm watching you, but But typically...
I get the feeling they're watching me every
Yeah.
time. I mean, that piece of aluminum better go into the metal bin, or I'm
And we
going
don't,
to get
we
thrown
don't
in with
have,
it.
we don't have extensive amount of staff at these facilities. We don't have everybody at each station. If we had a mandatory program, one of the things we would have to do is hire more staff to just do that, because we have safety concerns about operating and traffic flow. So in order to enforce any kind of a mandatory program, we need more staff to do that, aside from the who writes the citations, what kind of lines of evidence do we have, what if the material was already deposited and another customer saw, would that be acceptable for evidence? All those things, if this bill were to pass, we would have to work out with the Office of Law, involve the police department, and create a whole new system that, quite honestly, as Mr. Murphy has indicated, becomes something that we've never done. Not that we're complacent, but it will turn a more friendly, encouraging, maybe easier way to go relationship with our customers that enjoy coming to the facilities to a very confrontational set of circumstances. You would have to be confrontational to effectively run a mandatory program. We can do it. It would just be something very different than what we've experienced over the past 20 years with all of our programs, whether it be in the schools or at homes or events or at our sites.
Is it your opinion, and I'll stop, that the non-confrontational, whatever you want to call that, the cooperative plan, has led to more recycling at the landfill?
Yes.
Conversely, is it your opinion that if we adopted as you termed it, the confrontational model, that it would result in less recycling taking place? Or it would just happen differently?
Mr. Benoit, if I might be heard on that. Nancy Duden, Deputy County
You rescued
Attorney.
Mr. Pittman, who couldn't find an
I'm
answer.
sorry, Mr. Pittman.
Abstain.
One thing I just want to clarify is Mr. Grasso said in his remarks, and I want to make sure there's an understanding on this, and it's a little premature because the amendment hasn't been talked about yet, but if this is changed to a civil offense, in fact, calls to enforce would not be made to the police department. The police department does not write civil citations. It would be incumbent upon DPW to have staff at the landfill that would write those civil citations. But not only would they have to write the civil citations, they would have to gather the evidence, and they would have to appear with Office of Law in court if the citation is not voluntarily paid. So I just want to make that clear. It would become a civil offense, just like a building code offense or a weedy lot offense, where staff is required not only to write that citation, but then to leave the work site at some point and come to district court to defend or prosecute those civil citations. So that's just one thing you should take into consideration.
Thank you,
Mr. Chair.
Thank you, Mr. Chair. I love going to the dump. I find it a model of efficiency. I find your staff to be very friendly and helpful. I don't go that often, but when I do, I'm always impressed. I have a question. If someone was to show up to the dump, say Millersville or Burns Crossing, that's what I'm familiar with, and they got a pickup full of trash bags, and trash bags are clear, staff can see in them, and it's just mixed, right? It's soda cans and dirty diapers. I don't know. What does your staff what is the proper current procedure for a mixed load? Does it go into the general trash dumpster?
Or if it looks like it can't be separated, and it looks like it's mostly trash, it would be handled as trash. I mean, typically what happens at all the recycling centers, at least one station, maybe even two, depending on where we are, is we'll look in the back, or we'll ask the customer, what do you have? And they'll tell us, and we'll direct them to the area.
Right.
And that's typically...
But if it's a mixed load, you would generally direct them to the...
to the disposal area. Now, what I just finished saying a little while ago is that at our northern and our southern recycling centers, we've established areas where people get out of the traffic queue and do separation, because it would just take too long for them.
Sure.
The lines will start to go out onto the main arteries if we don't get people in and out. So those ones that take longer to unload and sort, and we actually reconfigured the dumpsters so that the recycling dumpsters are close to the trash, et cetera. So they don't have to go back and forth along the areas.
Sure.
So we try to accommodate that and get those people out of the ones that are already doing. They already know where to go. They come, several times a week, and they know what to do.
Would a more attractive procedure or policy from the administration standpoint be, instead of to, in your words, mandate recycling at the dump in the convenience centers, would it be to establish a fee for mixed loads or for trash and say, give people in essence a choice? Look, you can separate and you come in here for free, you put everything where it belongs. If you don't want to do that, then it's going to cost you some,
But it already costs. You already pay that in your tax bill, about $298 per year to dispose of.
I
If you did that at the curb, there'd be no...
No, I understand that, Mr. Murphy, but my expectation or my assumption is that at least some, if not a large number, of frequent visitors to the landfill may not have curbside. If you live in a private community with your own private trash cleanup or pickup, maybe you don't have county curbside. If you live in an apartment complex, maybe you don't have access to county refuse service. So there is a universe of county residents that don't pay it in their taxes, or that don't have the recycling service available to them. So I'm taking you at your word that you are more interested in incentivizing than mandating. And I think, to its credit, the panel has exposed some deficiencies in the sponsor's legislation. And he knows I'm 100% for the concept. This might not be the right bill to do that. I'm interested in finding out what is the right bill to do that. And we may not find that out tonight, but I don't think this issue is going to go away, especially in the context of, state policy is working more towards, no trash policies and other things. So I would suggest that if this bill is not destined for success tonight or in the future, it's still in the best interest of this county to figure out new and innovative ways to expand our recycling program.
Councilman, I'll defer to legal, but I believe as written, this bill, even as amended, or as suggested the amendment, your theoretical bag of dirty diapers and beer cans would be a violation of willful if you came up to the front gate and were told metal in one bin, trash in another, and then you willfully threw that bag into the trash dumpster. You'd be in violation of this ordinance as written.
I'm offering you the opportunity to suggest an alternative to that, but that's for a future conversation.
Mr. Chairman.
Mr. Walker.
Mr. Pittman, I did have the opportunity to take the full tour, as you know, and I'm also one of the individuals that frequents Burns Crossing. Just did so with my political signs. Took the extra step of unscrewing each sign from the wood, and through the coroplast into the plastic dumpster, in spite of the fact that actually it was about 5 minutes to 4, and the employee that checked me in said, "Don't worry about it, just throw it all in the trash dumpster." And I said, "Well, right, but I want to recycle it." And he said, "Don't worry about it, there's 5 minutes up, I just want to get home." Just throw it in the trash dumpster. And I said, "Well, sir, I'm not going to do that. I am going to recycle it." And so I proceeded to recycle it. My question for you, and I do, as I said, go down to the wall. I use the wall, and I also have been up on the pile a number of times. And I've never, ever experienced any individual refusing to dump their trash appropriately. And I've been there a number of times over the past couple of years. Tend to go there when you move and you have a lot of junk that you're going to need to get rid of. And but my question, I guess, is that my concern long term with this is because I'm from New York City, and up there it's mandatory not only at the, well, I guess we don't really go to the landfill up there, it's picked up at the curb, but it's mandatory at the curb. And that's my concern, is I think this is a slippery slope toward mandatory recycling at the curb. And I guess my question for you is, what percentage of the volume of trash that we collect at the landfill and recycling facilities, what percentage of the total is that versus the trash that we collect at the curb? I mean, it sounds like my guess would be it's a pretty low number, but do you happen to know what it is off the top of your head as a tonnage number or a percentage of tons?
Yeah, let me answer that. It's going to be complicated. I may have to send you something, send the council something in the morning, but on the curbside program alone, just look at the curbside trash. We've conducted on 3 occasions in the past 10 years waste sorts, where we actually hire a contractor and do a statistical sample. I think I've mentioned this in previous meetings.
Yes.
And we determine what the opportunity rate is. In other words, if everybody recycled at the curb what our program provides for, you can come up with a number. Now, the good news is, because our program has developed, in 2005, that opportunity rate was only 55%. In 2012, it went up to 60%. So there's more opportunity because there's more things that can get recycled. So of that 60% of the entire waste stream generated from the household at the curb, of that, we're recycling 44%. In 2008, that number was 30%. So we're only 16%, we're halfway to at least a 50% goal. And that's been our goal for many, many years. Now, we're not going to stop at 50%. In fact, we're really not going to talk about 50 anymore, because we're so close. We don't want people to get complacent and say, hey, we're almost there, I'm not going to do any more. So that's the answer for the curbside waste. The other waste that's generated that comes to the landfill and the recycling centers, there's not an easy way to compute the opportunity rate for that, because it's all the other larger things that you really can't recycle. But there are some things, when you clear out that basement or when you move, that all of a sudden become recyclable. They're in your storage area, but now they have an opportunity to recycle. And when you look at the percentages at our convenience centers, we're in the low 40s, which I think is pretty good. I think the low 40s at the recycling centers is a better number from a progress standpoint than are at the curb. Because I know there's recyclables in the trash at the curb, but there's not much recyclables opportunities at the recycling centers. I don't know if that answered your question precisely.
I guess my concern is just that this is a start, and the next step is mandatory recycling at the curb, and we're creating additional positions now to issue civil citations. And in New York City, they decided, oh, we need to do the same thing. So now we literally have the sanitation police that can show up at your curb, rip open your trash bag, and if you haven't separated things correctly, you can receive a $500 fine at the curb. So that's my concern, heading forward in the future. So I do appreciate what you've done in the facilities, and I do appreciate the work that our employees do. But I think that, and I don't suspect that the number is 70-30. I don't know what it is, but it's definitely not that. Just from my own personal experience, and I've been there, like I said, numerous times to both the South County landfill and to the Millersville landfill as well. Thank you.
Okay.
I'd like to talk with you for a moment about enforcement. On the presumption that we were to pass this bill, we're talking now about administrative or civil, I'm sorry, in a civil situation, and you mentioned the possibility of having to go to court. Would we have to bring in trash to demonstrate in a lot of court that something was not?
You don't physically have to bring in the trash with you, but a civil citation is written under oath. It's really, you have to think of it like a traffic citation. When you go to court on a traffic citation, the police officer that saw you commit the traffic infraction, that wrote the citation, has to appear in court, or there's no good evidence. So the person who sees you failing to separate your recycles is the person that has to write the citation, and then that same person has to come to court and testify against you. So it can't be one person at the landfill if we're talking about doing this all the time and then coming to court to testify. So no, you don't have to bring this stuff.
So
in
is
with
this a matter, for example, you could do it with a camera or, a cell phone, you can take a picture of something just to document it. I'm wondering about the enforcement of this thing.
You
If-
could take photographs, but honestly, it could just be the testimony of the person who sees you doing it. But
so-
that person has to be the one that writes the citation and comes to court.
Okay, so a lot of times you see, even for traffic enforcement, even signs perish the thought along the roadside. We don't sit there and get every single person. We go in and the word gets out. If you come to the landfill, you may get a dumping ticket or something like that. And doesn't have to be, we watch every single person. There is some judgment in how you would do the enforcement. And
Well, you would have to train the employees how to do the enforcement, but they would, I would assume, be trained to write a ticket to anybody that they saw.
but there's some judgment involved with this, just like the police chief, he says we're going to put 10% of our time during the day or 30 minutes a day doing traffic enforcement,
Well,
and
that
that
would be-
works.
That would be not a legal question, but a policy.
Well,
question.
I understand it.
And then we're back to, Chairman Grasso's point. We're not enforcing what we, in this case, the law.
Well-
And so you can't have it both ways.
No, but
You've
we
got, if
don't
there's going to be a
have-
law, it's got to be enforced, especially when you're in the compound.
Okay.
If you're out on the street doing drive-bys, that's one thing, but if you're in the facility and you see it as the employee, you've got to take action.
So are you saying now that there is if you go into the recycling facility, it's mandatory that you separate?
I'm saying if this
With
bill
this
were the
bill?
bill, yeah.
Yeah, okay, I understand that, okay.
Let me throw something, let's move on here. I'm just going to, because I think everybody's missed the whole purpose of this whole deal. Tell me, madam, what is your definition of willful? What exactly does willful mean?
That you do it knowingly. That you
Okay,
come
hold it
in
right
and-
there. Okay. So if I turned around and took the clear trash bag with baby diapers and I just threw it in, did I willfully do it?
Yes.
Okay. That's not what I see willful. I see that as a mistake. What I see willful is when I turn around and someone says to me, "Sir, please put your recyclable items." No. Supervisor come over, "Sir, please put your recyclable items." No. And I throw it in the can. That's what I call willful. I purposely did it after being told twice. Not once, twice. So now I bring to my next question here. Someone decides that they want to take motor oil and just open it up and dump it in the dumpster. What are you going to do about it? I didn't think so. Okay? What's the difference? It's a recyclable item. Okay? We got a container over here, so someone can just come in there just for spite and take that motor oil and dump it right in the container. Just go everywhere. And we don't have enough guts to say something about it.
How often does that happen?
It doesn't matter how often it happens. The point is, it can happen. Okay? And here's my next point.
Well,
When I told
things
let me
can happen,
finish.
Mr. Chairman.
When I told the administration that they were stealing our stuff, okay? And I said to Molly Cannon, I said, what are you going to do about it when someone steals our stuff? She says, we'll probably call the police, okay? And when the police comes there and the police says, sir, you can't take that stuff. Hey, kiss butt, I'm going to take that stuff. What are you going to do about it? We're going to lock them up? Okay. We're going to lock this person up, and now we're going to be going into some kind of lawsuit because there was no law saying that they couldn't take that item. They couldn't take it. So the council had to pass a law to stop that. I'm not saying that everybody's going to come through here and everybody's going to take a clear trash bag and they're going to put people. That's not the point. The point is I made the terms spelled out very clearly. The person at the gate doesn't say anything. The person at the gate, at least in the Dover Road, says up on the hill. But then you have the guy at the one side right at the little shed, says please put her, and then you have the person on the wall, okay? And they see him taking the stuff out of there, and he got more. Sir, please don't do that. That's not where it goes. Hey, I'm going to do it anyway. Oh, and by the way, I'm going to turn this 5-gallon thing of motor oil into the can. What are you going to do about it? Okay? You're all a bunch of cowards, man. Cowards. You got to stand up for what's right. okay? And that's what can happen right now because you don't have a law in the place. Someone just do anything they want. They can put a nuclear bomb inside there, radiation, and you can't do nothing about it. Better hope the federal government steps in. But that's what you got, okay? You're not taking the other way about it. And I'm telling you, I went there today. And it was just here today, a guy said to me, you just missed somebody. I said, really? He goes, yeah, had a whole load of thing, brush and everything. We said, sir, please separate your recyclable items. Guys just kept, might as well throw the 5-gallon thing of oil in there too. Why not? That's the problem, guys, okay? You don't have anything in the play. It's a discretionary point between two people. It's not the guy over here. It's a supervisor. It's another person that's in there. It's two people that saw them after they were warned not to do it, even into the dumpster. That's what this law is about.
Mr. Chairman?
Mr. Walker.
How is that different, though? I guess my concern, as I expressed earlier, was that at the curb, that's the next step in the process.
That's not...
I mean, I think, well, I understand that, but I'm just saying there's a slippery slope that we're heading down. And so once we decide we're going to start finding somebody at the landfill, what's the difference? I mean, if you're saying that recycling is extremely important and that it's going to put harmful things in our landfills, then why wouldn't the next step, I mean, the logical next step, be to attack actually the larger source of trash, which is trash at the curb?
Would you support it?
No.
Well, then it's not going to happen, is it?
I'm asking you the question, though. I'm asking you the question.
It would be my logical point. It would be.
Correct.
But my point
okay, I just wanted to make sure I got that on the record. So you're supportive of not only finding people at the landfill, but also supporting finding people at the curb as well. That's the next step.
Well, let's put it this way.
That they should recycle. If they should recycle, if you're saying they have to recycle at the landfill, then the next logical step would be to say they have to recycle at the curb.
Well, let me finish.
Is that true?
No.
It's not?
No.
So you don't believe recycling is true all the time?
Let me finish. John turned around, okay, and if you remember in the very beginning of our council session, we had people going around to the neighborhoods and stealing the recyclables in front of people's houses. Remember? And I said, all the property, once it hits to the curb side of the people's houses, belongs to the people of Anne Arundel County, the taxpayers. You were against it. You were against it because you wanted newspaper to light your fireplace. And instead of you just going next door to your neighbor and say, can I have your newspaper to light your fireplace? You said that once that newspaper hits out on the street, in your bill, Grasso, I would be stealing from Anne Arundel County. I said, that's exactly right. So this whole bill is about you.
But you're supporting recycling. You would support finding the person at the curb. If I put metal in my trash can, along with paper and along with food waste, you would support finding them.
No. Remember what I said the words were? According to this, willfully, this is a whole bill.
But if I willfully did
it,
if I said, let's take it to the next step, though. If your
Well, I don't
next
wanna
bill,
take it to the
if
next
your next,
step.
but
I'm
I
talking
do,
about the
because I
landfill.
think this is, well, I understand, but there's a larger volume of trash at the curb, isn't there?
I guess there is, isn't there?
Mr. Chairman.
I would say there probably is.
But when I wanted to do the metal recycling thing, your answer was, well, John, gee, in your bill, if we turn around and had this thieving of people taking recycling, my mom one day went down the street and found a weight set.
She did.
Okay? And I wouldn't have got it. So it's all about Jerry Walker. That's what it's
No,
about.
it's
The
about
heck
the
with Anne
people of Anne
Arundel
Arundel County.
Mr. Chairman,
who are paying the
my-
rates into the system. They're the bosses of the county employees, not the bosses that are down at the Public Works. So that's my take on it.
Mr. Chairman.
Mr. Miller.
For the first time in my 7 years, 9 months serving on the county council, I'm going to utter the words point of order. And
I'd like to move on is what I'd like to do.
ask
But Mr. Walker has to start.
that everybody focus on the bill that's at hand. Thank you, Mr. Chairman.
Okay, I think we pretty much said our piece today, and we'll see where it goes from here. We want to also, anybody on public hearing on 4614 want to come down and say anything? I wouldn't blame you either if you didn't want to come down. Okay, so we're going to close the public hearing on 4614.
Madam Secretary, please read the title of Resolution 3515.
Resolution approving a project of the Chesapeake Arts Center to offer a program related to STEM skills and activities.
Thank you. Have a administration, Mr. Marzick.
Mr. Chairman, members of the council, Bernie Marzick from the County Executive's Office. I would ask Belinda Huseman and Brenda Fraley if they could join me at the table, if they're still present, for Resolution 3515. Resolution 3515 offers the county support for the Chesapeake Arts Center application to community investment tax credits from the Maryland Department of Housing and Urban Development. You'll remember from the July 6th council session that we had several resolutions similar to this. We have 2 before the council tonight. If awarded, these funds will go directly to their new Makerspace program and will support students and adults by funding the creation of a technological community with workshops and classes engaging students who are historically less attracted to these kinds of activities. As I mentioned, Belinda Huseman from Chesapeake Arts Center, as well as Brenda Fraley, Hodgkins, are here to answer any question. Tell a little bit more about the program, if they will.
Well, Chesapeake Arts Center has taken an old wood shop that was in the Brooklyn Park High School and turned it into a makerspace. We're doing this to add on to our program at Chesapeake Arts Center to attract students and programmatically come up with a new after-school program. Part of it is to help with the revitalization of North County and help to get students into our art center that would be less historically attracted to maybe the arts, but would want to come in and do some tinkering and learn electronics or LED lighting. Work with metal. A makerspace, if you don't know, is a combination of a wood shop, metal shop, sewing, 3D. We're going to have 3D printers. And we are hoping to engage students from all the 5 elementary schools as well as the PBA school and to provide activities for them from that 3 to 8 time frame when it's vulnerable for them to maybe get in trouble.
Mr. Chair?
Mr. Trumbauer?
Thank you, Mr. Chair. You mentioned 5 elementary schools. Are those 5 schools that are attached to the STEM program, or are those within the feeder district?
They're within the feeder district.
Okay.
They're within probably 2 miles.
Okay, so this is specific to that feeder district, and any student within that feeder district would be able to avail themselves of
Yes,
the
and
makerspace?
we have the support from Anne Arundel County Public Schools with their letters of support for the bond bill. We do have the $150,000 approved bond bill that $100,000 will be put towards the new equipment, and the $50,000 will be to update the some dust collection stuff in the wood shop and update the electrical. So we're prepared to move forward with the makerspace. We're just, the funding for this that we're actually going to be raising funds will be used operationally to search and hire a specialized education director to formulate an inspirational, productive, and safe makerspace, determining the design based on mission, space, and budget, while planning for open accessibility while maintaining accountability and safety, to establish rules and policies to safely and effectively manage the makerspace, selecting and installing tools and equipment and training staff, and most importantly, to implement an engaging curriculum to include classes and workshops for marketability, sustainability, and viability.
If all you know, do all you know where the Chesapeake Arts Center is? It's right in the heart of Brooklyn Park. And her and I actually graduated there, so the neighborhood is poor, and we want to get these kids off the street, especially the time that the parents are not home, and the kids are going home by themselves. This is a great opportunity then for them to be creative.
Thank you. Any questions from the council? Seeing none, thank you all very much.
Thank you.
Public hearing on Resolution 3515 is now open. Anyone wishing to speak on 3515, please come forward at this time. Seeing no movement in the audience, public hearing on Resolution 3515 is now closed. Madam Secretary, please read the title of Resolution 3515.
Resolution approving a project of the Chesapeake Arts Center to offer a program related to STEM skills and activities.
Thank you. Any final discussion?
Mr. Chairman,
Mr. Smith?
for the record, I'd just like to be added as a co-sponsor of that resolution. Thank you.
Thank you. Madam Secretary, please call the roll on Resolution 3515.
Mr. Grasso?
Aye.
Mr. Fink? Mr. Pruski?
Aye.
Mr. Perutka?
Abstain.
Mr. Trumbauer?
Aye.
Mr. Smith?
Aye.
Mr. Walker?
Aye.
6 in the affirmative, 1 abstention. Resolution 3515 is passed.
Thank you. Madam Secretary, please read the title of Resolution 3615.
Resolution approving a renovation project of the Providence Center.
Mr. Marzick.
Mr. Chairman, members of the council, Bernie Marzick from the County Executive's Office. I believe we have a couple folks from the Providence Center here, Amy Bolin and Tom McQuillan. I appreciate it coming to the table while I'm introducing the resolution. Resolution 3615 offers the county's support for the Providence Center's application for the community investment tax credits from the Maryland Department of Housing and Urban Development. If awarded, these funds will go toward a renovation project at the Millersville facility on Cloverleaf Drive. The renovation will help them better serve the men and women with intellectual and developmental disabilities. They're applying for $50,000 in tax credits so they can install private hygienic changing rooms with showers, expand program rooms, creating a sound barrier wall with an expanded multi-sensory room, and many other small improvements to the project areas of this site. As I mentioned, Amy Bowen and Tom McQuillan are here from the Providence Center.
Thank you. Any questions from the council? Seeing none, thank you all very much. Public hearing on Resolution 3615 is now open. Anyone wishing to speak on 3615, please come forward. Seeing no one in the audience, the public hearing on Resolution 3615 is now closed. Madam Secretary, please read the title of Resolution 3615.
Resolution approving a renovation project of the Providence Center.
Thank you. Any final discussion? Seeing none, Madam Secretary, please call the roll on Resolution 3615.
Mr. Grasso?
Aye.
Mr. Fink?
Aye.
Mr. Pruski?
Aye.
Mr. Perutka?
Abstain.
Mr. Trumbauer?
Aye.
Mr. Smith?
Aye.
Mr. Walker?
Aye.
6 in the affirmative, 1 abstention. Resolution 3615 is passed.
Thank you. Madam Secretary, please read the title of Resolution 3715.
Resolution to ratify a mutual aid agreement for police protection between Howard County, Maryland and Anne Arundel County, Maryland.
Mr. Marzick?
Mr. Chairman, members of the council, Bernie Marzick from the County Executive's Office. The resolution ratifies the agreement between Howard County and Arundel counties to share police forces in portions of the county and in portions of the county where there's a situation in need. Major Cramp from the Police Department is here, and can answer any questions the council may have on this resolution.
Thank you. Any questions from the council?
No, Mr. Chairman.
Mr. Prisky.
I just want to add, this past week I got a chance to go to Tipton Airport to meet our aviation unit, and we have a joint working relationship with the Howard County Police, and that's a neat facility there, and they do some great things. So I just want to thank you, and let's keep that unit going. Thank you.
Thank you. Any additional questions or comments from the council? Seeing none, thank you. Public hearing on Resolution 3715 is now open. Anyone wishing to speak on 3715, please come forward.
Julie Johnson, P.O. Box 6634, Annapolis, Maryland. I'm concerned about where the balance of the mutuality is concerned, because I really didn't grasp that or understand. Are we helping them out, or are they helping us out, or is this just in emergencies that we help each other out? And I would, in other words, I don't understand, what the cost to taxpayers are and what the benefits are. Thank you.
Thank you. Anyone else wishing to speak on 3715? Seeing no movement in the audience, the public hearing on 3715 is now closed. Madam Secretary, please read the title of Resolution 3715.
Resolution to ratify a mutual aid agreement.
Thank you. Any final discussion? Seeing none, Madam Secretary, please call the roll on Resolution 3715.
Mr. Grasso?
Aye.
Mr. Fink?
Aye.
Mr. Pruski?
Aye.
Mr. Perutka?
Abstain.
Mr. Trumbauer?
Aye.
Mr. Smith?
Aye.
Mr. Walker?
Aye.
6 in the affirmative, 1 abstention. Resolution 3715 is passed.
Thank you. Madam Secretary, please read the title of Resolution 3815.
Resolution recognizing the Community Health and Wellness Center at Reese Road, Citizen Working Group.
Mr. Smith. Thank you. Mr. Smith, your
Well,
resolution?
Well, hopefully this is a good news story. So we'll hopefully bring smiles to the rest of the audience members. But this resolution is essentially an effort to legitimize a process that has been underway for a number of decades. And I think for me, in my perspective, I certainly believe it required the county to sort of intervene just to ensure all the pieces are put together going forward. We're going to have some testimony from audience members, and I will certainly say a few remarks after that. So thank you, Mr. Chairman.
Thank you. Mr. Marzick, do you have any comments? Administration is a co-sponsor.
Bernie Marzick from the County Executive's Office. Mr. Smith, thank you for introducing the resolution, and as we've been working with you since coming into office, this is obviously a top priority for you. It's a top priority for the administration to establish a health clinic in this area that's in need of this health clinic. So we commend you for this resolution, and we will offer our support as this group begins its efforts to develop a plan for this health center. So,
Mr. Chairman.
Mr. Pruski.
I just want to recognize I'm a co-sponsor on this bill. The area of what this will eventually serve used to be in District 4. When I was on the Board of Education, we obviously advocated for this, and I'm just glad it's finally moving forward. I want to thank all the community members that are here tonight, and that we will continue to make sure it comes to fruition, but keep up the good fight. Thank you.
Thank you. Any additional questions? Seeing none, this time we'll open up the public hearing on Resolution 3815. Is anyone wishing to speak on 3815?
Yes.
Seeing no movement in the audience. There's a couple people. All right.
And if Dr. Chan actually was...
I didn't think we had any sign-ups. I don't know. I didn't see it. Maybe, I think there was the only one. I apologize. Come on down. Dr. Chen, would you like to start us off? Why don't you do that?
Sure. Thank you so much for allowing me to be here tonight. My name is Dr. Jinling Chan. I'm the health officer with the Anne Arundel County Department of Health, and I'm pleased to be here tonight to speak in support of this resolution introduced by Councilman Pete Smith. To establish the Community Health and Wellness Center at Reese Road Task Force. Certainly, health disparities continues to be an important issue that we grapple with in the county, and that affects communities north, south, west, and central. And certainly within this particular region of the county, we're experiencing health disparities. We believe that access to health care that is trusted and high quality is certainly one issue that contributes to the differences in health outcomes that we see among certain populations within our county and among our neighbors. This Severn area, which includes Mead Village as well as the communities along Pioneer Drive, like the Orchards at Severn, Arwell Court, and others, has certainly a higher percentage of people in poverty, 9.2% versus 6.3% in the rest of the county, as well as a higher percentage of people on food stamps, 7.9% compared to 5.6% in the rest of the county. Some of the major health issues that impact this particular community, including things related to maternal and child health, so we're looking at infant health outcomes. There's a higher rate of low birth weight births, as well as when we did a sub-analysis a few years ago that I was a part of, we certainly saw that this population accessed early prenatal care, that is in the first trimester of pregnancy. They accessed it later than other populations in the county, and there was a higher rate of teen births in this county. In addition, there's chronic disease issues, so higher rates of asthma and high blood pressure that cause people to go to the emergency room unnecessarily, and these are certainly conditions that can be affected by good access to primary care. And lastly, certainly and not least, substance use affects every community in Anne Arundel County, and this area in Severn is no stranger to substance use, and we have, and the police statistics have shown that people have died and suffered overdoses related to their substance use issues, and so having access to substance use care that is, again, trusted and high quality is really important. Lastly, I would note that the census tract of 740104, which includes the area of Mead Village, has actually been designated as a medically underserved area by the Federal Health Resources and Services Administration. And so that's something really important because they take into account not only what the population looks like and some of the health issues there, but in terms of how many primary care providers are available to serve that population. So that is one particular census tract that has been designated, one of very few, I would say, that have been designated as a medically underserved area in Anne Arundel County. Total health care, of which a key person is sitting next to me, is a federally qualified health center that was just recently this spring awarded this particular service area to serve Anne Arundel County, and has really been a great partner at the table to talk about the health needs of the Severn area. And I believe their track record in Baltimore City certainly provides us with a strong foundation to move forward on such a health and wellness center. So, in closing, I'm supportive of this resolution and the goals that it outlines to be able to establish and plan for a health center to serve this needy community. The work of the citizen group and some of the members that are represented here on the panel to work towards the establishment of the Community Health and Wellness Center at Reese Road is to be commended, and the administration and the Department of Health is in support of it. So thank you very much for your time and attention.
Thank you. Ms. Brown.
Good evening. My name is Pamela Brown. I'm the Regional Director for Anne Arundel County from Total Health Care, headquartered in Baltimore, Maryland. And we are excited about coming to Anne Arundel County. Our very first health center will be opening in October of this year in Odenton. So we are looking forward to it. We're excited about this project. We are supporting the task force in every aspect to do our very best to serve the citizens and residents of Anne Arundel County.
Thank you.
Good evening, Chairman Walker, members of the council. Thank you. Good evening, Chairman Walker, members of the council. My name is Lisa Shore, and I'm a community volunteer here to speak about the resolution for the task force for the Health and Wellness Center on Reese Road. And I'd like to ask the folks behind me, anyone in the audience who's here to support this project, to please stand. I've been involved in this project since I drove through the area on a Leadership Anne Arundel bus tour in 2003. However, my involvement is minor compared to the work of Miss G, Glenda Gathers, who envisioned a recreation center for her community for over 30 years. On Thursday, Miss G and I met to discuss what we wanted to say to you this evening. Unfortunately, she wanted to be here, but unfortunately she was called away on a family emergency out of town. And I hope that I can adequately share her commitment and her passion for this project. This project is about health, hope, and heart. The health part is the medical center that will serve the critical needs of the community. The community center will provide preventative health care through recreational activities, wellness, and support. We're thrilled to have a potential health care company on board that understands this. In Ms. G's words, this project is also about hope. It's about providing positive opportunities for youth and adults. Quality recreational and after-school programs for kids will keep them engaged and off the streets and help them grow up and become contributing members of our community. Adult and teen programs will provide support to help them make positive, productive life choices. We've envisioned things such as fitness programs, GED and college classes, job training, and parenting courses. We expect the Health and Wellness Center to become the heart of the community, a place where everyone is welcome and where opportunities abound. Just like the community center in Severna Park, it will be a community gathering place that enhances family life and individual development to create a healthy, vibrant, and connected community. Please vote yes on this resolution. Thank you.
Thank you. Mr. Bracy?
Mr. Chairman,
yes.
real quickly, I just recognized Julie Hummer from the school board, and I just wanted to sort of recognize her presence here in the audience, and thank you for being here in attendance. Yeah.
Mr. Chair, while we're recognizing people, there's an Annapolis City Alderwoman in our presence as well. Rhonda Pindell Charles is here from City Annapolis.
Thank you. Thank you. I apologize. Mr. Bracy?
I'd like to say I'd like to thank the chair and the vice chair for having us here today. As you know, this is my 8th appearance here regarding the Health Center / Rec Center at the time. I'm just here basically as the longest serving person on this issue along with Mrs. G. Me and Mrs. G, we were tied at the hip on this issue for over 30 years. It's long overdue. It broke our hearts when we was 2 weeks away from groundbreaking last April when the rug was pulled from under us. You all know what happened with that. So basically, I'm just here just to reinforce what I've said here for the last 30 years, and is that this project is long overdue. Some of you were babies when we started. Some of you were not even in politics when we started with this project. And Lieutenant Smith is next to me. We were joking how he was a baby officer when we started this project, looking for this to get done. So we're getting kind of long in the tooth now, and it's long overdue. I would really like the council to approve this measure as soon as possible so we can get rolling again for like the 5th time now. And it's long overdue. The kids are needed now. I ran into a young man who now he has grandkids when we started this project. He was 22 years old when we started, and now he has grandkids. That's how long this project's been going on. So thank you for allowing us to be here, and thank you for allowing me to speak. Again, we'd like to ask you to vote yes in the affirmative. Thank you.
Thank you. Lieutenant?
All right, I'm just a kid from Baltimore. I came down here in Anne Arundel County, and I was immediately assigned to the Pioneer City area. I met Lewis back then, the 2003 bus tours when I met Lisa, and the many others, Miss Gathers, Miss Galloway, and countless others, Miss Grace, who wasn't here tonight. we're all the glue that's kind of tried to keep this thing together over the years, and this is what you call police and community together. This is what it's all about. I don't have any other agenda to be here but to continue to support this initiative. I don't work in a community anymore, but it's very important. I worked with Mr. Persky many years ago. We did a community beautification project there. Worked with Mr. Smith when we redid the Mead Village Rec Center. These are things that are important to the community, and as we see across the country, the investment in the community is a big deal. I remember seeing a van, a big like tour bus parked in front of Van Bachelen Elementary School during the final weeks of August, and that was the little makeshift lab basically to get the kids immunizations. And this is before the People's Health Center took over a little row home to try to immunize these kids who didn't have access as others do to health care. So the opportunity to get a health care center that would also have some type of recreation space is paramount. The principals of Van Bachelen Elementary have been instrumental to the police officers there who let us beg, borrow, and steal the space to use for free when we had opportunities to engage our community, have community meetings or what have you. So an opportunity like this to have another facility there for our use, coupled with the healthcare services that are desperately needed for a number of the kids and parents. And I don't know how many of you have gotten to go into some of the houses there, but it's some deplorable conditions, and they need it more than anything. And there's been a lot of progress made in the past 15 years that I've been over there. And I hope that you guys support this and continue to support it. Thank you.
Thank you, sir. Appreciate it. Ms. Johnson.
Julie Johnson, P.O. Box 6634, Annapolis, Maryland. I won't say much, except to say that if you don't vote for this, there's something terribly wrong. These people come to you and ask you and plead with you. They have the right to demand the public services that are provided elsewhere in the county for people who are much less needy, that these folks have been deprived of. So I certainly hope each and every one of you will support a deep and a profound need in the community. Thank you.
Thank you, Ms. Johnson. Anyone else wishing to speak on Resolution 3815? Seeing no movement in the audience, public hearing on Resolution 3815 is now closed. Madam Secretary, please read the title of Resolution 3815.
Resolution recognizing the Community Health and Wellness Center at Reese Road Citizen Working Group.
Thank you. Any final discussion?
Mr. Chairman?
Mr. Peruka?
If I could, just briefly, obviously this bill has a lot of support, or this resolution, I should say, has a lot of support, and it's going to pass. And I mean no disrespect to anyone who's introduced it, nor to anybody who's spoken on behalf of it. I respect what you've said, and I can't in good conscience vote for this resolution because I'm stuck on the authority question. I don't see in the constitutionally how we have the authority to do this. So I just wanted to explain that, and again, I mean no disrespect. It's not a question in my mind of the goodness of the project or the usefulness of it. It's a question of the authority for it. Thank you.
Mr. Chairman.
Thank you. Ms. Smith?
And just for clarification, this resolution is essentially calling for the legitimacy of a group of folks who will look at how to complete the project, not the specific project. And so while my colleague from the 5th District might be concerned about the authority for the facility itself, recognizing the efforts of citizens who want to work on that may not fall within that category. Just respectfully sort of putting that out there.
Yeah,
Thank
you. Mr. Chairman?
Mr. Peruka?
And I do thank you for that. And I reserve the right to be wrong about this. My mind could change, but that's where I'm stuck. Thank you, sir.
Thank you. Any final discussion? Seeing none, Madam Secretary, please call the roll on Resolution 3815.
Mr. Grasso?
Aye.
Mr. Fink?
Aye.
Mr. Persky?
Aye.
Mr. Peruka? Mr. Drumbauer?
Aye.
Mr. Smith?
Aye.
Mr. Walker?
Aye.
6 in the affirmative, 1 in the negative. Resolution 3815 is passed.
Thank you. Madam Secretary, please read the title of Resolution 3915.
Resolution approving waiver of statutory repayment obligation and release of lien on property in Linthicum, Maryland, owned by Hospice of the Chesapeake.
Thank you. Mr. Marzick, when you're ready.
Mr. Chairman, members of the council, this resolution 3915 allows the county to waive the repayment of a $10,000 grant to the Hospice of by the Hospice of Chesapeake. This $10,000 grant was originally issued with the required condition that it is repaid if the land was no longer used for public purposes. However, this property was used for over 20 years for public purposes, and we are requesting the repayment obligation be waived due to these 20 years of public use and benefit as a health care and hospice clinic. The council should have received a letter from the hospice requesting this resolution last week, and Lori Blair from the Office of Law is here to answer any questions the council may have.
Thank you. Any questions from the council? Seeing none, thank you very much. This time we'll open the public hearing on Resolution 3915. Is there anyone wishing to speak on this resolution?
Good evening, Chairman and Councilman. David Whitney of Cape St. Clair in the 5th District. My only question here is hospice a profit-making business? Because I've read several articles that talk about hospice being a profit-making business. So that's my only question here. Thank you.
Anyone else wishing to speak? Yes, thank you.
I'm Ed Schneider. I'm the Chief Financial Officer for Hospice of the Chesapeake. We are a non-profit, non-for-profit. There are hospices that are for-profit, but we are non-profit.
Thank you. Any additional testimony on Resolution 3915? Seeing none, the public hearing on Resolution 3915 is now closed. Madam Secretary, please read the title of 3915.
Resolution approving waiver of statutory repayment obligation and release of lien on property in Linthicum, Maryland.
Thank you. Any final discussion? Seeing none, Madam Secretary, please call the roll on Resolution 3915.
Mr. Grasso?
Aye.
Mr. Fink?
Aye.
Mr. Pruski?
Aye.
Mr. Perutka?
Aye.
Mr. Trumbauer?
Aye.
Mr. Smith?
Aye.
Mr. Walker?
Aye.
7 in the affirmative, none in the negative. Resolution 3915 is passed.
Thank you. Closed. Madam Secretary, please read the title of Bill 5215.
An emergency ordinance concerning current expense budget, fourth quarter fund transfer, and supplementary appropriation.
Mr. Marzick, when you're ready.
Mr. Chairman, members of the council, Bernie Marzick from the County Executive's Office. Bill 5215 is the fourth quarter transfer bill. This bill transfers remaining balance from the CO contingency fund of $2.66 million and savings from the under expenditures in other departments over $666,000 to make additional appropriations to the departments that are in need. There's a total of $3,331,100 added to the general fund departments to cover expenditures that were unanticipated or that were in excess of the approved budget. You all should have the chart in front of you, but it transfers $30,000 to CAO, $900,000 to Central Services, $392,000 from Office of Finance, $464,000 to non-departmental Office of Finance, $500,000 to the Police Department, $901,000 to the Fire Department, $74,000 to the State's Attorney, $70,000 to the Liquor Board, and we have Jessica Lays from the Office of the Acting Budget Officer, who is here to answer questions the council may have, as well as Nancy Duden from the Office of Law. I'd be happy to answer any questions.
Thank you, Mr. Marzick. Any questions from the council?
Here, Mr. Chairman.
Mr. Grasso?
Yes. My contention, and is now, and probably is even so then, is that I got an amendment introduced to not allow the $70,000 transfer to the Liquor Board. There's a couple ways of looking at things on this avenue. You can say, is there a possibility we had a contract and this person deserves that money? That might be fair too. On the second point is that I'm still trying to understand how we wind up paying someone $200 an hour, and who was it that approved this $200 an hour when we just had the last meeting, and we would say that in the same situation we would have one of the attorneys from the Office of Law that generally makes somewhere probably between $75 and $80 an hour handling the same case. So I haven't received anything from the Liquor Board showing where these hours were spent and where this $70,000 ran up at. And just have you guys got anything with it? Have you got a bill showing where this money is being spent? Because in my feelings is that it might be legit. I'm just really upset that I just think that the government in its means is penalizing a business that is trying to open up that had a liquor license, and $20,000 of that $70,000 was used to fight this man. And the man had a liquor license, and now we don't want to give him a liquor license again. At least it's on hold at this point. There was no decision. So has anybody received a bill or shows hours on where this money actually come up? Because Chairman Walker made a comment, I guess a couple meetings back, and the individual was in the group over there and said, I just would like to know, are we paying this person $200 an hour to sit in the chairs? And I just can't get my hands wrapped around it. I'm not saying they don't deserve their money, because if they work, they deserved it. But I just feel like something is just not right here with $70,000.
For the record, Nancy Duden, County Attorney. Mr. Grasso, we did receive an itemized breakdown on the bills through Ms. Sutherland, the auditor. So Ms. Sutherland got it from the Liquor Board, and I got it from Ms. Sutherland. And Ms. Sutherland asked my office to go through those bills, and we did that and made a recommendation back to Ms. Sutherland about various categories of what we would see as approved expenses versus expenses that were not under the contract. Ironically, the situation that you point out with the gentleman trying to get his liquor license does fall into the category of what we would say were approved expenses, because that's exactly what the contractual attorney is supposed to be doing, is representing the Liquor Board on those licensing hearings. And as far as the contract situation, yes, there was a contract and there was an addendum, and then there were amounts accrued that were outside that addendum to the contract. But those amounts, other than the few things that we pointed out to the auditor, are amounts for work that was done for the Liquor Board, legitimate work, well-done work, and it would be, certainly be our recommendation that those amounts should be paid.
Is that the entire $70,000 is what you're saying? So that $70,000 is good for everything?
It's not actually $70,000. It was closer to, Ms. Sutherland has, it was closer to $98,000, I believe.
Okay, so we've taken it down to the 70s. Where's the other 20 going to come from?
The other, there were some amounts that we, and again, I'm not the final authority on
Right.
this, but there were some amounts that my office, in conjunction with purchasing, recommended that not be paid as outside the contract. So representation before the Ethics Commission, that type of thing that was outside the contract. But there are, the vast majority of those amounts we would recommend be paid for FY15.
Okay. I called, who is it that's underneath of you? One of the
Lori
assistant-
Blair. I
Yeah.
believe you spoke with Lori Blair.
I didn't speak to her. I left a message and I didn't get a return call back. Maybe she tried to call me.
Today, I'm sorry, she's in Maine.
All right.
She's on
Well, no, this
vacation.
was a week or two ago.
Yeah.
I'm fighting this cell phone thing. So I'm just not going to be like the rest of the people walk around like this all day long with a cell phone. So I just let my voicemail fill up, and I said if they want to call me, they'll call back. And if they don't, oh well. The issue, and I lost my train of thought. Let's see. Who is it that signed this contract?
The contract gets signed by Central Services, by the purchasing division of Central Services. So there's a buyer, just like there is for any vendor that the county engages for services.
Is that buyer still working for us?
That buyer is still working for Anne Arundel
Unbelievable.
County. To be perfectly fair, the contract then, once signed by the buyer, comes to the Office of Law to be signed for form and legal sufficiency. We do not negotiate rates or numbers for contracts. We just look at it to make sure it's binding and acceptable. And we did sign the contracts for form and legal sufficiency in the Office of Law.
So my argument would probably, my fight should be with actually Central Services to try to understand why we're paying someone $200 an hour. Was it, you think there was an actual bid put out for somebody? Or is this?
There does not have to be a bid for professional services. For a professional services contract, unlike certain other contracts, there's an exception in Article 8, and you can choose the professional that you think would be the best fit to perform those services.
Okay, the picture's getting clear here now. So what you're saying is who is it that chose this person to be on the professional services? In other words, who was it that made that decision?
And I'm afraid I don't know.
Okay, so it would have been Central Services though, right?
No.
Okay, so that leaves us with the actual Liquor Board then, is what you're saying?
That would be correct.
because it's sort of a hybrid agency, well, it's really a state agency that gets county funding. They would have come to us and told us who they wanted their attorney to be.
Got it. Okay. Put some light on the subject. All right, thank you.
Thank you, Mr. Grasso. Any additional questions?
Mr. Chairman.
Mr. Kursky?
I have a question in regards to the Regional Transit Agency. I brought this up during the budget process. If you look at line 41, I know there's an amendment, and I'll wait to address that. But I just have some questions. Does the administration have an actual agreement in regarding this compact for RTA of record?
It is my understanding, again, Nancy Duden, County Attorney, it is my understanding, Mr. Prusky, that there has been no agreement signed at this time. I do know that the county executive has contacted the county executive from Howard County and provided his picks, his two people for the Transportation Authority. And it is my understanding that once all those people are in place, the agreement will be drafted.
Okay. I just want to follow up so the council can understand this. And again, I know this is a minor issue and $1 billion budget, but we have an agreement to run obviously bus service. And I should say, actually, I should correct myself. There is no agreement. Okay, we're actually giving money to something where there's no official agreement. There's a contextual piece that's there, but in terms of having signed piece. Also, an advisory board was supposed to be put together. That's not occurring. Certainly, we have an amendment coming forward, which I'll address later. And I just have some big concerns about, well, it might be state funding, federal funding coming down, that we're supporting a certain agency, and the quality of service, as I've said on several occasions, is also not up to par. So from a legal perspective, I hope the administration, and Bernie and I, you and I have talked about this, I want to go on the record, that someone start to oversee this a little bit more closely, because certainly it's federal and state dollars that you're providing quality service, and we're certainly not getting it. I don't know if the county auditor wants to add anything, but when the amendment comes up, I'll certainly do that as well.
Any additional questions? Ms. Sutherland?
Mr. Chair, I don't have any additional questions, but I didn't manage to write a blue letter this week, so I did want to offer a couple of comments on the fourth quarter bill. There are a number of corrections that need to be made, of which the administration has agreed to grant numbers, like where it says GFR 215, it should be 213. So there are a couple amendments for there. As far as the amounts go, the amounts appropriated from the Utility Water and Wastewater Operating Fund balance to Utility Operating Debt Service is just wrong. They don't need the money, and it's the wrong fund. They have agreed that that can be amended from the bill, and there is an amendment prepared to do that. And then for the fire department, they're asking for $901,000, and they only need $201,000, and $100,000 of it is in a different line item. And the Budget Office has also agreed to that, and that amendment is prepared for your consideration. And I think that's it.
Mr. Chair.
Mr. Trumbauer.
Thank you, Mr. Chair. So in the event that we make changes to this bill, the funds fall back into the CAO contingency?
Yeah,
I mean, if we don't reprogram them, that's where they stay, right?
Yes, the amendment will also correct that line item where you take it out of the contingency.
Okay, so each amendment in turn will reconcile itself?
There is one amendment to reduce the appropriation for the fire department. I knew about Mr. Grasso's proposed amendment, so we have to see whether that passes. When we looked at the Liquor Board request for additional appropriations, the additional bills received to date are $105,800. $5,100 of it is related to the Ethics Commission investigation, which I don't think you should approve the expenditure appropriations for. That leaves $100,695. They've already paid $60,000. $24,783 is encumbered, which leaves a net need, according to them, of $25,900. But they have savings in other line items. So should you wish to approve appropriations to pay these bills without paying the bills for the Ethics Commission investigation, a $10,000 appropriation would be enough to do so. So we also have that amendment prepared and a balancing amendment with the CAO, if that's what you choose to do.
Okay, so you've
We have
got
every
everything
possible
covered. Okay,
combination.
that's
Just tell
what I
us
was
what
trying to get at.
combination you want, and Joanne will bring it
Gotcha.
out.
Thank you.
Mr. Chairman? Mr. Chairman?
Mr. Grasso, and then Mr. Fink.
The council, just a couple days ago, and then also in the advice of the county auditor, we all took away, I'm going back on the liquor board thing because I'm getting texts left and right over here. We took away the $60,000 for their FY16 budget, okay?
That's correct.
Now, what is to prevent this from happening again? They turn around and bring contractual people in again and run short of the budget and then come up here again and ask for another $70,000 transfer. What is to prevent that from happening again?
Well, someone could always come in and ask for more money, but having gone through what we've gone through this year, I certainly think that both the Office of Central Services and the Office of Law would make sure that any contract going forward is drafted much more tightly to specify what the scope of services expected is, what the rate expected is, and what the cap is, and that there would be some type of language to perhaps automatically shift work into my office if the cap is reached, so that, you know, so that it's clear to whoever the contractual attorney is that they cannot exceed the cap on fees and expect to get paid.
Okay, that's good. Very good answer. I like that. Okay, thank you, Mr. Chairman.
Mr. Fink?
Thank you. Madam Auditor, you said there was $10,000, roughly $10,000 left, or $10,000 needed to pay the outstanding bills for the attorney. Is that correct? Yes. What happens if they're funded the full $70,000 request? What happens to that money at the end of the year, end of the fiscal year?
Well, any number of things could happen. If there are additional bills, because these are the bills through April, certainly at which point this was publicly being discussed, and I would certainly hope that there were no services rendered that haven't been billed once that discussion was on the table publicly. But if there are, or if the Ethics Commission chose to pay the other attorney who represented the other commissioner in the ethics investigation, and if they had an appropriation available, they could use it to pay those things.
And what happens if the money's just, they use the additional dollars that you talked about, they take 10,000 of the 70 and leave 60, I mean, it goes back to the general fund at the end of the year if they don't spend it, basically?
If you appropriated 70 and they only needed 10, and they didn't spend the remaining 60, it would fall to fund balance, yes.
Thank you. Mr. The current contract, was there a cap put on that contract at all?
No, the current contract for FY15 was $50,000, and then there was an addendum to allow an additional $10,000 on top of that, and that's the only signed addendum, signed approved addendum. And then money continued to be billed, and when it came to our attention, we went back and looked and realized that there was only the one addendum. So right now, the contract and the addendum are only for $60,000. But let me just be very careful to say that that does not mean that there wouldn't be an obligation to pay the rest of the money that was necessary for the scope of services we contracted for.
So the 50 and the 10, is that considered a cap or no?
No.
So if you put a cap on a contract, say in FY16 or 17, then we're not obligated to anything over that amount?
We could draft it in that way. There are two kind of prongs here. One is we would have to draft the contract in that way, and the second thing is that we would have to educate the buyer not to approve amounts billed above and beyond the contracted amount.
So if I'm that attorney and I'm working and I'm billing, and I guess at that point my client is the liquor board, and it'd be reasonable for me to believe that the liquor board is able to make the decision or has the authority to pay me. I mean, it seems like there's some obligation on our end to make sure that the attorney's bills are paid, right? I mean, they feel, if you're that attorney, you feel the liquor board's my client, they're telling me I can keep working, they're the ones paying me. I mean, never would you think that, no.
That is correct. And in all fairness, I want to be clear that this year, and when I say this year, fiscal year 15, There was definitely a misunderstanding on everyone's part about how this was going to play out. If you talk to the gentleman that approves for the state comptroller's office, his approach is, as long as they are within the money earned by the liquor board and given to the county for the general fund, then they're okay. I would argue that that is not entirely correct, because state law says that the liquor board is bound by our budget and fiscal policies and purchasing laws, and therefore a contract is a contract, and you would have to stick to the terms of the contract. But I would also say that the contract is not the most artfully drafted contract in the world, so it's not clear when the cutoff was. So for FY15, we are in, a year when things could be argued either way, which is why I say with caution that the liquor board is entitled to have their cases defended by their contractual attorney, and the contractual attorney, contract or not, is likely entitled to be paid for that work. And we can talk about $200 an hour or $100 an hour or $500 an hour some other time, but for the work that was done that needed to be done for that liquor board, there's a very good argument that that attorney is entitled to be paid for that.
Sure. Is there a contract for FY16 yet?
There is no contract for FY16, and as a reminder, you all cut that money from the budget and put it in the CAO contingency until we're able to work this out finally with the state.
How does that work? There's no money in the budget right now. If the liquor board decided they wanted to contract an attorney, would it still go through the normal process? And is there at some point that somebody says, hey, there's no money for this contract, so we can't do it, or does it just keep on cruising and they hope that the council will give it from the CAO account?
Well, we have a meeting coming up with the state to kind of try and work this out, so I don't think we're going to get to a point where somebody would have to say, hey, we don't have a solution for FY16. We are working very hard to put a solution in place before FY16, because the bottom line is the liquor board has legal business that has to be done, and we've got to figure out whether that's going to be a contractual attorney or my office or some other solution. We've got to figure that out.
But in general, in these contracts, is there some kind of check that says, hey, there's no money for this, how can we even begin a contract? Take the liquor board out, I mean, just any contract that we do.
Well, it really varies, because sometimes you're going to have a contract that's a flat rate to perform a service, but often these professional services contracts are just an hourly rate, and there's this interplay between central services and the controller, where the controller has to say there are generally funds available and we can pay for this.
So the comptroller would be the stopgate on that, say, hey, yeah, there's funds we can take it to Office of Law and verify this contract.
And the state comptroller is always going to approve it if it's within the money that the liquor board is earning for the county, is what they've told us.
But they're not the final fiscal authority.
I would argue that they are not the final fiscal authority.
But the comptroller would argue that
you are
he
the
is.
final fiscal authority.
But the comptroller would take the other position?
That is correct.
And the liquor board went to the comptroller and got permission for this, is that right?
That is
Remember hearing that at
correct.
the work session?
That is correct.
So
They
then,
did.
I mean, I wish we weren't in this situation, but it seems like the liquor board did what they thought they had to do. They believed they had the money. The attorney believed that the liquor board had the authority to pay her to do the work. So I mean, at the end of the day, it's...
That is correct, which is why the recommendation of the safest thing to do for FY15 is pay to date, except perhaps the amount for the Ethics Commission, and then we can work out a solution for FY16 going forward. But in FY15...
Why do you draw the line on the Ethics Commission? Because that was not in the scope of the contract?
It's not in the scope of the contract, that's correct.
All right, thank you.
Mr. Pruski.
I feel like deja vu. I certainly understand we voted on the budget for what's next year, for this past year, but I thought I asked at the last meeting that we were looking for an Attorney General opinion to clarify some of this. And again, I know you talked about meeting with the state, whatever else. Can you be clear on what we're doing to resolve this so we don't have it again.
Yeah, we've already had, and when I say we, Bernie and myself and Mr. Shu have already met once with Senators Astle and DeGrange, and we are having a follow-up meeting this week to try and work a solution. At the same time, we have asked them to reach out and get an Attorney General's opinion on these issues so that we can finally resolve them, because they will be able to get a response from the Attorney General much more quickly than we would.
Okay.
And hopefully we'll have it resolved before FY16, but we are working to resolve it.
And following up with Councilman Fink's question about the Ethics Commission or ethics work, you know, I know there's an argument whether that was in the scope or not in the scope. What if somebody argues that it's in? I mean, what happens? You know, the attorney says, well, I'm going to sue because I should have that money. I mean, where does that end up? I just want to be clear about what could happen next if that is something that's requested. I mean, if somebody's saying their service is paid and there's a bill out there, certainly, you know, you can sue it, but I just want to be clear on where would that go next?
Well, if the attorney that incurred those fees felt that that was within the scope of services and she chose to file suit, then we would have to litigate that. And in all honesty, we would most likely settle that case for some amount of money. You know, that's just the reality.
Some amount less than what they requested, typically.
Hopefully not the same amount. Okay. Thank you.
Mr. Chair, Ms. Duden, may I clarify, when you're talking about the work for the Ethics Commission investigation being outside the scope of services, you're referring to the services provided by Arthur Law Group?
That is correct.
If the other attorney who represented the other commissioner were to present a bill, those are not services rendered by Arthur Law Group, and that attorney has no contract to provide services to the Ethics Commission.
That is correct.
Right?
There was an outside attorney who represented one of the commissioners, and I would in no way agree to pay that bill. I mean, it just, there's no contract that could even pass the laugh test on that.
Was there a reason why that commissioner chose someone other than the person who was contracted? What was the reason?
Generally, when you have to defend yourself in front of the Ethics Commission, you are required to get private counsel, because...
Right, but I mean, why didn't that person also choose the Arthur Law Group? If one of them did, how come the other one didn't?
I don't know. I don't have that information.
Mr. Chairman.
Mr. Fink?
If any one of us 7 were to go before the Ethics Board, the Ethics Commission rather, would Office of Law represent us?
I don't believe so, no. I could take a look at that, but there are very strict code requirements for when we can represent people and when we don't represent people. And a lot of it would depend on the allegations, but generally, if you're going before the Ethics Commission and it is on an allegation that you have violated that in some way because of your personal conduct, you would have to get a private attorney for that.
Thank you.
There are other provisions in the code, for instance, for criminal. We don't represent county employees in criminal matters, even if, for instance, we have an inspector that trespasses onto land to do an inspection and is charged criminally. We do not represent that inspector at the criminal trial. He or she is required to get private counsel, and then if acquitted, they can petition the CAO for reimbursement of their legal fees.
Learned something tonight, didn't we?
Yeah, interesting. Didn't know that. Any other questions from the council? Mr. Marzick, this is the fourth quarter transfer bill, and it's labeled an emergency, and I was wondering if you could explain to us why it's an emergency.
It's a good question. I've actually thought about that since the
You've had some
hearing.
time to.
I have.
I'll just, before you make your statement, I'm just going to read back to you your testimony from before. It says, this bill is not necessary for the immediate preservation of the public peace, health, safety, and welfare. We committed to the council several months ago not to bring emergency bills before you unless they were necessary for the immediate preservation of the public peace, health, safety, and welfare.
Sure. There's
Those
actually
are your exact-
I'll give you a very simple explanation, actually, is that in order for this bill to pass before the end of the fiscal year, it would have to be introduced before the fourth quarter began. That's answer number one, because of the date as far as the introduction and the 45 days going up to it. So it's impossible to have a fourth quarter transfer bill passed.
It's because departments have exceeded their appropriation, correct?
If I may, I just want to point out the situation that would occur if you do not pass this as an emergency, is that at 11:59 and 59 seconds p.m. on June 30th, the FY15 budget ceases to exist. So it is not possible to do this retroactively with a regular bill that, would be effective in 45 days and then be retroactive to June 30th. It either happens before June 30th or it doesn't happen at all. So the result you would be left with would be certain things would be unfunded, certain grants would be unfunded. We could very well be looking at the possibility of furloughs or layoffs because there wasn't money to pay. So I don't disagree with the chairman's statement that maybe better planning was necessary on part of departments. That's not really a legal question, but I just want you to understand that legally we could be looking at litigation both internally and externally, because we could be in violation of certain negotiated contracts with certain unions. We could have vendors that go unpaid because this money wasn't transferred.
But it was because departments exceeded their appropriation.
I don't argue that. I'm just telling you why I would feel that this could, not only could, but has to be an emergency bill.
Hi, Jessica Lee's Budget Office. On a practical standpoint, we wait to do the fourth quarter transfer as late as we can in the fiscal year because there's two components that need to be met. One, an unanticipated expenditure or an expenditure that has exceeded what we budgeted, but two, the need. So some of these expenditures came up maybe in April or beginning of May that we might have known about, but we didn't know whether the department would need the additional appropriation to cover the expenditure because the department may have savings in another line item that can outweigh that cost that is exceeding the budget. As you can see, even in this bill was drafted in the beginning of May, and from May to tonight, just having more data in the system, having more expenditures, the administration will agree with the findings of the auditors because by the time the auditor reviews the bill, there's more information into the system and that the need may disappear or be less than what it was 3 weeks ago. So it is most financially beneficial to the county to do the bill later in the year, or else this bill would have been much larger earlier because the unanticipated expenditures were greater than the savings that offset some of the appropriations in the bill. So for all of the departments that are in this bill, at the time that we drafted the bill with the data that was in the financial system or what was known at that time, these are the departments that we believed would go over budget had we not provided an additional appropriation.
They both bailed you out, Mr. Marzick, but go ahead and say what you were going to say, because you had something prepared.
No, actually, I have nothing prepared. Really made at one point, but I think it's a big issue. That's this issue was raised. We came into office December the 1st, and this issue was raised, I think, in January by Mr. Peruka and by the auditor, and some of her comments as far as the definition. We'd be more than willing to work with the council to come to or have some effort to change the charter as far as the definition of what would qualify as an emergency bill, if there's some understanding, because there are situations where there are going to be emergency bills, and this being the perfect example of one.
Last time we met over this issue, that you weren't in favor and you committed to not introducing emergency bills unless they were for the public peace, health, safety, and welfare, quote.
Of the county, correct. And I would argue that this bill is.
And
but I mean it very sincerely, and I've said it to folks who I've talked to, since that meeting and since January, that the county executive feels strongly about this, and that it's an issue we want to work with you on. If you have ideas as to how to fix this charter, I mean, you all have been approving these bills.
I wasn't the one with the problem with it. You all were.
Well, I mean, Mr. Peruka had a problem with it. Ms. Sutherland had a problem with it, and some of her earlier blue notes on these issues, and we had a problem with it on the bill that you're referencing from a couple months ago, or a month ago. So we'd be more than willing to work with you on how to solve this issue.
Ms. Sutherland?
Mr. Marzick, I'm confused by your very first comment of why this needed to be emergency. Did you say that you would have to introduce this bill before the beginning of the fourth quarter?
That's what he said.
In order for it to be effective by June the 30th.
Why is that? Every day in May is a legislative day, and it would only be a bill that required 2 weeks advertising. So you would not have to introduce it before April 1st. You could introduce it on...
I think March 16th is the date that comes to mind as far as when the bill would have to be introduced.
Probably May 16th makes more sense. Or really even May 29th. If it's an ordinance that requires 2 weeks advertisement, that's it.
And the bills that we've been introducing...
Oh, you're saying for it to take effect with a 45-day effective date?
Correct.
I'm sorry. Okay.
An effective
Right,
date,
so I think it's
yeah.
March 15th would take you to April 15th, meaning it passed that day, and then you'd have 45 days after that for it to...
Well, you'd really have to pass it by around May 15th, so end of April.
Correct.
Okay.
And just
That's
to
not,
be-
that's not the end of March, it'd be the end of April.
Okay.
Just to be clear, it does have to be effective before June 30th, or all is for naught. On or before June 30th, or all is for naught. And you end up with an FY15 budget where the expenditures exceeded the appropriations. That's just the reality of that.
The other issue, too, is that every year we amend this bill. So if it's not emergency and you amend it, we have to go to another hearing. And so I think it's that unpredictableness of how many amendments we have that this bill has never really gone through without some type of change because of the numbers being changed or an error, that it doesn't always take that 45 days. We introduce it, we're going to have an amendment, it's going to be pushed off to a future hearing, which is going to make it more than the 2 months that most bills could go through in.
Fair enough. Any additional comments or questions? Seeing none, thank you all very much. This time we'll open the public hearing on Bill 5215. Is there anyone in the audience wishing to speak on this bill?
Thank you, Mr. Chairman, members of the council. My name is Harry Blumenthal. I'm counsel to the Board of License Commissioners of Anne Arundel County. And to my right, your left, is Ms. Judy Hagner, who is the administrator to the board. We obviously listened with interest to the varying expressions of opinion and views that have gone by, and quite frankly, I find merit in all of them. But, of course, they're somewhat inconsistent within themselves. We're really here to be responsive to questions should you have them, but if I may, having heard the colloquy that has gone on, I'd like to give you a different perspective, or not a different, but another perspective on why we're in this situation, everyone. And I think Ms. Duden fairly stated the situation, that the work was performed, no one quite knew we would get here, and the problem is that the system this past year is no different than the system that has been in place for 50 years. It's the amount of money that has brought this to the council's attention, to the board's attention, to the attention of the county executive, and to the attention of the controller. But there's nothing different about the system that's been in place other than that in this year, as I mentioned when I appeared before you last time, the board has experienced an unusual amount of litigation. And the problem with litigation is when an attorney starts a trial, the attorney can't quit if it gets too many hours. You have to continue with the trial. You may think it's going to go 1 day or half a day or a week, and it goes a month. You don't have the option or the luxury to say my client is out of money and I'm leaving. Whether it is the board or whether it's private counsel, it is not ethical for an attorney to stop representing his or her client in the middle of proceedings just because the funding's not there. And in this instance, the funding was there because, as has been indicated to you, the procedure is that the board, and not me, but the commissioners, hire counsel or ask counsel to submit a proposal to them. They then have that proposal approved by the controller of the state of Maryland. Without that approval, that never reaches the county. With that approval, it gets to the county.
Can you please summarize, Mr. Blumenthal?
I'm sorry?
Can you please summarize?
Yes. Well, Ms. Duden has indicated to you that there is an attempt to work this matter out. so that this situation does not repeat itself next year. The administration has recommended a fourth quarter transfer of $70,000, which includes bills which have been submitted but not yet paid. And we recommend, I suggest to you, that this is an appropriate resolution to a solution that will avoid all kinds of difficulties that otherwise might occur. Thank you very much.
Thank you. Is it your opinion that the ethics billing was correct?
I think so, because we have advice of outside counsel that it was. Now, maybe the council's opinion will be challenged by others.
Then why was one of the commissioners step outside of the contract with Ms. Arthur and go somewhere else for litigation support?
That is the opinion of counsel that I obtained, that it was appropriate for the board to recompense a commissioner for private counsel before the Ethics Commission. I did not...
I understand there were two people that had ethics issues, though, and one of them used Ms. Arthur and one of them did not. Was I not clear in that?
I don't know. I was not involved in those decisions. I was asked, I made it my task to ask outside counsel whether the chairman of the board could hire independent counsel to represent him before the Ethics Commission. I felt that I could not, because the allegation made against the chairman included by inference, an allegation against board counsel. I'm board counsel, so I wasn't going to represent the chairman of the board or the person making the allegation to the Ethics Commission without naming board counsel, said board counsel in the complaint. So I felt I was conflicted from doing that.
Okay,
so
but I guess what I'm asking is that it sounded like from Ms. Duden's testimony that there were two members that had ethics complaints against them. One went to Ms. Arthur and one went somewhere else. Was that incorrect? Did I mishear that? Maybe I was confused.
I believe that factually that's correct.
Factually, it is all three had a complaint against them.
Okay.
Two went with Arthur Law Group. The chairman hired an outside counsel.
Okay, so were we reimbursing the chairman then?
I do not know.
Part of the fourth
Did the chairman turn a bill in for his
No.
services outside of the group?
No, sir.
But you do believe that we owe Ms. Arthur, even though it wasn't within the scope of her contract?
I do believe so.
I'm sorry.
I'm sorry. My name is Judy Hagner. I'm the administrator of the board.
Thank you. And you have 2 minutes. I don't know
I
if
just
there's anything else.
came forward in case you had any other questions.
Okay. Sounds good. Ms. Johnson.
Julie Johnson, P.O. Box 6634, Annapolis, Maryland. I know virtually nothing about the case, but as a taxpayer, this raises the issue, an issue that is an ongoing habitual complaint where clients retain counsel. You make your deposit, there's an estimated cost for the case, and you get to 2 days before trial, or very close to trial, and suddenly we need thousands of dollars more. The client is over the barrel, he has to cough up the money, and he does. There are attorneys who work on a contingency fee basis, that they get 1/3 of what they're going to win if there are damages. There are other kinds of contracts. For instance, if you hire somebody, you can hire somebody at hourly wages. On the other hand, you can say, what do you charge to paint a house or put on the roof? You figure in all the materials, all the contingencies, and you give me an estimate for the entire cost. And those people make very good livings, and they're very successful, and they have a fair and reasonable estimate of the amount of time that things are going to take. I sat in on the trial, on a trial for a divorce among one of my son's friends, and what was supposed to be a 2-day trial dragged out to 8 or 9 days. The people are entitled to a divorce. The fees to each party were $90,000. This is under 35 years old. So you're looking at $180,000 to get a divorce. This is preposterous. It's outrageous. I sat there, and they repeated the testimony over and over again. They were deliberately running up the bill. And so I have really serious concerns that when county agencies are establishing contracts with professionals, that there is a view of this is going to be what we're
Can you
willing to pay.
please summarize, Ms. Johnson?
So that rather than having an open-ended issue of how many billable hours were there is a closing to it. And the other thing is, all of you have heard a bazillion jokes about billable hours. And if you haven't heard any, I'll tell you a few, but essentially there are at least 25 or 26 billable hours in every day.
Thank you. Ms. Hagner,
Yes, sir.
to come back to your willingness to answer questions, the bills that we've received to date, those are through 1st April or end of April?
1st of April.
1st of April.
And they total
After-
$45,772.
The bills in FY15 to the date to April?
Of April 30th. I mean, sorry, March 31st.
March 31st. And then, and I guess at that point, you all sort of knew that there was some attention focused on the issue. And so have there been additional bills since the beginning of May through this period or through the
Not
end of
that I
June?
have received. I'm sure there are, but I have not received them.
Okay, so Ms. Arthur has performed work for the board, but hasn't billed you for it yet?
Correct. She hasn't been paid for any of this work.
But she hasn't sent a bill yet for any of the work that
She
she's
hasn't
done
been-
since the end of March?
Correct, but she
Is
also...
that normal practice for her not to send bills in a timely
No, I
manner?
usually get them in the first of the month, first week of the month.
So she bills once a month typically?
Yes.
So since the end of March, it's been April, all of April and all of May, and now we're halfway through June, but you haven't received any invoices since
No.
the end of April?
No.
Do you know why? Did she give you any explanation?
No, I have not asked her.
Ms. Arthur, would you care to explain that to us?
Thank you, Mr. Chairman. Sarah Arthur. I didn't submit them because I don't know that I'm going to be paid for them. So at this point, everything was put on hold, and I've just stood back. I've done the minimal amount of work for the liquor board that they required. I attended a hearing last week because Mr. Blumenthal was ill, and they needed someone to cover, but I really have done as little as possible the last couple.
And what does that translate to? I mean, as little as possible. I'm not sure. Is there a certain, do you have an idea of how many hours you've performed service for them over the past
I mean,
2.5 months?
I have looked at the totals, yes.
What are they?
I believe the total is, I think it's about 55, 60.
55 to 60 hours?
60,000.
55 to 60,000 additional dollars in billing?
No. It's the total amount. I don't know what the additional, I guess the additional would be about, I think it's over a 3-month period, about 15.
Okay. Ms. Sutherland, the number of dollars, so we're talking about last year's budget that was approved, and we approved a certain number of dollars for them already. I'm assuming at this point we've gone through the dollars that were appropriated, and now we're into over appropriation. So what this translates into is almost like a transfer, like we're just transferring the money. What based on what you've got the calculations over there, would you mind running over those with us at this point? And then add in, say, 15,000 extra in overage hours, and what does that come up short as far as what we appropriated last year and what they've requested and she's submitted billing for this
Okay. So the bills received to date through March, for services through the end of March, totaled $105,800. So if there was another 15, we're at $120,800 for the year. The county's already paid 60, so that's going to leave you with $60,800. There's $27,800 that is encumbered that would be used to offset that. So that would give a shortfall of $36,000. There is, by my calculation, at least $15,000 of savings in other line items that could be used to reduce the additional appropriation needed. So 20 to 25,000 would be enough, I believe, to cover the bills that have been received that are unpaid and unencumbered, and the additional 15,000.
Mr.
Ms.
Walker.
Hagner, you were shaking your head in disagreement on the 15,000 in savings. What,
I had encumbered, you had to figure 27,000? That was in-
$24,783.
That took me to bare bone. I had nothing left in my budget.
Well, nothing.
No, let me, if you excuse me. When we spoke with the comptroller and I spoke to purchasing, I was told with this fourth quarter transfer, and I also talked to the Office of Budget, that I could pay Miss Arthur the $24,700. That would take out part of her bill to give her her money. Then, if the fourth quarter transfer was put in for the $70,000, I would get my $24,700 back, put back into my budget to pay my additional invoices that I have in my office.
Additional invoices for what?
For printing, I've got bonding for my inspectors,
Did you make
advertising.
Did you make the auditor aware of those encumbrances? It sounds like they're encumbered, or they're not encumbered, or?
They're on my P card. These are monthly occurrences.
Right. But, Mr. Chair, when we looked at it, and we looked at it as recently as this morning, I'll give you an example. There is a $15,000 appropriation for computer consulting services, of which there was a $1,000 invoice recently
Right, and I took
submitted and incurred.
$10,000 out of that account earlier for Miss Arthur. That's where the additional $10,000 came from.
Okay. When we looked at it, we think that there will be $20,000, and this is as of this morning, there'll be $10,000 of savings in supplies and materials and $10,000 of savings in business and travel. And we don't see the appropriation for the computer consultant being used for $14,000. So that alone is $34,000 of savings. I backed that off by $10,000 or $15,000 to make sure nobody gets hurt, make sure everybody has enough money. I'm not cutting them to the bone, and I don't think I'm recommending a reduction that would be inappropriate.
Second.
I do. I'm sorry. I took the $10,000 out of professional services, other professional services, which is my computer programmer. I transferred it over to Arthur Law Group. That gave her that $10,000 appropriation. Then that left $5,000 in that account. I have been waiting on a bill from Mr. Davis. I finally got one of $1,000. I'm expecting another one come in any day now of $2,000 to $3,000. If you say I have that much in supplies and materials, I'd love to use it because my printer died about a week ago.
Have you considered that the encumbrance for your purchase, your procurement card will be liquidated and that that money is available?
No.
Ms. Sutherland, you're suggesting then that at this point, the administration's request for $70,000 is excessive. Is that correct?
Yes.
And what would you, in your estimation, give us as a dollar figure to say that was appropriate to transfer to them to, based on Ms. Hagner's comments and your analysis, provide them without leaving them at zero?
And providing the additional $15,000 for the services since the end of March, $25,000.
So
And
anything
Ms. Hagner,
over,
you disagree with the $25,000?
I do, just because
And
anything is left
What number
over.
would you agree to?
I wanted $70,000.
Okay, but...
That's what the comptroller approved of our request.
Right, but you're not spending the $70,000.
If it don't spend it, it goes into the county general fund with the other $300,000 that we've earned.
But if you've, I understand, but if you're saying that, Ms. Sutherland's saying that $25,000 is a reasonable number, and you're saying that you want the full 70, so by my math, that's $45,000. Are you expecting $45,000 in bills in this last quarter that we don't know about?
I do not know. I can't answer that because I don't know.
I'm not trying to put you on the spot. I'm trying to understand the math. I don't understand why
I do
you're...
not agree with Ms. Sutherland's
why you're-
math. That's all.
Right, but I guess what I'm trying to say is that she's figuring that that there's $25,000 won't leave you in a position where you'll be unable to pay bills that you get between now and the end of the fiscal year. But you're saying that, and I gave you the opportunity to say what number would, and the only number you came back with was the $70,000, but that's $45,000 difference by my guess, and I don't know what you plan to spend the $45,000 on. That doesn't make any sense to me, I guess.
Mr. Chair, if I
Ms.
might,
Sullivan?
then maybe this would help clarify it. Ms. Hagner, if the additional $70,000 appropriation is approved, and your original budget for legal services was $50,000, then that gets you to the $120,000, which is about Ms. Arthur's services for the whole fiscal year.
Correct.
So you're saying that you have no savings in any line item in fiscal year 15 that could be used to reduce the additional appropriation requested?
I'd have to review it again. I did on Friday. I may have, to my recollection, anywhere between 10 and 12,000.
10 and 12,000, and you weren't aware of the encumbrance for the P card, which is
No.
about how much? Do you know?
I do not know.
Okay. I mean, if that's 10 or 12,000 and the P card is 5,000, right there you're at 17, and I'm saying 25. So, I mean, we looked at it this morning. I think it's a good estimate, but
Mr. Chairman.
Thank you. Mr. Fink?
Do we know how much money they gave back last year to the general fund at the end of the fiscal year? Any idea, Ms.?
384,000.
So it's 300,000 that you earned, and then 84,000. I guess it was just under budget by 84,000.
Technically, yes. No, we were close on our budget last year.
So this year you're expecting to make, if that's the right word to say it, you're expected to make 300,000.
I would turn back approximately 3 to 350,000.
Between 3 and 350?
Yes.
So last year you think you made more, or you saved more in your budget to get to
I
that 384?
saved more in the budget.
Okay. All right. And then, do we, and you might have said this, Ms. Sutherland, and I missed it, do we know how much money's in the account today? I mean, is that
in what?
in the liquor board? I mean, is there,
I'm sorry, I don't have their total budget with me. We looked at it this morning. We looked at what it was appropriated. We considered that there is an encumbrance for P cards. Jessica is nodding to me. She doesn't have it with her either, I presume. But anyway, we looked at it this morning and compared the appropriations to the expenditures, to the encumbrances. How much are they going to spend in the next 2 weeks that isn't already in the system besides Ms. Arthur's bills? And that's why I think that that if you reduced it to 25,000, that would be enough.
so if we believe that Ms. Arthur should get, fully paid, we give the $70,000, what's the harm if the county's going to get it right back in 2 weeks? Or is there a concern that, hey, maybe, that 25,000 ends up 45,000? I mean, is that...
Well, one of the things that I would think it potentially could happen is that the other attorney would be paid from that appropriation. If you are okay with that, then...
Who's the other attorney?
The attorney for Mr. Hyatt, who represented Mr. Hyatt in the Ethics Commission investigation. If you are okay with that, then you can approve the $70,000, and what they don't spend will fall to fund balance.
Gotcha. All right, thank you.
Thank you, Mr. Fink. Any additional questions from the council? Seeing none, thank you all very much.
Thank you.
For your testimony. All right, this time we'll close the public hearing on Bill 5215. Madam Secretary, please read the title of Bill 5615 as amended.
An ordinance concerning Board of Appeals compensation.
Thank you. Mr. Marzick, when you're ready.
Mr. Chair, members of council, this bill is before you on July 6th. The county executive supports the bill as amended, provided the auditor is comfortable with members of the boards of appeal signing off on their own expenses, as we discussed at the last council meeting. I know she was not here for that discussion.
Thank you. Any final questions or discussions on 5615? All right, seeing none. Well, at this time, we'll open the public hearing on Bill 5615. Is there anyone wishing to speak on this bill? Seeing no movement in the audience, the public hearing on Bill 5615 is now closed. Madam Secretary, please read the title of 5615 as amended.
An ordinance concerning Board of Appeals compensation.
Thank you. Is there any final discussion? Seeing none, Madam Secretary, please call the roll on Bill 5615 as amended.
Mr. Grasso.
Aye.
Mr. Fink.
Aye.
Mr. Pruski.
Aye.
Mr. Perutka. Aye. Mr. Trumbauer.
Aye.
Mr. Smith.
Aye.
Mr. Walker.
Thank you. Aye.
Did you say
Aye, yes. Sorry.
7 in the affirmative, none in the negative. Bill 5615 as amended is passed.
Thank you. Madam Secretary, please read the title of Bill 5815.
An ordinance concerning Pines on the Severn Special Community Benefit District approval of loan and assignment agreement.
Thank you.
And this is just vote.
This is a vote only. The public hearing was held at the last meeting. We don't know if there's any final comments or discussion amongst the council prior to the
Mr.
vote.
Chairman, was there any, just for the record, any input from the community that actually laid out the physical voting of the meeting? Just for the record.
I have heard of none. Not aware of any,
Okay.
other than the emails I received.
Thank you, Mr. President.
And Mr. Chair?
Mr. Trumbauer.
Thank you. I don't know to whom to address this question, but considering the possibility that we will defeat this bill, then does anyone know what options are left to the community? Would they just have another vote and then bring another bill before us?
Ms. Duden, would you come down for a second? Would you care to comment?
Good evening, Nancy Duden, County Attorney. If the bill is voted down tonight, the community would have a couple of options. They could wait until their mitigation plan is approved by county authorities and then take another vote, or they could even vote in advance of that, provide you with the information that assures you that the vote was accurate, and then seek the funding at that time.
Okay. Mr. Chair, I just want to be clear. I intend to vote against this bill, but on the reason that there doesn't seem to be clarity around the vote, and we have received dozens of emails on, about questions regarding that vote. So I don't want a vote against this to be intended that I don't support what the community wants to do with this. It's just that there's enough questions surrounding the vote and enough dissension in the community to warrant, I think, some more time for the community to meet their obligations. So I just wanted to put that on the record.
Any other comments from the council? Seeing none, Madam Secretary, please call the roll on Bill 5815.
Mr. Grasso?
Nay.
Mr. Fink?
Nay.
Mr. Pruski?
Nay.
Mr. Perutka?
Nay.
Mr. Trumbauer?
No.
Mr. Smith?
Nay.
Mr. Walker?
Nay.
0 in the affirmative, 7 in the negative. Bill 5815 is defeated.
Thank you. Madam Secretary, please read the title of Bill 5915 as amended.
An ordinance concerning Broadwater Creek Special Community Benefit District.
Thank you. Mr. Marzick.
Mr. Chairman, Mr. Chairman, members of the council, Bernie Marzick from the County Executive's Office. Bill 5915 was before the council on July the 6th, and this establishes the Broadwater Creek Special Community Benefits District. There are two amendments that were approved by the council on July the 6th for tax ID correction and for address corrections in the bill. The administration continues to support Bill 5915 as amended.
Thank you. Any questions from the council? Seeing none, this time we'll open the public hearing on resolution, Bill 59, I got resolutions on the mind because we did so many of them. Bill 5915. Is there anyone wishing to speak on Bill 5915? Seeing no movement in the audience, the public hearing on 5915 is now closed. Madam Secretary, please read the title of Bill 5915.
An ordinance concerning Broadwater Creek Special Community Benefit District.
Thank you. Any final discussion? Seeing none, Madam Secretary, please call the roll on Bill 5915 as amended.
Mr. Grasso?
Aye.
Mr. Fink?
Aye.
Mr. Pruski?
Aye.
Mr. Perutka? Mr. Trumbauer?
Aye.
Mr. Smith?
Aye.
Mr. Walker?
Aye.
7 in the affirmative, none in the negative. Bill 5915 as amended is passed.
Thank you. Madam Secretary, please read the title of Bill 6115.
An ordinance
As amended.
concerning construction and property maintenance codes, seasonal waivers.
Thank you. Mr. Grasso, your bill?
Pretty much said everything I had to say last time. It appears the administration's happy and it stands on its own merit, Chairman.
Fair enough. Thank you. Mr. Marzick, any final comments?
No, County Executive supports this bill as amended.
Thank you. This time we'll open the public hearing on 6115. Is there anyone wishing to speak on 6115? Seeing no movement in the audience, the public hearing on 6115 is now closed. Madam Secretary, please read the title of 6115.
An ordinance concerning construction and property maintenance
You're
codes.
done. Thank you. Any final discussion? Seeing none, Madam Secretary, please call the roll on 6115 as amended.
Mr. Grasso?
Aye.
Mr. Fink?
Aye.
Mr. Pruski?
Aye.
Mr. Perutka?
Aye.
Mr. Trumbauer?
Aye.
Mr. Smith?
Aye.
Mr. Walker?
Aye.
7 in the affirmative, none in the negative. Bill 6115 as amended is passed.
Thank you. Madam Secretary, please read the title of Bill 6315.
An ordinance concerning zoning self-service storage facilities.
Thank you. This is my bill. Ask that we hold it over. We had the public hearing at the last meeting. And I don't have any, we don't have a hearing, but we do have an amendment that I would like to propose. Madam Secretary, please read the title of Amendment Number 1.
This amendment removes self-service storage facilities as a special exception use in C2 zoning districts and removes special exception provisions specifically related to self-service storage facilities in a C2 zoning district.
Move to adopt, Mr. Chair.
Thank you. Second, thank you. This basically does exactly what the Secretary just read, removes self-storage facilities from C2, from the C2 zoning district. Any comments from the administration?
Yes, Mr. Chairman, members of the council, Bernie Marzik from the County Executive's Office. We oppose this amendment. This amendment makes a bad bill even worse for several reasons. First, we believe this amendment violates the single subject rule by adding a completely different section of the code into the bill. In addition, there's been no public notice on this, which really changes the purpose of this bill. So we would ask for your opposition to the amendment for that reason.
No public notice, I'm sorry, on what?
In addition...
Public notice on what, Mr. Marzik?
On this amendment, other than...
We don't typically have public notice on amendments.
Correct.
Vote on them and then the bill is...
Correct, but there's no
reheard as
public
amended.
notice on a bill which just completely changes the purposes of this bill.
Mr.
I disagree with that, actually.
Mr. Chair.
Mr.
If
Stroback.
it makes Mr. Marzik feel any better, I had this exact amendment on a bill a month or so ago. So when we were talking, I'm sorry?
Address the single subject rule.
This is Bill 2115, which is actually being amended, but is included as amended here in this. Purpose of the bill being amending the special exception requirements for self-service storage facilities, which we are still doing.
Right. I mean, my point is, if there's a concern that this is coming out of the blue, we already debated it when we did that bill. It said Trumbauer instead of Walker and Grasso. Right?
Correct. It's
Correct.
a different bill.
And your amendment was actually defeated after some persuasion of some kind, if I remember correctly. But
this one has a couple different names on it, so maybe it'll pass.
No, we oppose that amendment, and again, this is on the specific issue of, we believe this, and Greg Swain from the Office of Law can expand on that, but a couple other concerns about this is that based on what we've been able to pull up for the acreage in the county, this bill would even further restrict competition in the county among folks who are coming in to create self-storage facilities in the county. And so we would, again, ask you to oppose for that reason as well. But the troubling part for me is this amendment also eliminates the area of C2, which was added into the code by 2115. And the people who opposed 6315 said the troubling part with opposed 2115, so the troubling part is that it now opened up C2, which would then make it unfair for the people who bought property in C4. This now eliminates C2 under this amendment, which would then make it unfair for the people who are currently buying C2. So it essentially does the same thing that those who spoke out against C2 were put into place, including the chair of, or the head of the self-storage facilities who spoke at the last hearing regarding C2.
Mr. Marzik, you mentioned the number of acres and the number of parcels.
Right.
Before the first bill, the 2115 was passed, do you know how many parcels and acres were included, or available, I guess, for self-storage units?
I do.
Okay, can you share those with us?
64 parcels.
So there were 64 parcels, and how many acres?
808.
And after the bill passed, how many parcels were there?
194 and 2,300 acres for
So we went from 800
areas that
acres-
were under special exception, not only
We went
as
from
conditional.
800 acres to 2,300 acres?
Correct.
And by removing C2, how many acres does that take the 2,300 down to?
I'd have to do some calculations, but looks like it's 100,
Roughly about 2,000?
no, looks like it's about 102 acres, or 106 acres being removed.
So we're down to about 2,000 acres still available? And we
No.
had 800 3 months ago.
Looks like it's at 22 or 2,100 acres, looks like.
But if we remove C2, that drops it to actually like 2,074 by my calculation. So we're going from, what my point is that we were at 800 prior to the bill the county executive introduced. And even removing C2 from the zoning code still leaves us 2,000 acres. So we went from 800 to 2, and we went to 2,300, and now this just drops it to 2,000, so almost, I don't know what that is, but that's 2.5 times at least, by my math, the number of acres, and probably, I would guess, at least double the number of parcels, if I had to guess, that are still available, higher than there was previously, just a couple months ago. Is that accurate?
You said a lot of numbers there, so I'm not sure which.
Well, I have the chart from planning and zoning, so
Right.
it was actually a chart that I requested. But anyway, that's my point, so I don't know if there's any other discussion or questions. I don't see any. All right. Madam Secretary, please call the roll on amendment number 1.
Mr. Grasso?
Aye.
Mr. Fink?
Nay.
Mr. Pruski?
Aye.
Mr. Peroutka?
Aye.
Mr. Trumbauer?
Aye.
Mr. Smith?
Aye.
Mr. Walker?
Aye.
6 in the affirmative, 1 in the negative. Amendment number 1 is passed.
Thank you. Bill number 6115 as amended will be heard, 6315 as amended, thank you. I forgot to write the vote down on the other one. Will be heard at the next council meeting, which is September the 8th. Madam Secretary, please read the title of Bill 6515.
An ordinance concerning personnel exempt service deputy central services officer.
Thank you. Mr. Marzick, when you're ready.
Mr. Chairman, members of the council, Bill 6515 creates an exempt position in Deputy Central Services at an E5 grade level. This position had been discussed as part of the budget for Central Services in fiscal year 16, and funding has been included in the budget for half of the fiscal year. Deputy Central Services Officer is being requested by the Central Services Officer to streamline some of the division's operations, implement some of the cost-saving programs, and improve customer service, as well as support ongoing operations and work on special projects. Doug Jones from the Office of Central Services is here to answer any questions the council may have.
Thank you. Any questions from the council? Seeing none, thank you all very much. This time, the public hearing on Bill 6515 is now open. Is there anyone wishing to speak on 6515? Seeing no movement in the audience, the public hearing on 6515 is now closed. Madam Secretary, please read the title of Bill 6515.
An ordinance concerning personnel exempt service deputy central services officer.
Thank you. We have one amendment. Please read the title of amendment number 1.
This amendment corrects the number and classification of positions approved for the Office of Central Services in the annual budget and appropriation ordinance.
Thank you. Do I have a motion to adopt?
So move.
Second. Thank you. Mr. Marzick, your amendment?
Sure. This is one of 3 amendments we're offering tonight with the various personnel bills after working with the auditor to clarify that the positions will be, correcting the number of the classified positions that have been approved in the ABAO.
Thank you. Any questions from the council? Seeing none, Madam Secretary, please call the roll on amendment number 1.
Mr. Grasso?
Aye.
Mr. Fink?
Aye.
Mr. Pruski?
Aye.
Mr. Peroutka? Mr. Trumbauer?
Aye.
Mr. Smith?
Aye.
Mr. Walker?
Aye.
7 in the affirmative, none in the negative. Amendment number 1 is passed.
Thank you. Bill 6515 is amended, will be heard on September 8th. Madam Secretary, please read the title of Bill 6615.
An ordinance concerning personnel classified service exempt service emergency management director.
Thank you. Mr. Marzick, when you're ready.
Mr. Chairman, members of the council, Bernie Marzick from the County Executive's Office, Bill 6615 moves a Director of Emergency Management from the classified system into an exempt position at an E6 level to elevate this position into the cabinet level because of the importance of this position. This director deals with weather emergencies, but also broader responsibilities of coordinating all county emergency situations through including terrorism, cybersecurity, disaster recovery, and weather emergencies in the county. I've also provided, and I apologize for the lateness, we just got the letter late tonight, a handout from the State MEMO Director offering his support for the idea of having the head of emergency management report directly to the Chief Executive of the county.
Thank you. Any questions from the council? Seeing none. Thank you all very much.
Mr. Chairman?
Mr. Grasso.
Maybe I might have missed this somewhere else. Why do we call it exempt service? What exactly is that?
It's at will and they're appointed.
Is that what it is? So in other words, it goes along with, I guess, the county executive who goes in office. It's an appointed position is what it is. You're taking it out of a merit position?
That's correct.
Okay, that's why we're calling it. Okay. just
Serve
making
at
sure.
will, yep.
Thank you much.
Thank you. At this time, we'll open up the public hearing on Bill 6615. Is there anyone wishing to speak on this bill? Seeing no movement in the audience, the public hearing on 6615 is now closed. Madam Secretary, please read the title of Bill 6615.
An ordinance concerning personnel classified service, exempt service, emergency management director.
Thank you. We have one amendment. Amendment number 1. Please read the title.
This amendment corrects the number and classification of positions approved for the fire department in the annual budget and appropriation ordinance.
Thank you. Do you have a motion to adopt?
So move.
Or second? Thank you. Mr. Marzick, your amendment?
Mr. Chairman, members of the council, this is the second amendment I mentioned regarding corrections made at the auditor's request for adjusting the number of classified positions in the fire department.
Thank you. Any questions from the council? Seeing none, Madam Secretary, please call the roll on amendment number 1.
Mr. Grasso?
Aye.
Mr. Fink? Mr. Pruski?
Aye.
Mr. Perutka? Mr. Trumbauer?
Aye.
Mr. Smith?
Aye.
Mr. Walker?
Aye.
6 in the affirmative, 1 abstention. Amendment number 1 is passed.
Thank you. Madam Secretary, please read the title of Bill 6715.
An ordinance concerning personnel exempt service, deputy director, aging and disabilities.
Thank you. Mr. Marzick.
Mr. Chairman, members of the council, Bernie Marzick from the County Executive's Office. This bill creates an exempt position of Deputy Director Aging and Disabilities at an E5 level. This position has been discussed as part of the department's fiscal year 16 budget, and funding has been included for half of the fiscal year. I'd like to have Pam Jordan from the Department of Aging and Disabilities discuss just some of the importance of creating this position.
Thank you. Good evening, Mr. Chairman, Vice Chair, and all the honored members of the council. Just briefly, the Department of Aging and Disabilities is very committed to serving all adults over 55, regardless of their means. And in order to do that, we need to get smarter about the way we do business. The purpose of this position is to be a business development specialist and help us achieve funding that we're not able to capture right now. So I look forward to your favorable consideration of this position. If you have questions, I'm happy to answer that now.
Thank you. You do a fantastic job, Ms. Jordan. Keep up the good work.
Thank you.
Any questions from the council? Seeing none, thank you all very much. At this time, we'll open the public hearing on Bill 6715. Is there anyone wishing to speak on 6715? Seeing no movement in the audience, the public hearing on 6715 is now closed. Madam Secretary, please read the title of Bill 6715.
An ordinance concerning personnel exempt service, deputy director, aging and disabilities.
Thank you. We have one amendment. Please read the title of amendment number 1.
This amendment corrects the number and classification of positions approved for the Department of Aging and Disabilities in the annual budget and appropriation ordinance.
Thank you. Do you have a motion to adopt?
So move.
Thank you. Do you have a second?
Second.
Mr. Marzick, your amendment?
Mr. Chairman, members of the council, Bernie Marzick from the County Executive's Office. Again, this is an amendment to correct the number of classified positions in the Department of Aging and Disabilities, as with the previous 2 bills.
Thank you. Any questions from the council? Seeing none, Madam Secretary, please call the roll on amendment number 1.
Mr. Grasso?
Yay.
Mr. Fink? Mr. Pruski?
Aye.
Mr. Perutka? Mr. Trumbauer?
Aye.
Mr. Smith?
Aye.
Mr. Walker?
Aye.
7 in the affirmative, none in the negative. Amendment number 1 is passed.
Thank you. Bill 6715, as amended, will be heard September the 8th. Madam Secretary, please read the title of Bill 6815.
An ordinance concerning personnel positions in the Classified Service Office of Information Technology.
Thank you. Mr. Marzick?
Mr. Chairman, members of the council, Bill 6815 creates two new classifications in the merit system at NR 23 for the Office of Information Technology. The department is currently utilizing two current vacancies to create these two new positions. Napolitano from the Office of Information Technology is here to discuss the importance of these positions if the council should have any questions.
Thank you. Any questions from the council? Seeing none, thank you all very much. This time we'll open the public hearing on Bill 6815. Is there anyone wishing to speak on this bill? Seeing no movement in the ayes, the public hearing on 6815 is now closed. Madam Secretary, please read the title of Bill 6815.
An ordinance concerning personnel positions in the Classified Service Office of Information Technology.
Thank you. Any final discussion before the vote?
Mr. Chairman.
Mr. Smith?
Just for the record and so everyone's aware, these previous bills were part of a package deal previously that was unsuccessful, so this is just a reiteration of those individual positions. So we have been aware of these for some time now, so just wanted to sort of put that out there. Thank you, Mr. Chairman.
Thank you. Any final discussion? Seeing none, Madam Secretary, please call the roll on Bill 6815.
Mr. Grasso?
Aye.
Mr. Fink? Aye. Mr. Pruski?
Aye.
Mr. Perutka? Mr. Trumbauer?
Aye.
Mr. Smith?
Aye.
Mr. Walker?
Aye.
7 in the affirmative, none in the negative. Bill 6815 is passed.
Thank you. Madam Secretary, please read the title of Bill 6915.
An ordinance concerning recreation and parks, civil offenses.
Thank you. Mr. Marzick, when you're ready.
Mr. Chairman, members of the council, Bernie Marzick from the County Executive's Office. Bill 6915 will give park rangers and park supervisors citation powers, as has been discussed by the rangers for a number of years, to meet the need of growing incidences in the parks. The goal of this legislation is to provide another tool for our park staff to effectively manage their facilities, as there has been an expansion of public access in unstaffed parks and an increase in incidents in current parks. We will also be offering some amendments to change the scope of the citation powers as well. Rick Anthony from Rexham Park is here, as well as Andy Rhodes from Personnel and Kelly Kenny from the Office of Law.
Thank you.
Mr. Chairman?
Mr. Aid? Oh, sorry. Go ahead, Mr. Trump.
If he has
no,
comments.
I'll ask last. Go ahead.
Okay. So I'm wondering how many individuals will have this citation power? Is it only a certain classification of ranger, or, I mean, will all park employees have a citation booklet? Can you help me understand who will have this power?
Yeah, not all park employees. We will focus on the rangers mainly, but also extend this to park superintendents and other staff that have been trained by the Office of Law.
Okay, and so it's not enumerated in the legislation. That's discretion from you, who will be able to do that?
I believe that's correct.
And just so I understand it, I mean, I go to the parks a lot. I interact with the rangers a lot. So, I mean, are they physically going to be carrying around, you know, like a booklet, and they'll write you a citation, or what will happen? Because previously you would have to call a police officer, and now that no longer would be required. So how will the actual citation get delivered to the infractor?
That's correct. Now, they do have warning booklets that they have on their possession, whether they carry them every day or not. So they will have those booklets, those citations there available for them. It's just another tool to help us manage the parks. And if you look at the amendments, we really kind of limited the scope. It's going to be heavily focused on parking enforcement, with also some reference to illegal use of boat ramps and then dogs off leashes.
Right.
So when you really focus on that, they will have at least a tool to be able to manage those infractions.
And then I presume if they encounter a situation that they don't feel equipped to deal with, they will call the police officer.
Exactly right, and that was one of the reasons for the amendments, is to make sure our staff
Yeah,
was
I have to acknowledge I haven't looked through the amendments yet, but I'll look forward to hearing about those. But I'm curious, because a lot of folks that use the parks, I mean, they might be jogging through quiet waters, and they might not have an ID, they're not in their car. If your staff comes up and says, hey, you know, you're breaking the law, you know, what's your name, address, and they say, you know, Groucho Marx or whatever, I mean, is that something that you'll deal with internal policies and figure all of that out?
Yeah, I mean, that's something obviously that they can do now.
Okay.
And if that happens, we simply would have to call the police if it's a major infraction. But again, if you look at the amendments, I think it addresses
Okay.
that pretty adequately.
Okay, thank you. I'll spend a little time looking at the amendments. Thank you, Mr. Chair.
Thank you. Any additional questions from the council?
Yeah, Mr.
Mr.
Chairman.
Grasso, go ahead.
Yeah, I just want to say, Mr. Trumbauer, my personal thing with dealing with the park ranger, I didn't know that they weren't any different than the police, other than being up here on the council and knowing that they didn't carry weapons. I think with them showing up with a uniform, everything else pretty much sets a standards, you know what I mean? So I think it was news to me that they didn't carry guns or weapons, and I'm still surprised why they aren't trained to do that, you know, but here nor there. Thank you, Mr. Chairman.
Mr. Chairman.
Mr. Pruitt?
Mr. Chairman, can you just give just a couple sentences of background on why this is, what's your experience which calls for this?
Well, I think the Rangers have been advocating this for years, but there are a few of the staff that were concerned about the lack of training. Quite frankly, there is a little bit of a philosophical difference. Some of the Rangers would rather be naturalists, and the department in general would like to have more of a friendly, someone that could be just kind of a friendly face, more so than law enforcement type attitude. But we do see, because of the expansion of our facilities, especially the Water Access Initiative, we do see an opportunity to create just a better management tool for our staff.
I appreciate that, and you know what, the way you just described it was what I was hoping you would do, because you know the parks are places that you're going to for a friendly experience, not necessarily to. I haven't cross-referenced the amendments to the bill yet, so I don't know. But one of the things that concerned me was, you know, citations for disobeying or for in other words, if I'm in the park and maybe I do have a disagreement with the ranger or whoever, I don't want to create a lot of little commissars. If you
Well, the amendments, exactly what your concerns are, the amendments address. That's the reason why we feel like we have a better proposal here with the amendments that would kind of safeguard that.
And just to be fair, thank you, I'm happy about that. At the same time, when indeed you do need to bust on somebody, you need to be able to do it. You need to be able to have the tool to do it. So I appreciate that. Thank you.
Any additional questions? Okay, I do have a couple. And maybe these are addressed in the amendment. But we actually had a discussion about citations last term, I believe it was, over at the landfill. And one of the things that came up was the court appearance component of citations. So if we're issuing citations to citizens now, are our employees going to be required to then follow up in court at a court appearance if somebody objects to the citation or appeals it or whatever? Because that was one of the concerns I think we had at Department of Public Works when we were looking at the landfill citations, was now all of a sudden we've got employees that aren't in their role. We already have a limited number in Recs and Parks, we know, in the Parks Department to begin with. So if they're all of a sudden running over to court, 2-3 days a month, it's even more hours they're away from whatever their normal duties are.
Yeah, that's correct. And again, that's one of the reasons we decided to kind of limit the scope of the citations that they would issue.
So it wouldn't be a citation
potential.
that requires a court appearance? Is that what you're telling me?
I think if you can appeal, okay, I'll let the law office answer that question specifically.
That's fine.
Kelly Kenny, Senior Assistant County Attorney. I can probably answer that question for you. It is correct that once a civil citation is issued and served on somebody, that it is processed through the district court. If a person is issued a citation and pays the fine, then there would be no need for the park ranger to appear in court for that violation. But like you said, if a person does contest it, then they're entitled to a trial. And then the park ranger or the person who issued that citation would need to appear at court and be our witness in that case to establish that there was indeed a violation. We have a docket the first Tuesday of every month, so it's once a month up for a code enforcement docket that those people may be pulled away to come to court with us.
So, technically you could have 3, 4, 5, 6 employees down there at court on the second, what did you say, first Tuesday of the month?
First Tuesday of every month.
I can't speculate how many. I do. It is important for the council to understand that we are not making this part of the employee's job description, so they do have the opportunity to make a judgment call to give a warning instead of a citation. So
Well, you bring up job description, which is actually one of the, sort of where I was going next with this, and that is, I mean, I guess when you're talking about citations at the landfill, you never have to worry about a landfill employee, or I shouldn't say never, rarely I think would you have to worry about a landfill employee taking that power and then saying, the next step in the process for me is to be police or deputized. I mean, what's to keep, now we've got the park ranger, and that title just in and of itself sort of is indicative of law enforcement, right? So now we're giving them a little more power in their job. And then what's to say, and these are employees that are in a union, correct? And the park rangers are in a union, correct? And so what's to say that the next step isn't that they say, well, we have citation authority, now we want to bargain or negotiate for, because we want to expand that, we want to have police powers, we want to carry firearms. Mr. Grasso said that he doesn't understand why they don't carry firearms. So they probably feel the same way, and if they get the ability to do a citation, and then we get a half a dozen situations where, citizens get into a physical altercation with a police officer and they don't, or a park ranger, and they don't have a firearm, I mean, it seems like a slippery slope, I guess, is my concern. Like, we're going from, it's not an issue at the landfill, they're never going to slide into a police role, but in this case, it seems like that would be a natural sort of...
Yeah, and we actually addressed it. I'll let Ms. Rhodes comment that we talked to the union about that, but I think she has some comments.
Mr. Chairman, for the records, Andy Rhodes, Personnel Officer. Mr. Anthony and I sat down with the union chief steward and Dan Taylor, who represents Teamsters 355, which is the representative for the park rangers, and explained to them, as Mr. Anthony said, this is a tool that they'll be able to use. It's not going to be required. Every park ranger, if they're not comfortable with writing a citation and don't want to be confrontational with someone in the park that they seem to be having a problem with, they can certainly call the police. But we made it very clear to them that this was not the beginning of the park rangers becoming a public safety unit, and that this was not something that we were willing to do, and if that is what they thought this was going to be the beginning of, that we would completely look at addressing this issue maybe in another way. So,
But that's like this administration. I mean, this administration moves on, next one comes in, and they could very well go to that one and say, hey, we've been doing all this citation work, we've been showing up to court, we've had all these incidents where we've had run-ins with the public, we feel like we need to be law enforcement officers now. I mean, they could make that argument at some point.
they could, but again,
And then we have
as-
bulletproof vests, and then police cars, and all kinds of
And that's
extra-
exactly why we brought them in to talk to them about it, because the next step was not going to be, bulletproof vests. We did tell them it's not going to be part of their job description, so it's not going to be something that their performance is going to be rated on. That this, again, was a tool that we are giving them, and that, we were going to monitor how well it was working.
And how many park rangers do we have that could potentially be able to give citations?
There are 14 park rangers.
14. And then it's your intention to authorize approximately how many more people to issue them?
I would say that we have park
Just roughly.
superintendents, including the trails, maybe 5, 6, maybe even 9 total.
All right, so 9 more.
And all of those employees will be called in, and the law office will give them the training in writing the citations.
And is there, you mentioned 2 situations or scenarios where they'd be able to issue citation. One you said dog off a leash, and the other one you said parking enforcement. Is there a defined list of in the amendment or something where it says exactly what? Yes. Okay. All right, fair enough. I don't have any other questions.
Mr.
Anyone else? Mr. Fink.
Thank you. What other county employees, other than police officers, have the authority to write civil citations?
Their zoning inspectors have a right to, building code enforcement employees have the right to write citations.
Grading code inspectors as well, and a couple employees of the Department of Public Works for weeded lots and things like that also have the authority to do so.
Weeded lot? Oh, like
Weedy lots, like overgrown grass,
okay.
right.
All right. Okay, got it. Sorry.
Thank you.
I got one of those places in my neighborhood.
Yes, Ms. Sutherland.
Thank you. Ms. Rhodes, are you aware of any other duties that are given to employees in the code like this, that they're not part of their job duties? Or even ones that aren't in the code, but where people have duties that aren't part of, I mean, their grades, their compensation, everything is determined based on what your duties are and relative to others, et cetera, and here we're going to give them duties but not make it part of their job description.
Well, in discussing that with Mr. Anthony, he decided that in his best, he thought it was in everyone's best interest not to make this a requirement because all of the park rangers may not feel comfortable writing citations.
Are you aware of any other positions like that?
I would count 7 right in front of us, I think.
What?
We can issue citations?
What?
No, not related to citations, but related to job descriptions. where-
couple ready to go.
I believe the charter lays out the county council's job description.
That's a good point that you said that. Maybe the council should have that.
But they're not.
The charter
What are you talking about?
Mr. Grasso, the charter lays out your job duties.
So maybe we should put that as a charter. Because I tell you, I could write them left and right myself, boy. And you know I take them on.
Mr. Chairman. Mr. Fink, the citations that we're talking about, the law-breaking offenses, are they laws or rules? Is it a law to have your dog on a leash? Is it a law to pick up your dogs?
It will be if you pass this bill. Those are all new offenses that are set forth in this bill.
Okay, so it creates laws and then gives the rangers the ability to enforce them.
Correct.
By civil citation. All right, thank you.
So we can't stop someone from picking up after a dog, right, I mean, and do anything about it? I mean, are people allowed to let their dog?
I think they've always been given a warning by the Parks and Rec staff. It was never a specific violation in a park in the code.
But it's interesting. Are there other counties that have park rangers that have these duties?
Yeah, I can't speak specifically to counties, but I know that the state, obviously, and then national parks, it just depends on different jurisdictions, but there are a few counties that have a little more enforcement powers than we do.
Mr. Chair.
Mr. Trumba.
In as much as we look like we might amend this, it would be interesting to me if Mr. Anthony or someone could look into the counties, because I suspect that there are some counties that may have this authority. But, I mean, to me, it seems like, you know, we're just giving our park rangers the same authority as our weedy lot inspectors have, so that's the least we can do.
Okay. Any questions? No more questions. All right. This time we'll open the public hearing on Bill 6915. Is there anyone wishing to speak on 6915?
Just had Julie Johnson, P.O. Box 6634, Annapolis, Maryland. In the Maryland Transportation article, Maryland Code Transportation article, I think it's 26102 or 201 or something in that neck of the woods. There is an authority where the counties can designate not only the police departments, but there are other personnel who can be authorized specifically to do traffic. For instance, you know that in the city of Annapolis, there are the parking enforcement people. They're not police officers. They're not law enforcement officers. They issue parking tickets. And I'm wondering how this bill links up to that statute in terms of, the authority. And I think you asked what statutes give you the authority to issue citations, and I'm pretty sure it's Transportation 26102 or 201, something. It does say in that part of the statute. Thank you.
Thank you. Seeing anyone else wishing to speak on this? Seeing no movement in the audience, the public hearing on 6915 is now closed. Madam Secretary, please read the title of Bill 6915.
An ordinance concerning recreation and parks civil offenses.
Thank you. We have one amendment. Please read the title of amendment number 1.
This amendment eliminates certain civil offenses from the authority of Department of Recreation and Parks for enforcement purposes.
Thank you. Do I have a motion to adopt?
Motion to adopt.
Do I have a second?
Second.
Thank you. Mr. Marzick, your amendment?
Sure. Mr. Chair, members of the council, Bernie Marzick from the County Executive's Office. For the sake of ease, I think explaining this, it might be best to work off page 4 of the auditor's Blue Note. Under all the bullets that are listed in the current bill, and we can go through what our amendment will include. And if you move about 3/4 of the way down, there's a bullet that begins obstructing a park entrance with a motor vehicle. So every bullet above of that is being deleted by this amendment. So the amendment will have the obstructing a park entrance with a motor vehicle.
I'm sorry, I just got to that page. Can you, can you repeat?
Page 4.
Page 4.
It's about 3/4 of the way down, the bullets obstructing a park entrance with a motor vehicle.
Obstructing a park entrance.
It's from the bottom.
Thank you. Got it, okay.
So if every bullet above that is deleted by the amendment. What is included in the amendment is obstructing a park entrance with a motor vehicle all the way through. Next bullet, parking a motor vehicle in a park overnight. Next bullet, parking a motor vehicle anywhere but in a designated parking area. The next 2 bullets are deleted, and the last 2 bullets are included, related to animal care.
So lubricating, repairing, or performing and capturing,
Correct.
refining, those are deleted?
Yes. So there are 5 bullets. The bottom 2, and then 2 are deleted, and then the next 3.
Mr. Chair.
Mr. Trumbauer.
Thank you, Mr. Chair. Mr. Marzek, how did the administration come to the conclusion to parse them out that way? That you would retain these 5 but delete everything else?
I think that this is kind of the overall philosophy on this, is that park rangers have existing authority for warnings, and the next step is to have the police come in. And the idea was to try to identify areas that, through Mr. Anthony and Ms. Rhodes, and their expertise and their discussions, we're able to identify as the areas that needed the enforcement, as well as areas that, in our parks, in these 5 bullets, as well as other areas that, they felt comfortable putting the rangers in these situations to enforce these violations.
Well, so I appreciate that, and I see that, we're retaining the ability in the proposed legislation to deal with the, animal excretia, we're calling it, and some other things, but yet we're taking out their ability to cite someone for littering in the park. I mean, if we feel comfortable giving a ticket for dog poop, why not give a ticket for littering? I mean, those seem relatively on par in terms of an offense to me.
Yeah, well, and this was probably more generated from our department after discussion with staff. It's really not a significant issue when it comes to littering as it is the continuing repetitiveness of people keeping their dogs off the leash or not cleaning up. Obviously, we have a park maintenance staff that does an adequate job of cleaning up, and for the most part, we've had a tremendous amount of compliance just with the ranger asking someone to please pick those items up. So mainly for our overzealous rangers, we were trying to remove as many of the infractions as we could and really focus on the issues that we were currently facing in the parks.
Okay.
Mr. Chairman.
Ms. Smith.
And I probably would say this, probably easier to get someone to pick up a piece of paper than to pick up poop for the record.
Right.
Mr. Chairman.
So as I'm reading the blue letter here, it just says $50 for the first violation, $100 for the second violation, and $500 for each subsequent violation. Is that over a specific period of time? So in other words, if I went this year, did something, got a citation, then went next year, and then 5 years from now got another one, then I'd be paying $500 on the third? Is there any sort of time limit on when the clock starts ticking again, or is it just in perpetuity?
Kelly Kenny again for the record. There's no time limit written in the code. It's usually within a couple years that they'll cite somebody for a subsequent violation, and it has to be either a fine that's been paid or has gone to court and they've been found guilty or been placed on probation before judgment before you can move on to that second highest fine for that person.
So if they pay the fine, they'd still be liable for the
Then the next time it would be the
offense.
second violation, the $100.
But you said a couple years, but that sounds kind of vague. I mean, it
Right,
leaves
that
it
would
up
be
to the Office of
something-
Law to enforce?
Right, and that's usually something that can be dealt with in a policies and procedures document, and they can determine how many years they want to keep records on these people. I'm not sure what their records retention policy is, but it will depend on how many years they have records going back to determine whether that person was ever cited before.
Do you have any indication, Mr. Anthony, as to what your policy is going to be on that?
No, we haven't had that discussion in depth at this point for that.
Mr. Trumbauer?
So one last clarification. I mean, I keep looking at this list of things. Like, I don't want people to do any of this stuff in our parks. So
They're still against the rules.
Well, yeah, so what you're saying is, if your staff observes those 5 highlighted bullets, you can ticket them. If they see something else going on, they either do one of 2 things. They warn them and say, hey, don't do that, or they're going to pick up the phone and call the police.
And if they are able to obtain personal information and this person has continued to disobey the law, then I can also issue a banning letter. So I still have tools to enforce.
Okay. I just don't, if we vote on this amendment and we strike all this other stuff, I just want to be clear that I still think you need to deal with this.
Oh, yeah,
if you feel that you'd rather continue law enforcement officers having to deal with that instead of your staff, then I'll defer to your expertise. Thank you, Mr. Chairman.
Thank you, Mr. Trumbauer. Any final discussion? Seeing none, Madam Secretary, please call the roll on amendment number 1.
Mr. Grasso?
Aye.
Mr. Fink?
Aye.
Mr. Pruski?
Aye.
Mr. Perutka?
Aye.
Mr. Trumbauer?
Aye.
Mr. Smith?
Aye.
Mr. Walker?
Aye.
7 in the affirmative, none in the negative. Amendment number 1 is passed.
Thank you. Bill 6915, as amended, will be heard on September 8th. Madam Secretary, please read the title of Bill 7015.
An ordinance concerning finance, taxation, and budget revenue reserve fund.
Mr. Grasso, your bill.
Well, we're just...
Actually, it was my bill previously.
This looks like a great
familiar.
bill, Mr. Grasso.
Does it really? Well, I think the council pretty much knows the game that we got here. Mr. Trumbauer put the same bill in, but he just wanted to have a limit of, I think it was $100 million. And he said, we never said we're going to put $100 million in. We're just going to have the ability to put $100 million in. And I think some people got a little worried about that issue, so it seemed to be a little bit more of a better situation to meet halfway. We were riding at around $50 million, wanted to go $100 million, so we came at $70 million, and that's where it is today.
Mr. Chair.
Mr. Trumbauer.
This is a great bill. It looks exactly like the bill that I had, except instead of Trumbauer, it says Grasso. And this bill, if I recall correctly, was defeated by a close vote based on the administration's opposition of the emergency status. So my last legislation actually had the same percentage and the same numbers, unless I'm mistaken, Madam Auditor. Okay, so...
You want co-sponsor?
You know what? You get the glory, baby.
I co-sponsor. You know we tag team all the time, buddy.
I couldn't close the deal. It's up to you guys. Go for it.
Close the deal. I knew it was going to be a good one tonight. I knew it. That's it. That's all I had to say.
Thank you, Mr. Grasso. Any comments from the administration?
Mr. Chairman, members of the council, Bernie Marzi from the County Executive's Office. Just to clarify, Mr. Trumbauer, it was actually the County Executive's amendment to your bill, which was identical to this bill, which is before us today. So the County Executive will gladly support Bill 7015 to change the formula for the Revenue Reserve Fund.
No, it's not emergency. That wasn't political either. Seeing no further discussion, we'll open the public hearing on Bill 7015. Is there anyone in the audience wishing to speak on 7015? Seeing no movements in the audience, the public hearing on 7015 is now closed. Madam Secretary, please read the title of Bill 7015.
An ordinance concerning finance, taxation, and budget revenue reserve fund.
Thank you. Any final discussion?
Mr. Chairman,
Mr. Fink.
I was going to say it's a great bill. We should have voted on it a couple months ago.
It was actually in front of us a couple months ago. Less than a couple months ago. A month ago. Glad you think it's a good bill now. That's awesome. Madam Secretary, please call the roll on Bill 7015.
Mr. Grasso?
Aye.
Mr. Fink?
Aye.
Mr. Pruski?
Aye.
Mr. Perutka? Aye. Mr. Trumbauer?
Aye.
Mr. Smith?
Aye.
Mr. Walker?
Aye.
7 in the affirmative, none in the negative. Bill 7015 is passed.
Thank you. Madam Secretary, please read the title of Bill 7115.
An ordinance concerning pensions, interplan transfers, Chief of Police.
Mr. Marzick, your bill?
Mr. Chairman, members of the council, Bernie Marzick from the County Executive's Office. Bill 7115 allows for the police chief who is currently in the police service plan to move into the employee service plan, but return to the police plan after he or she reaches 20 years of service. We introduced this bill based on suggestions from the auditor and the council chairman as we were having discussions on the previous bill that the council considered. Currently, the police chief may enroll in the employee's plan within 1 year of appointment. However, he may not bounce back to the police service plan. We will also be offering amendments related to the fire chief and the superintendent of detention facilities who are in a similar position with this. John Peterson and Kelly Lovett. John Peterson from the Office of Personnel and Kelly Lovett from the Law Office are here to answer any questions the council may have.
Mr. Trumbauer.
Thank you, Mr. Chair. Does this bill, I remember this was introduced while we were deliberating on the other police chief pension bill.
Correct.
So does our passage of that have any impact on this, or are they completely standalone?
Completely standalone.
Okay.
I think the idea, this is part of the discussion that some people suggested we shouldn't have introduced this bill. But I think the idea was this was a policy moving forward so that you don't end up dealing with some of the similar situations that have been dealt with in the past. And kind of more of an overarching policy from the council as far as people who are in these pension plans that have different benefits versus the regular employees' pension plan.
Yeah. Well,
Mr. Chairman.
Hold on.
I'm good.
Okay.
I'm
Mr. Fink.
Apologize, Mr. Trumbauer. Is this bill still necessary after the last bill that passed? I mean, why would any future chief come down to a lesser plan when they don't have to? I mean, they're protected from what this bill was originally designed to do.
John Peters, I'm sorry.
I mean, it doesn't hurt, I guess, but it's...
Well, if you add, now they're going to add in other people in this next amendment, so that's why they're
Well,
expanding.
yeah,
the
well,
scope
the
of it.
amendment's not in yet. Just on this bill, it just doesn't seem like a police chief would
You're
take
right.
a lesser of a plan if he's already protected by the other bill that passed.
If he has 10 or 12 years of service, he could enter into the employee plan and then bounce back if he got to 20 years.
If he has 10 or 12 years of, his pension will be close to nothing in the regular employee plan. Right, I mean, 10 years, it takes 10 years to become vested now?
8, I think.
It takes 8 for, again, John Peterson, Office of Personnel.
Is it 8? I thought it was 10.
It's 10 for regular
appointed.
employees, it's 8 for appointed exempt positions. So anyone hired, any exempt employee hired after December 1, 2014, it's 8 years.
If
Regular
he's-
employees, classified employees, it's 10 years.
If he's a police officer, 11 years in, takes that jump to chief of police, switches over this, then he falls under the 8-year pension? 8-year vested?
Correct.
It just doesn't seem like any of these guys or ladies will end up taking this. But
The difference with this bill is that the other bill laid out specific parameters for which you could qualify. This would be more open to anybody who came in day one. The other
Expanded.
bill was a little more tailored.
It does, but, I mean, who, I guess there's no harm to this bill, but who would take a less of a plan, lose their spouse benefit, go to 2 years instead of 2.5%?
Well, the chance that you might
I
not
don't
be.
see the need for it.
The chance that you might not be vested, you may not survive that period of time. So if you were to transfer to the employee's plan, which has a lesser vesting period, 8 or 10 years versus 20, and then once you reach that 20, you can go back to the other plan. So unless you met the parameters of the prior bill, if you were appointed the police chief, say you only have 10 years.
Yeah, but the likelihood of, say this employee's got 11 years and 12 years, and likelihood of him staying the police chief for 8 years is slim to none. So why would he jump back to this? I don't know. I just don't see anything. There you go.
The idea would be that they may have some existing service already. So say they had 8 years, they would be vested on day one if they took the employee's plan. And then once they made it to 20, they could revert back to the employee.
But they probably wouldn't make it to 20 if they only had 8 when they became police chief. I mean, I think that somebody's going to be in that job for 12 years. I guess it could happen, but likelihood's low. Thank you.
Any additional questions? Seeing none, thank you all very much. This time we'll open the public hearing on Bill 7115. Is there anyone wishing to speak on this bill? Seeing no movement in the audience, the public hearing on 7115 is now closed. Madam Secretary, please read the title of Bill 7115.
An ordinance concerning pensions, interplane transfers, Chief of Police.
Thank you. We have amendment number 1. Please read the title.
This amendment permits a fire chief and a superintendent of detention facilities to also transfer from the employee's retirement plan back to another retirement plan for which they are eligible after completing a specific number of years of actual plan service, and corrects a technical error to properly identify the full title of the employee's retirement plan.
Do you have a motion to adopt?
Motion.
Second.
Thank you. Mr. Marsnick, your amendment?
Sure. As I mentioned, this amendment is to include the fire chief and superintendent of detention facilities, to give them the ability to have the same benefit that the police chief would have, to enroll in the employee's plan and then move back into their individual pension plans once they reach the full 20 years.
Mr. Chairman.
Mr. Fink?
The fire chief, the firefighters are 20 years for a pension. Superintendent, or the detention facility guys are saying they got to be in there for 20 years, all or nothing.
They have a 20 and out in the detention.
Do they got to get 20 years or they get nothing? If they work for 12 years and leave, do they get somewhat of a pension?
Depending on when they were hired, they can vest at 8 or 10 years.
So if that's the case, why do they need to be included in this?
Because again, they could vest in the employee's plan.
But if they can invest in their current plan, which
At
I'm
20
sure is
years.
better. But I thought you just said 8 years.
No, I'm sorry. Maybe I misunderstood your question. Again, as an employee, exempt employee, they could vest with 8 years. In the detention and deputy sheriff's plan, it'd be 20 years.
So detention facility workers have to get 20 years or they get nothing.
There's different categories. If you bear with me, I can grab.
This is Kelly Levitt, Senior Assistant County Attorney. Just to add to what Mr. Peterson is saying, is a Category 2 participant in the detention officers and deputy sheriff's plan. That would be vesting as someone who's hired after July 1, 2015, would be vesting after 10 years.
10 years.
And before that?
And before that, it would be vesting after 5 years.
So then
Category
this
2
really doesn't apply to them.
It doesn't apply to the existing superintendent.
Or even somebody that's hired after July 1st. They're going to vest at the same point.
Now, if they're an exempt employee, and if they, as an exempt employee, they could, in the employee's plan, they could vest with 8 years.
But under their current plan, they vest in 10.
10.
And they get 2.5% per year, or is it 2%?
2.5.
Thank you.
Mr. Chairman, real
Mr.
quick.
Smith?
Part of the logic with the police chief's bill previously was that that position and the county attorney, if they're part of a process where if someone did something wrong, they would be responsible for investigating the suspected criminal action. How does the detention center or the fire chief fit into that process where they would not, or would they, investigate some sort of criminal action where they couldn't come forward? I mean, that was part of the sort of appeal with the police chief and potentially the county attorney, because they were the ones who were ultimately going to be responsible for doing the investigation and recommending criminal charges if necessary, whereas that authority does not lie with the fire or detention center.
That's correct. We didn't assert that for this bill. I think it's a different situation. I think with this was the overarching policy that was brought up at either during the budget hearings or during one of the work sessions about the ability for, or I guess the idea of having them be able to bounce back. And that's why the bill was put in for the police chief, based on some of the concerns that were raised, by the council, to give them the option to bounce back from the employee plan back to the police plan. And in this situation, the amendment is being offered to essentially make that benefit for the fire and the superintendent, fire chief and superintendent, who are also in unique situations as well with their pension plans.
Thank you, Mr. Chairman.
Any additional questions? Seeing none, Madam Secretary, please call the roll on amendment number 1.
Mr. Grasso?
Aye.
Mr. Fink?
Aye.
Mr. Pruski?
No.
Mr. Perutka? Mr. Trumbauer?
Aye.
Mr. Smith?
Aye.
Mr. Walker?
No.
5 in the affirmative, 2 in the negative. Amendment number 1 is passed.
Bill 7115, as amended, will be heard on September the 8th. Is there any other business to be brought before the county council?
Motion to adjourn, Mr. Chairman.
Do I have a second? Thank you. All in favor?
Aye.
Opposed? The motion carries. County council is adjourned until September 8th, 2015.
What's up, Bernie?